I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the Supplementary Budget Estimates 2025-26. I'd like to begin by acknowledging the traditional custodians on the lands of which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. The Senate has referred to the committee the particulars of proposed expenditure for 2025-26 for the portfolio of Home Affairs and Attorney General and other related documents. These are supplementary budget estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney General's portfolio. The committee has set Thursday the 11th of December 2025 as the date by which written questions on notice should be provided to the Secretariat. The committee has also decided that answers to questions on notice should be returned to the Secretariat by 5 p.m. on Thursday the 29th of January 2026. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with expenditure of public funds where any person has the discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of information or the document. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I will be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Officers called upon for the first time to answer a question should state their full name and their position for Hansard record, and witnesses should speak clearly into the microphone. The committee's proceedings today will begin with the Attorney General's Department in the cross-portfolio, corporate and general matters, and I welcome the Honourable Don Farrell, and I call officers. I think we're going to start with you, Secretary, from the Attorney General's Department. Minister, would you like to make an opening statement?
Chair, thank you for the opportunity to do that, but in the interest of time and to give the other senators a maximum opportunity to ask questions, I won't make a statement on this occasion.
Thank you, Minister. Ms Jones, would you like to make an opening statement?
Thanks, Chair. Good morning. No opening statement.
Thank you very much. We'll proceed to questions, and I believe we're starting with Senator Ruston.
There's just seeking some advice from you, Ms Jones, in relation to Australian court decisions on workplace allegations made against Minister Reynolds. And I'll quote the words of Justice Lee, without reasonable foundation in verifiable fact, and Justice Toddle, objectively false and misleading and dishonest. I'm just interested, does the Attorney-General's Department accept the findings of these two courts?
Thanks, Senator. Senator, those matters relate to the area of the department, the integrity and security area, that's not scheduled to be appearing until later today. So I think we would need to defer until that part of the agenda.
Thank you.
So you're not going to put on the record your opinion as the highest officer in the Attorney-General's Department in terms of whether you accept the findings of these courts?
I think two things. We would not normally offer an opinion as officials, but secondly, that matter is squarely within the Integrity and Security Group, which is scheduled to appear later today.
Minister, did you want to... do you accept the findings? Does your government accept the findings of these two superior courts?
Look, the decisions are the decisions. I don't know, it's up to the government or myself to accept or reject these court decisions. We have a legal system in this country that allows people to, file cases. We have a system that allows independent judges to make these decisions. And
Sorry, can I? We're just having an issue with people on this side being able to hear. So if you could just speak, either have the microphones turned up, or if we can have speak a bit closer to the microphone.
is that any better?
Yeah, and on our side too. I think the question was very quiet.
You said a very chilled tone, Chair, to start.
That's how we want the day to go, Senator Shoebridge.
It's been a long year. Look, we have a very good legal system in this country. People are entitled to file applications if they think they've, in that case, been defamed. Look, I don't think it's up to the government or myself, for instance, to have a running commentary on these matters, and the decisions stand. And people can make judgments about them, I guess, but I just don't think it's up to the government to be having a running commentary on the court cases in this country.
Thank you, Minister.
And I personally haven't, in all my time in politics, made comments on court proceedings. I just don't think it's a particularly helpful thing for politicians to do.
I'm not talking about proceedings, I'm talking about findings of judgments that have been brought down, but I'm happy, on the advice of Ms Jones, to come back at 1:45. In terms of the costs that are paid to people who represent the Crown, is this an appropriate time to ask about those?
That's in the same area. So the process for sorry, actually, I should clarify. Would you mind just repeating that question so I do direct you to the right part of the department?
Okay. I'm just interested who would be the right people to ask in relation to a briefing of counsel in relation to matters that, whilst you may not be the principal, but I'm assuming the Attorney-General Department is the one that provides the necessary advice.
If there's a request, for example, in relation to paying a rate higher than the normal approved rate, it does come to the department to provide advice to the Attorney-General. That's the Office of Legal Services Coordination, which again is in the Integrity and Security Group and will be on at that same time.
Okay. All right. Well, I might leave my questions until then. Thanks, Chair.
Thank you, Senator Ruston. Senator O'Neill.
Thank you very much, and good morning. I understand that on the 14th of November at the Standing Council of Attorneys General, the Commonwealth Attorney General and all state and territory Attorneys General committed to a WWCC reform agreement, including timeframes to reform working with children checks to keep young people safe. This is such an important matter to so many Australians who've been chilled by revelations in the course of the year. clearly the government's moved quite quickly to address this issue. Can you please outline for the public so they understand what the agreement set out and why these particular reforms are necessary?
Thank you, Senator. The broad responsibility for the work around working with Children's Check is in the next group, which is the Justice and Communities group, although SCAG proceedings are managed across the department in a cross-portfolio way. So I'll just check with the Chair. I think that there is a basis for answering those questions now because it relates to SCAG in particular, which is cross-portfolio.
Absolutely, and it's across the nation. I'm sure there's interest.
I'll ask the relevant officers to come to the table.
Thank you very much, Ms Jones.
Thank you.
So for the officers who've just come to the table, my critical questions were, can you please outline what the agreement set out and why these reforms are necessary?
Certainly. Tamsin Harvey, Deputy Secretary, Justice and Communities Group. Senator, the Working with Children Check schedule of work that was agreed by Standing Council of Attorneys General on the 14th of November sets out effectively 6 key items that all governments have agreed to work together on. And so I'll just quickly go through those. So the first one, which is priority action 1, is implementing mutual recognition of negative notices. So that a person who's denied a Working with Children Check in one jurisdiction, or where their Working with Children Check has been revoked in that jurisdiction, can't be granted or holded a Working with Children's Check in another jurisdiction. So this is referred to in the paper that was publicly released and is available on the department's website as Banned in One and Banned in All. And jurisdictions agreed to have legislation introduced by the end of this year. At the moment, most jurisdictions have that legislation either in place or introduced, and Western Australia and the ACT are the only 2 who haven't yet, and we understand are still working towards that. The Northern Territory introduced legislation, I think, last week, and other jurisdictions have introduced and passed that legislation. There's then priority action 2, which is having meaningful consistency in automatic exclusion criteria, and priority action 3, which is meaningful consistency in risk assessment frameworks. So making sure that as we move towards mutual recognition of checks nationwide, and there are currently 6 million Working with Children checks, that the exclusion criteria and the risk assessment frameworks are meaningfully consistent across all jurisdictions. So the policy settings for that work, jurisdictions all agreed would be done by the middle of 2026. And also by the middle of 2026, they will have done priority action 4, which is having clear information sharing pathways, and then looking to have legislative and policy and implementation changes by the end of 2026 and early 2027. And then there's priority action 5 is an operational national continuous checking capability, which enables close to real-time background checking across all jurisdictions. And then that will enable priority action 6, which is that mutual recognition of Working with Children checks, and they're for both committed to for the middle of 2028. So that was the main elements, the key elements that were in the agreement by Standing Council of Attorneys General and released in that paper.
So one of the things I think Australians often say is, I can't believe that this wasn't in place. Can you explain why the reforms, which you've just indicated have some very, very strict guidelines, why were they necessary?
So, Senator, working with children checks, as I mentioned, they apply, I think there are 6 million people who hold them at the moment. They apply across a range of professional but also volunteer settings, and they are one component of a broader range of work to keep children safe in those settings. So they make sure that people with relevant convictions, but there's also a range of other things that are taken into account, are unable to participate in work that is closely related to children. So it's part of creating much more broadly child-safe environments.
So,
Senator, if I could just also add that
Ms Jones.
you mentioned every jurisdiction has had working with children check regimes in place, but we have not had a coherent national approach, notwithstanding there has been quite a lot of effort over recent years, because it is so complex to have legislative frameworks, policies and systems aligned. So this does represent a significant step forward in that national approach, and when we have a workforce that moves across jurisdictions, it's incredibly important that there's consistency and mutual recognition around these checks.
So if you could, I'm sure people are a little surprised that that wasn't already in place, and this is significant leadership, and we've got leadership from right across the country. Very keen to see that the WA and ACT move on this early in the new year. But to make this kind of change, there needs to be an investment. What's the investment from the federal government, and how is the government and the minister leading in this matter?
I'll ask my colleagues to answer, but if I can just say, we have not given up hope or expectation that Western Australia and the ACT will introduce this year. They still have sitting days in their parliamentary schedule, and our engagement with them has been positive, and they are still seeking to meet that commitment.
That's very heartening.
I'll hand over.
Mr Brown.
Thank you, Senator. Tom Brown, Acting Assistant Secretary, working with Children Check Reform. At the 14 November Standing Council of Attorneys General meeting, the Attorney General announced Australian Government investment of $37 million over 5 years to implement the National Continuous Checking capability. That new capability will be introduced through the Australian Criminal Intelligence Commission.
Okay, so for the benefit of the committee, there's a number of stages you've gone through very helpfully, 1 through to 6. But could you explain the difference between the National Reference System, which I understand the Standing Council of Attorney Generals is prioritising, and the real-time continuous checking capability, which, based on the timeline that you gave, will take longer to develop? When will states and territories be able to join the NCCC?
Thank you, Senator. In relation to the difference between the National Reference System and the NCCC, the National Reference System is an existing system which houses negative working with children check decisions, so declines and revocations collected up from across different state and territory screening units. It's an existing system which gives visibility of those negative decisions, which informs risk assessment and other decisions by screening units at present. The NCCC is a new capability. It will be adoption ready for the pilot stage at the end of this year. It will give near to real-time monitoring of criminal history information changes, so charges and convictions, for working with children check holders nationally. So it gives a real-time picture across jurisdictions of changes to criminal history information. You asked, I believe, about when the NCCC will be adoption ready.
Yeah.
There'll be a progressive onboarding arrangement. So there is a pilot of the NCCC which will be adoption ready at the end of this year. That pilot will apply to ACT and AFP policing information, but the model is a staggered model where jurisdictions, according to their system readiness and the changes that each jurisdiction will need to go through to link to the national system, are quite unique and have their own timeframe. So it's a staggered model, but leading up to, as Ms Harvey mentioned, and 2028 full continuous linking, which coincides with other changes to turn on mutual recognition of working with children checks.
Thank you, Chair. I've got a couple more questions when you bring the call again.
Yeah.
Thank you.
Thank you, Senator O'Neill. Senator Shoebridge.
Thanks very much, Chair, and nice to see you all this morning. I thought I might just start with the department's performance under FOI. I assume that's cross-portfolio. Yep. Secretary, you know that there's a statutory timeframe in which to make FOI decisions. Yes?
Senator.
And you're aware of what it is?
I am, Senator.
Which is? The timeframe in which to make an FOI decision? I'll give you a hint, it's not 84 days, just for helpers. What do you think it is? Any guesses?
Actually,
Any
Mr Eagle is going to help me
takers?
out on the precise date. I think I know what it is, but I'm going to defer to his greater expertise.
Kenneth Eagle, Corporate Counsel. Senator Shoebridge, obviously, is 30 days, but that can
30
be
days.
extended under a number of different circumstances.
Or just not met? Just not met with deemed refusals? It's not extended.
If you
it's
don't
just
make
not
the
met.
decision within the statutory timeframe, then yes, you'll have
Yeah.
a deemed refusal.
Secretary, for the last year, which we have full data, last financial year, do you know what the average number of days your department took to make FOI determinations was? I gave you a hint earlier.
Very helpful, Senator Shoebridge.
Yeah.
Thank you, Senator. Obviously, we seek to try and meet the required timeframes wherever possible. We work closely with applicants to ensure that we clearly understand the scope of their request and we can respond accordingly. In terms of average timeframes, again, I'll need to ask Mr Eagle to answer that question.
24, 25?
So I don't have that exact number in front of me now.
Well, I do, because you gave the answer on notice to questions last time, and it's
Yep.
84 days.
Yep. Thank you, Senator.
Yeah, which, if my maths isn't perfect, but that's almost 3 times the 30-day statutory standard, isn't it?
The standard, yes.
Yeah. Secretary, do you know why your department takes 3 times as long as the statutory standard to determine FOIs?
Senator, I think with it, as with any averaging of statistics, that can take into account some matters that have taken significantly longer. I think...
Do you have any data to support that, or is that just a guess? Do you have any data?
We have looked
to
at
back
the
that
data, and
up?
I looked at that question on...
Point of order, Chair.
Yeah, thank you. If you can let the witness.
I think we have had a very clear direction at the beginning of this session that all people, whether they're witnesses or members of the committee, are to be treated with dignity, courtesy, fairness and respect. And Senator Shoebridge, I believe in your conviction, but I know your capacity for civility, and I do not see that on display at this early stage of the morning. So I would call your attention, Chair, to the standards and ask that they be adhered to.
Thank you, Chair. But I think
Thank you.
answers are always best when they're based in actual data rather than speculation and guess, and that will probably make the day quicker.
Yeah, I think the answer, even if it's not necessarily the answer that you want to hear, the way that we ask questions is still important, and letting the Secretary finish her answer is really important too.
So, Secretary, I think you're in the middle of explaining why your department takes 3 times as long as the statutory time limit to determine FOIs, so I'll let you finish.
So, Senator, I do recall looking at the data in the context of looking at the answer to the question that you asked from the last estimates. I think what I will see if my team can answer is in terms of the number that we actually did answer within the required time frame, which I think is still a significant number. I want to be clear, we really genuinely have a commitment to try and meet the deadlines, but we don't do that always. I recognise that, but we do have a commitment to try and do that, and we have sought to ensure that we have adequate resources in the FOI team to be able to manage that. But Mr Eagle will assist.
Well, before we go to Ms Engels, if If you had additional data when you saw the answers that explained the reality of what was happening, why didn't you include that in the answers? Why do we have to wait? I'm now going to ask you again. You're going to go and take some more information, get some more data, and then we'll come back again. If you had that information, Secretary, that helped put context on this, why didn't you put it in the answer?
I think we answered the question appropriately in terms of what the specific request was that you put in your question on notice.
Well, let's get the gloss, if there is some, that justifies your department taking 3 times as long as the statutory limit to determine FOIs last year.
So, Senator Shoebridge, I can say that in calendar 2025, 85% of decisions are made within the statutory timeframe.
Well, I'm asking, like, it's not very helpful if we go from the financial times that I've been asking about, then we suddenly switch to a whole new data set, which is calendar. I'm assuming most of the department's records are kept on a financial year basis. So if we're just going to, otherwise we can start this all again and I'll start asking on calendar basis.
And so since in 25-26 of the 161 requests received, sorry, rephrase that, in 25-26 we've had 161 requests received and 147 requests are finalised.
All right, but I was asking about the last year, which we have a full data set.
24-25,
yes.
There were 333 requests received, 339 were finalised.
And why did they take 3 times as long as the statutory time? And this was the question I was asking. We've got a random set of data about calendar years and about this year. I'm asking why it took 3 times as long to determine FOIs last financial year as the statutory requirement that sits on the department.
Sorry,
can we just answer the question?
Yeah, and as mentioned, Senator, while 30 days is the base required statutory timeframe, if there is need for third-party consultation, that becomes 60 days. If there is need for, sometimes applicants will consent to an extension, so...
Well, how many... Sometimes they will, sometimes they won't, but rather than just float speculation, how many times did they consent to an extension? How many times was there a consultation that explains this pretty woeful performance? Just making generalised assertions doesn't help understanding why the performance is like it is.
So, Senator, in answer to your question, we did provide you with some data regarding Section 15AB and AC extensions.
21 deemed refusals, 33 occasions where you sought an extension of time for complex or voluminous requests, but you told me there were 333 applications.
In 24-25, yes.
Yeah. So you've given me data that says on 33 occasions it was complex and voluminous, so you sought an extension. On 21 occasions you just comprehensively failed and there were deemed refusals. On 2 occasions there were internal reviews. So what that's 56 matters, but there were 333.
Where decisions were, applications were received and 339 decisions. So the rest of them
So why 84 days?
Overall?
Yes.
That's the average. Well, so as the Secretary mentioned, sometimes requests can take longer to process than the statutory timeframe. We do endeavour to get them all completed with the statutory timeframe. We seek extensions regularly and sometimes we get them. And as I think last time, as you noted, sometimes we do not get the extensions. Sometimes FOI requests are more complex.
All right. So can you provide every data point for last financial year, the financial year before, and this financial year that explains the department's performance? If that's consent extensions, that's deemed refusals, that's applications, that's voluminous matters, that's some other thing that might pop into the department's head to explain the delay. Can you provide on notice a comprehensive explanation for why on earth it took the department that's responsible for the Act 3 times as long as the statutory requirement to answer FOIs last year and whatever the explanation is for the year before and for this year?
Sure, Senator, we'll take that on notice.
Thank you, Senator Shoebridge. That seems like a good point at which to share the call. That's your 10-minute block. Senator Blythe.
Thank you very much, Chair. I'm just going to ask some questions around R.V. Clark in the Supreme Court of Queensland, which was a matter where the ATO used compulsory audit powers to obtain answers for a covert criminal investigation. So I was just wondering when the Attorney General's Department first became aware of allegations of impropriety involving the investigator and the Australian Taxation Office in this matter.
Senator, that is not a matter that I have any knowledge of. I think if we were to have any knowledge, it would be the group, the Office of Legal Services Coordination, if it had been reported to us as a significant issue. But I personally don't have any knowledge of that matter, so I would need to take on notice to ascertain what, if anything, what if any involvement the department has had.
Okay. That may make this line of questioning very, very brief, so I will provide all of the rest of the questions that we've got on notice for your department. Sorry.
So can I, Ms Jones, just to assist you with respect to this, Crown v Clark was a prosecution brought in the Supreme Court of Queensland. There were scathing, absolutely scathing comments made by His Honour Justice Smith in terms of making a stay, ordering a stay of the criminal proceedings with respect to the conduct of the ATO and also with respect to how the prosecution was progressed. Very disturbing findings made by His Honour. I would have thought the Attorney General's Department would have been briefed, or it would have come to the attention of the Attorney General's Department, the comments which were made. It would be concerning if it hadn't. So it could well be that your officers could consider the matter, have a look into it. And which outcome do you think?
I think Office of Legal Services Coordination in the Integrity and Security section, when the department's there, if it was reported as a significant issue. In terms of the conduct of the prosecution, I'm just not sure who was the prosecuting agency in that context, whether it was the CDPP or Queensland.
It was the CDPP. But given the strong nature of the findings, the scathing nature of the findings, it raises material rule of law issues, which is why when the matter came to my attention, I would have thought that it would have been a matter which came to the attention of the Attorney General's Department with respect to the conduct of the case. So if your officers could perhaps look into it, and we'll hold our questions until that section of estimates.
Thanks. We'll make relevant inquiries and see if we're able to assist in any way.
Okay.
Thank you.
Thank you, Senator Blyth and Senator Scarr. Senator Shoebridge.
Thanks, Secretary. When my thanks, Minister. When my office asked questions on notice about OAIC reviews from the department, we were told your department doesn't keep data, and you had to request that from the OAIC. Is that true? You don't keep data on the OAIC reviews relating to FOI from the department, only when you're forced to?
I'll ask Mr Eagle to assist with this.
Just to be clear, you haven't got the answer, but the answer included the department does not collect this data.
Yeah, we didn't have the data in the form you requested it, and we obtained it from the OAIC. Or you requested it from the OAIC.
Did you have it in another form?
We didn't have. We would have to have manually generated the data.
So when you said you didn't have the data in the form requested, you just didn't have the data because you didn't collect it.
Well,
was it in some other form?
Not in the form you asked for it. No.
What form was it in?
So we don't collect breakdowns. We don't routinely collect the breakdown of the OAIC data.
So I said, I asked if it's true you don't have the data.
Yes.
You said you don't have the data in the form that I requested it. In what form did you have the data? Was it in some other form?
No.
Okay, so you just didn't have the data?
No.
Okay. Secretary, I assume you want your department to perform well in FOIs. That's kind of it?
I do, Senator.
Yeah. So if you don't get any data about the reviews to the OAIC, but what are you judging the FOI on? Just the vibe, the departmental vibe about how you answer?
No, Senator. I think obviously we engage closely with the OAIC and work through any particular issues associated with matters from the department that appear before there. There's regular bilateral engagement, including at my level with the Information Commissioner and the FOI Commissioner, as well as the Privacy Commissioner. But I think I'm, like you, I draw a lot in terms of managing performance from data, and if there's improvements we can make in terms of our data collection, then we will look at that.
Well, do you have a target for FOI, for the timeliness of FOIs? Do you have, do you have a target? Like, is it the intention to meet the statutory requirements?
Yes, I think as I and as Mr Eagle have indicated, obviously we would seek to meet the statutory targets.
All right.
The timeframes.
But you don't, and you haven't for pretty much as long back as the data's been requested. Is that right? When did you last meet the targets?
Sorry, 100%.
Well, when was the average number of days for processing? 30 or less?
That wouldn't show whether we'd met the statutory timeframe or not, because the statutory timeframe isn't always 30 days.
All right. So, do you know? Do you have data about the number of occasions that your FOI matters meet the statutory time and
yes, Senator.
The number of times they don't?
As I said in an answer to an earlier question, and I appreciate you prefer financial years, but in calendar year 2025, 85% of requests were met within the statutory timeframe.
All right. Well, can we go back, just so rather that we don't have muddied set of data, for the questions that I asked you about about financial years, can you also include the number that met the timeframe? I'm happy to have it on notice.
Yeah, thank you.
I'm not asking you to do the numbers there. Do you have a target, Secretary, about the numbers that should meet?
Well, I think first and foremost, to meet the statutory timeframes is what we would seek to commit, but I recognise there are a range of factors that can contribute to not meeting timeframes, but that is always our intent.
I'll put the rest of those questions on notice. The Duggan family, Safrine Duggan, whose husband Dan and the father of her children has now been in jail for over 1,100 days, has written on a number of occasions to the former Attorney-General and received polite but pithy answers. She's written to the current Attorney-General and just received no answers, not even the dignity of a response. I suppose first to you, Minister, if an Australian citizen is asking the Attorney-General about her husband and the dad of her kids who's been in jail for 1,100 days plus facing extradition to the United States, and they write to the First Law Officer in your government, do you think they're entitled to a response?
Well, I don't know the particular circumstances of this case, Senator, but I will make some inquiries as to what's happened here.
Well,
as a matter,
sorry.
Please let me finish.
You finish.
As a matter of practice, every time somebody sends me a letter, I do try or some form of communication, I do try and respond in a timely way with as much information as I can provide. I do that both in my capacity as a senator for South Australia, but also, you know, in the ministerial role. But I don't know the circumstances of this particular case, and I'd hate to make a judgment without all of the facts in front of me.
Well, Secretary, I mean, I think the Minister's set out the basic assumptions of decency and responsibility for a minister in receiving correspondence, and this isn't like correspondence. This is a woman asking about her husband who's been in jail for 1,100 days facing extradition to the United States, who's been separated from his kids for 1,100 days, writes to the Attorney-General and gets no response. Can you explain?
Senator, the first thing I'd say is, Chair, this is a matter in the Integrity and Security Group. Extradition and international crime cooperation are matters to be dealt with in that area. But I would note, I'm not familiar particularly with the status of that letter, but we will seek to have officers look at that and be able to respond at that appropriate time.
And the rest of those questions are in which outcome?
So it's in the Integrity and Security.
Integrity and Security. Thanks, Secretary. Court transcripts and Judicial Commission?
That will be in the Justice and Community Group, which is the next group after we finish with corporate.
And that includes Judicial Commission?
It does.
Yeah. NDAs, non-disclosure agreements.
So that will be in the Integrity and Security Group when the Office of Legal Services Coordination comes on. There are some aspects that go to the Respect at Work report, which is in the human rights area, but I'll make sure that we can answer any questions you have about that.
Okay. And so in which outcome?
So that's the Integrity and Security Group with the Office of Legal Services Coordination.
Well, so let's get there.
Thank you, Senator Shoebridge, for that. That concludes our time with cross-portfolio. We will now move to the Justice and Communities Group and Closing the Gap outcomes 10, 11 and 15. Senator Blythe, are we going to you? And we'll proceed with questions, and we'll start with Senator Blythe.
Fantastic. Thank you, Chair. This is just in relation to the, I guess, the federal government's or the Commonwealth's position in relation to softening bail laws. So looking at the national plan to tackle increasing remand rates, despite the state and territory governments refusing to endorse the SCAG bail and remand reform working group's report, will the Commonwealth still be pursuing that national plan?
Thanks for the question, Senator. I think it relates to some work that was requested by the Standing Committee of Attorneys General to be undertaken. So that request involved every Attorney General from every jurisdiction asking a working group to look at a range of issues associated with bail and remand in the context of addressing high rates of incarceration of First Nations adult and youth. And the working group, following that tasking from every Attorney General and every jurisdiction on the Standing Committee of Attorney General, prepared a report that was considered at the most recent Standing Committee of Attorneys General meeting. The report was not endorsed by SCAG and no jurisdiction sought to have it endorsed, including the Commonwealth, but it was discussed. So I can hand over to my colleagues to provide a bit more detail on the process associated with the report. But I would just note in relation to bail legislation, the report was clear that is a matter for each jurisdiction.
Senator, the bail and remand report that the working group provided to the Standing Council of Attorneys General had a number of recommendations in it, and some of those went to legislation, but a range of them actually went to programs and policies that the working group had considered and had recommended, for example, either further work be undertaken or jurisdictions consider those. So, sorry. So as Ms Jones said, the report was released. It hasn't been endorsed by jurisdictions, but those recommendations are certainly there for consideration by all jurisdictions, including through work such as the Justice Policy Partnership.
Have you been instructed to go ahead or do anything else with those recommendations, or is that just a report that will sit?
So those most of those recommendations, criminal justice systems are located in states and territories. So, for example, those legislative changes would all be for each individual state and territory to consider. So we haven't been instructed to take forward legislative change. That is a matter for states and territories. Certainly, there are pieces of work that in there which do not go to legislation, but instead go to things like alternative and co-responder models. There's some education things. Ms Bogart, my colleague, might be able to talk a little bit more about them. But certainly there are things in there that could be considered by all jurisdictions.
Thanks, Senator. Esther Bogart, First Assistant Secretary of the First Nations and Justice Policy Division. Yes, there are a few of those recommendations, the non-legislative recommendations that the Commonwealth is in a way already implementing. So, for example, the Justice Reinvestment program that the Commonwealth funds. There are some initiatives that fund, for example, bail support services, which was recommendation 1 of the report, and and alternative responder models. And there's around 5 of the current initiatives do have a kind of flavour of the co-responder and alternative responder models. So looking at those models which effectively, if people are on bail or to prevent people from interacting with the justice system before they get to court, and it has a real community safety sort of aspect to it as well, that people don't get into the criminal justice system in the first place. We've also invested $642,000 for the Australasian Institute of Judicial Administration to develop an Aboriginal and Torres Strait Islander bench book. That's been in progress for a couple of years, and that sort of aligns with recommendation 3 about providing education to bail decision makers when they're considering decisions around bail and remand.
So can I just understand, so this plan wasn't endorsed by any of the parties at all that were party to it?
Senator, it's a report. It's not sort of a national plan. It's just a working group report that was provided.
Okay, but it contained recommendations.
It did, but it looked at evidence base of things that are already working, and a lot of the conversation in the working group was what could jurisdictions learn from one another from a best practice perspective, and so multiple jurisdictions are already implementing some of the things in there prior to the report being
But they didn't endorse this report at all. No party endorsed it. Can I ask, and this may be something you have to take on notice, of the various recommendations that were contained in that weren't endorsed by any of the parties, how much taxpayer funding is being allocated to progressing the recommendations?
So a lot of those recommendations are directed at the states and the territories, so we
just
wouldn't
heard
be
that
able to...
642... Sorry. Yeah.
I mean, to the extent that there's any costs associated with any of our activities, of course, we can provide you with the detail on that.
That would be excellent.
But not the state and territory material.
No, I'm aware of that. I'm purely asking from a Commonwealth perspective.
And Senator, I was just going to add, Ms Bogart's evidence was that these are things that we already have in place, and so that report has been prepared and now released, and in part, as Ms Bogart said, it picks up on a range of work and good practices that are occurring across the country.
Yep.
And so in terms of funding for the report, I wouldn't characterise most of it as that. I would say these are things that we already have in place, and that are,
which is fine, but it's just unusual that not a single party has endorsed it. So there are recommendations that, if you're saying it's good work, it's unusual that not a single party would endorse any of the recommendations. So they didn't even single that out. They just haven't endorsed any part of it.
I think that was just the view that there was work there that was helpful from the perspective of being able to share information on best practice around particular services that might have good community safety outcomes, but also, very importantly, seek to reduce First Nations adults and youth interaction with the criminal justice system. And there was value in that information, firstly being shared with all jurisdictions, and secondly that the report was transparently released without needing to go through and endorse or not endorse particular recommendations, though there was a very clear understanding that any decisions around legislation are a matter for individual jurisdictions.
Yeah. Sorry,
Just a 1 minute.
yes, certainly. Thank you. I think some of the members of that group have come out much more strongly than that in suggesting that they weren't supportive of any part of it, but that's fine. I'm happy to hand over the call. Thank you,
Thank you
Chair.
very kindly. Senator Cox.
Thank you very much, Chair. Can I ask some questions around justice reinvestment? Right people at the table? Yes. Excellent. At previous estimates, the department gave an outline of the government's national justice reinvestment and justice reinvestment, particularly in Central Australia. Can you break down for us some of the programs into some specific examples of the initiatives that have been funded, particularly for Central Australia?
Certainly, thanks, Senator. So we have across the two programs, so the National and Central Australia program, we have 27 initiatives that have been funded under the up to 30 commitment. We actually technically have 28, but one has completed, so 27 active. That's made up of 25 under the National program and 2 under Central Australia. Our 2 Central Australia program initiatives are less than 12 months old, so they were the most recently selected. So they're both in the very kind of initial stages, but deal with a lot of the peacemaking in Central Australia, so one of the critical functions that help with community safety in Central Australia. Across all of our initiatives, though, I guess we've got some that are further advanced, and some of those maybe picking up on some of Ms Bogart's commentary. We have, a bail support services initiative that's designed a flexible intervention program for at-risk youth. So that one's well established and has had, I think it's upwards of 100 referrals at this point in time. We've got an alternative co-responder model where there's case management support within the court system and post-sentencing support. So really looking at all sides of the justice system, so preventative as well as re-engaging both adults and youth at the sort of having entered the system to prevent reoffending. And in terms of some of, I guess, the impact that we're seeing, and noting that justice reinvestment is a long-term commitment, but we've got, one of our initiatives that have met all of their year 1 measures of success. So one of our initiatives that's been operational for 12 months has established a new youth hub, is housing multiple trauma-informed youth services, and they collaborate under a psychological case management model, so really connecting in all of the services that will help those youth. We've got that program I mentioned with over 100 referrals. They've had 50 clients being case managed through the program already. They've also assisted young people with supervision orders to actually complete their orders. So part of, I guess, the real value of justice reinvestment is that quite typically in the justice system, there'll be some intervention at the point of connection with the justice system. And then there's no sort of follow through, there's no wraparound, and that's where we really find reoffending happens. All of these initiatives really go towards that wraparound service and connecting all of the local services together. So your police, your courts, your education systems, your psychological, mental health supports. We've also got an initiative that's established their program and done all of the fundamental recruitment training, governance, structures in place, and they've engaged with 6 schools and their program's already expanding. So they're currently supporting 9 students and 4 families. And putting that into a human context, that's taking children who are not attending school at all to seeing attendance rates upwards of 80% in a really short time frame. And when you consider that those programs are just at their fundamental stages, seeing that expand and seeing the level of impact in the community is quite, I hesitate to use the word rewarding, but it is really rewarding to see the impact that these initiatives are having in the communities.
Yeah, thank you, Ms Woods, and such an important initiative that our government are investing in, and with 27 programs, those 2 in Central Australia and 25 nationally, such a great and of real interest to this committee as we have an inquiry that we'll be looking further into this. So thank you and thank the department. Thank you, Chair.
Thank you, Senator Cox. Senator Shoebridge.
Thanks, Chair. Minister, we're a nation of like 27, 28 million people. We have a youth justice crisis around the country, and then when the national government is asked about programs to help justice reinvestment, we get given 3 out of 28 examples. One helps 9 students.
Three what?
We got details of 3 of 28 examples that your government is funding. One has helped 9 students. One has had 50 clients, and one has had 100 referrals, although we don't know what's happened with 100 referrals. We could probably go through the other 25 and maybe get another 10 here, 20 there. Is that really a national response to a national crisis? 9 students here, 50 there?
Well, we, as a government, take our responsibilities in this area very seriously, and I know this is an issue that's a priority with the Attorney General. A lot of this work, of course, well, overwhelmingly, this work is state-based issues, so to a significant degree, I think the job of the federal government is to, work with the states to resolve these issues. As a government, we don't want to see particularly young people involved in the criminal justice system. But I guess it's fair to say that the issue is getting harder to deal with because it would seem, certainly in some of the states, the issue is difficult to deal with. But look, I can't say anything other than, we as a government don't want to see increased levels of youth incarceration, and we will work as best we can with the states to try and minimise and reduce these issues.
Well, but you see, Minister, the Commonwealth has legislative powers under the External Affairs Power, has substantial fiscal powers that they can apply on states who behave badly. You say, and I believe you personally, that you want to see youth justice numbers reduce, less First Nations kids in jail. I believe that's your personal commitment. The problem you have is, under your government's watch, the numbers of particularly First Nations youth in detention has skyrocketed in Queensland, the NT, New South Wales, WA. The Victoria is just moving to put kids in jail for life. Your assertions about what you believe in and then the reality of where the country is going to under your government are 180 degrees apart. How do you explain that?
Well, I think I have explained it, Senator, because
my job is not an explanation that the community will accept, Minister. Not my job.
No, I don't.
We'll let the Minister answer the question.
Yeah, no, I think you're verballing me there with respect, Senator Shoebridge. All I'm saying is that the overwhelming responsibility for dealing with this issue or these issues lies with the states. And as much as we might like to intervene in the states to deal with these issues, the reality is that these are primarily state issues. We want to work with those. I know the attorney wants to work with the states to try and, as you say, reduce the levels of incarceration.
But Minister,
not every issue is easy to resolve in government, Senator Shoebridge. You might like to think you can flick your fingers like that and the problem gets solved. That's not the way society works. That's not the way governments work. And the longer that you're in this game, the longer you realise that some of these problems do take longer than you would like. That's something I've found in government, that it's easy if you're a member of the Greens to define the problem. It's much harder when you've got the responsibility.
I can give you some suggested responses to help. Use the external affairs power to put in minimum standards for detention. Use the fiscal power you have to punish states that put more First Nations kids and to fund states and programs, take funding away from carceral systems in the Northern Territory and put it into Aboriginal controlled organisations that divert kids away. There's some solutions, but you're not doing it.
Well, I'm happy to do this, Senator Shoebridge, since you've addressed your mind to some ways in which we can resolve this issue, to take those three things that you've just mentioned and raise them with the Attorney-General and come back to you with her response to those ideas.
I appreciate that, Minister. Secretary, last time we were here, I asked you, after there was some discussion about the Justice Policy Partnership, the National Justice Policy Partnership, and closing the gap targets for First Nations kids under that partnership, I asked you to provide instances of actual concrete change that's been delivered under that partnership. Now, I could read on the answer that you gave, but it would just depress the country, because there's not a single instance of actual change. It's process, 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 process. How is it that even when you take a question on notice, you can't identify a single instance of actual concrete change for either closing the gap targets or First Nations kids in jails under the Justice Policy Partnership? How can't you give one instance?
Senator, first thing I would say is the characterisation you made of the impact of justice reinvestment, I think, understates the importance of those projects around the country. They are significant investments that took several years working with community, working with ACOs to try and design programs that worked best for particular communities. What we've learnt is you can't have a cookie-cutter approach and just apply any way of operating. The early signs are positive in particular communities. and so I think it's really important to call that out. It is a way where the Commonwealth can show leadership. We are not the only ones that do justice reinvestment projects. States and the territories have some themselves that they have funded, so it's not exclusive to the Commonwealth in terms of doing justice reinvestment. The Commonwealth invests significantly where it has responsibilities, including in the National Access to Justice Partnership and the funding of Aboriginal legal services and family violence prevention legal services. There's a range of other initiatives that I can ask Ms Harvey to talk through.
I was asking for instances
I'll get to the
of actual
Justice Policy
concrete
Partnership.
change.
So the Justice Policy Partnership is a long-term commitment and mechanism working with every state and territory and with relevant First Nations representatives to consider a range of issues that go to improving justice outcomes for First Nations people. It's not intended as a mechanism to deliver projects itself, but it's more about supporting effective conversations around the justice system.
They have not been effective, Secretary. In part of this answer, this process-driven answer, when I ask about actual concrete change, one of the examples, one of the sentences is the Justice Policy Partnership has provided substantial evidence-based advice and recommendations to SCAG on raising the age of criminal responsibility and bail and remand reform.
Yes.
And on every one of those, raising the age of criminal responsibility, bail and remand reform, across the country, it's done the exact opposite of what's contained in the Justice Policy Partnership. Instead of getting kids out on bail, it's putting more kids in on remand. Instead of making remand safer, remand has got more dangerous. And instead of raising the age of criminal responsibility, the NT has lowered the age of criminal responsibility. How do you put that answer in as an example of an achievement when on every single part of it, it's gone backwards?
Senator, as the co-chair of the Justice Policy Partnership, the partnership was established, as Ms Jones said, bringing together all government officials, state, First Nations experts and First Nations Coalition of PEGS partners. And the role of the Justice Policy Partnership, as with all partnerships, is to provide advice. The Justice Policy Partnership is not, we're not decision makers.
Chair, the whole reason I asked this question was, what's actually happened? What's changed? What's got better? What concrete happened? I'm not asking about the advice. What's changed as a result of it? And I point out to you on that thing, everything has changed for the worse. And I ask again, so you bring these First Nations people in, you bring these First Nations peoples into this, Peaks and others. They've got a lot of stuff on in their communities, right? They've got a lot of stuff to do to try and help their communities. And their energies and their intentions get sucked into this thing and nothing happens. It's actually a kind of wicked betrayal of First Nations communities, bringing them into a process that never makes any changes, never helps, never gets a kid out of jail, doesn't hold the states and territories to account. It's wicked doing that to people who have so many other things to devote their attention to in their communities.
So, Senator, I don't accept that characterisation. I think it's inaccurate and unfair.
Well, tell me what's changed
and
for the better.
And the Justice Policy Partnership will continue to provide robust advice to governments. Ultimately, it's a matter for governments to decide their settings around child protection, around detention facilities, around legislation, and we continue to engage with officials, but ultimately they are matters for state and territory governments.
Thank you. I'll now share the call. Senator Scarr.
Thank you, Chair. I want to ask some questions in relation to the Copyright Amendment Bill 2025.
Just get a change of people, Senator. Perhaps while they're on their way, I might just note, I understand that this bill is currently before the committee in another, before the reference committee in another...
So that means you'll be limited in the in the types of answers you can give and the questions asked.
Yeah, so I wanted to ask questions in relation to the consultation process. Is that something that's going to take me into areas?
It's allowed. I've been given advice,
Yeah.
so that's allowed.
Okay.
Yeah.
Thank you. Thank you. There's been some discussion in relation to Section 28 in particular, and this is where, in the context of an educational setting, works may be referred to, and the issue around whether or not the protections for copyright in that context should only apply in relation to virtual lessons as opposed to lessons which are given, they're recorded and then delivered sometimes subsequent to the first lesson. You're aware of that issue, Ms Priestley?
Yes, Jenna Priestley, Assistant Secretary, Commercial and Copyright Law Branch. Yes, I'm aware of the issue.
Okay. So what I'm first interested to know is what consultation did the department engage in relation to this issue in terms of formulating the bill?
So we engaged in a range of consultation in a number of ways over a number of years. So I can take you through a timeline at a high level.
Sure.
This issue around Section 28 was first identified most recently in a copyright roundtable chaired by the then Attorney General in February 2023. That was where stakeholders agreed that it was a priority issue, that the government, that further work could be done to try and come up with a consensus position on sensible reforms that could be made to that section to address some issues with broad stakeholder support. We then spoke about...
So sorry, can I just stop you there?
Yep.
We might just stop on this journey. In terms of that round table with the Attorney General's Department, what was the nature of the stakeholders in attendance at that round table?
So there was around 20 stakeholders who attended that round table. I think probably key on this particular reform, the Copyright Advisory Group was represented at that round table, and they represent broadly schools and TAFEs, and then Universities Australia, which represents universities, was also present. From the copyright stakeholder side, we had Copyright Agency, Screenrights, who are declared collecting societies, which deal with the education statutory licence, as well as a number of other stakeholders representing rights holder groups. So
was there any group, and I'll just raise this now so you can consider it in terms of the subsequent steps that were undertaken in relation to submission, were there any stakeholders representing the interests of, say, families who take advantage of remote education, people who, because of their circumstances, have difficulty perhaps in attending virtual education and rely heavily on recorded education?
So I think those views were represented by the Copyright Advisory Group, who put forward positions in relation to those particular circumstances.
Okay.
And they represent schools and TAFEs.
Okay. So they specifically dealt with that issue?
I'm not sure if that issue was specifically dealt with at the first roundtable, but that group has made representations to government on a number of occasions around remote learning issues.
Okay, I'll let you continue with your consultation roadmap.
So after the first roundtable, we had a second roundtable, which was chaired by the department, where we spoke about remote learning issues in more detail, and also covered off on some other issues identified at the first roundtable. I think it's fair to say that discussion at that round table did identify that issues around remote learning were quite contentious. So as a result of that, we held a follow-up side meeting in August of 2023.
So just stop you there. So the second round table identified the issue around remote learning was contentious.
Yes.
How was it contentious? What were the competing submissions in that regard?
So it was a discussion. I'll be going back in my memory a little bit here, but basically Section 28 of the Copyright Act, there was a difference in opinion about whether it covered online learning or not, with some stakeholders of the view that it does currently cover online and remote learning, and some stakeholders not agreeing with that position. So the Copyright Advisory Group was generally of the position that it did not currently extend to online learning, and some other stakeholders were of the view that it did not. Oh, it did, sorry.
Okay. So who makes up the Copyright Advisory Group?
So
are they academics, stakeholders, practitioners?
The representative of the Copyright Advisory Group, I think I'll have to take exactly on notice who makes up the group, but broadly they are representatives from the Department of Education in New South Wales, I believe, that act on, represent the views of schools across Australia and TAFEs.
Okay. And who was in the other camp? Who thought it was covered?
So most rights holder groups were of the view that Section 28 did already extend to online learning in a live context.
In a live context, not a recorded context?
Yep.
Sorry,
I think
just
it's a shared view.
Just for the Hansard record?
A shared view across all stakeholders and the department that Section 28 doesn't extend to recorded lessons and has never extended to recorded lessons. So it's intended to apply in a live classroom setting only, whether you're talking about a physical classroom, an online classroom or a hybrid classroom.
Okay. Are there some education providers who argue the existing statutory licence already regulates this safely?
So on the education side, I don't believe that we've had submissions on that point, but the rights holders side do make the argument that the statutory licence does already apply to recorded classrooms, and in circumstances where the statutory licence doesn't apply, schools may be able to enter into voluntary licensing.
Okay, all right. If you can continue with your roadmap.
So in August 2023, we had a side meeting with interested stakeholders on remote learning, and that again included the Copyright Advisory Group and key sort of rights holder stakeholders. We really tried to get to the bottom there of what the problem was and where there might be scope for agreement between, I guess, both sides, for want of a better term. And that's where we did agree to, I guess, the scope, the policy and the scope behind the amendments that are currently in the bill at the moment. That was formally agreed at our final roundtable in December of 2023. We then in the department went away and did some policy work to turn that policy that had been agreed into legislative amendments alongside the Office of Parliamentary Counsel. We re-engaged with stakeholders in April of 2024 to give them an update on that work, and then from September of this year we consulted again with that group that had been identified as particularly interested in the amendments to Section 28 on the draft provisions of the bill, and we did that in a number of ways. So we provided them with the draft provisions. We held meetings with them, we had one-on-ones back and forth to develop the amendments to a point where, at least among those stakeholders, there was agreement that those amendments could be taken forward with broad stakeholder support.
Okay. So where was, in terms of the consultation, how did the parties involved in the consultation consider that this issue of students who may be sick or they've missed a class, they missed the online, say, virtual class, needed to catch up, perhaps for whatever reason they've come into the system a bit later and there's benefit for them to be able to go back and catch up in terms of lessons. How did the parties making submissions in relation to this matter consider that it should be dealt with?
Senator Scarr, I'm just going to mark that after the officials answer this question, I'm going to rotate the call.
Sure.
Thank you.
So I would say the focus of this bill, the Copyright Amendment Bill, has been on identifying amendments that could be taken forward with broad support from stakeholders. So really the consultation that we have done with stakeholders since the scope was agreed in August of 2023 was to focus on how we might be able to make amendments to agree to that scope. So
including that issue.
The recorded lessons issue wasn't a focus of subsequent discussions. Okay. We were really focused on the elements that could be taken forward with support across the board.
Thank you very much. Senator O'Neill.
Thank you very much, Chair. And sadly, so many Australians still face incredible levels of sexual violence and family violence, and my questions go to the Sexual Violence Specialist Legal Service pilot. So if we could get the people for that to the table.
The right people to the table, Senator.
Thank you. I was alarmed to read a story this morning about a man who got his mate to use new technology to limit the movement of his wife's car, had a kill switch so that she could only go as far as her local school with the children. This level of coercive control is very disturbing for decent Australians, particularly decent Australian men who are sick and tired of this. So I'm very, very interested in the action going forward, what's been happening. So that's what I want to get on the record today so that people can have some hope that this government is listening and responding to the challenge.
Thanks, Senator. And I'll ask Ms Bing to detail the measures and activities that the department is responsible for. I saw that item on the news this morning and the e-safety commissioner talking about that. And I think that the broader issue of the adaptation of technology to the ends of coercive control is an ongoing issue that we need to work with e-safety commissioner and other departments to consider the implications of that. But in terms of the matters that we're directly responsible for, I'll turn to Ms Bing.
Yeah, I understand, Ms Bing, that last week the Attorney-General might have announced a national extension of specialist trauma-informed sexual violence legal service pilots. What are these pilots and what are they doing to support women victim survivors of sexual violence?
Samantha Bing, Assistant Secretary, Family and Community Safety Branch. Thank you for your question. So I'll start with the specifics and then I can turn to broader work on foot if that's helpful.
Thank you.
So these pilots are providing wraparound therapeutic legal assistance and non-legal assistance to victims of sexual violence. They were a pilot in 3 jurisdictions to start with. But on the 26th of November, the government announced expansion and extension of these pilots in the ACT and WA. So that's 2 of the existing pilot sites, and the establishment of new pilots in South Australia, Northern Territory and Tasmania. They are being done in partnership, so it's not just a single service delivery model, it's a consortium model of providers to deliver the services, and that reflects the specialist skills that are needed to provide both legal and non-legal assistance in a holistic way. The other jurisdictions will be announced imminently, so Victoria, New South Wales and Queensland, their pilot sites will be announced soon. There was some information about the providers. I can go through the providers in each jurisdiction if that's helpful.
Yeah, that would be really good. Let's just sort of roll back a little bit because access to support has often been fragmented. So and women fleeing domestic violence have needed more wraparound care. I think you described it, and often trauma-informed care is what's spoken about. So this is a government response to an identified problem. How was the need for these pilots identified, and how was this particular response designed?
So the work that's been happening in this space that this portfolio leads falls under the auspices of the Standing Council of Attorney General, SCAG's
In the
five-year
ACT
work plan.
and WA, these are the pilots, yeah?
So the pilots are just one part of what we are doing to respond to sexual violence. We have a broad program of reform work under the Standing Council of Attorneys General. There's a 5-year work plan to strengthen criminal justice responses to sexual assault, 2022 to 2027, and that work plan is aimed at improving the way systemically that the justice system deals with sexual violence and improving the experiences so that the justice system is less traumatising for those people that engage with it. There's a whole range of reforms on foot there, and I might remind you of the Australian Law Reform Commission's recent inquiry that was released in March, which has a raft of recommendations that we're carefully working through with the states and territories, all designed to improve the experiences of victims and survivors engaging with the justice system, but also to hold perpetrators to account.
Okay, so into that context and with that dedication to policy and investment in support for these women, 2 pilots were established in ACT and WA.
No, my apologies. There were 3 pilots that were established a number of years ago now. 3, so Victoria, WA and ACT. Okay. They have now been extended for an additional duration of time.
Right.
And we are setting up those pilots in each other jurisdiction as well. That work is on foot, and that's the other 4 that were announced. That relates to those announcements that happened recently. And then there'll be 3 more jurisdictions that will be announced soon. So there'll be those pilots operating in each jurisdiction. The original 3 pilots have now been extended for a further period of time, and we've added new service delivery models into that. So they will be having justice system navigators, so people to help someone throughout the process, and they will also be supporting people to access existing restorative justice pathways. They are 2 elements that were drawn out of the ALRC inquiry report, and we are deliberately embedding them into this service model and evaluating them, and that will be part of implementing the longer-term response to the ALRC inquiry.
So, Ms Bing, you've given me a very fulsome answer, but I wonder if women who are listening today understand what all those programs are. So if I can just go to the point of, who's delivering the services and what are people getting from these service providers that address the terms that you've just spoken in? So, if you can translate it to happily, I'm not in this situation. I've been very happily married to a wonderful man for 40 years. But, if I was in a situation and I needed to flee today, what am I going to get as a consequence of this change in practice, these insights? Who's going to provide it to me and how's it going?
So I would say that the model will differ slightly in each jurisdiction, so I can't give you a single answer, but I can take you through some examples.
That would be great.
They do all have consistent core services that they're offering, but they may be adapted to the jurisdictional context. So, for example, in ACT, the Women's Legal Centre ACT and Victim Support ACT are working together to support people that come forward. So, for example, someone might contact that, they'll be given an appointment, or they'll walk in the front door and they'll be given support. They'll have access to a trauma-informed interview rooms that are set up. I've been to the one in the ACT, also has an area for children to play, and other trauma-informed ways to engage with people.
So I'm not sitting at a desk with somebody who doesn't understand what's going on, with the kids, freaking out because, we've fled a situation, we're in a pretty awkward... This is actually a place where I'm going to be welcomed.
Yes.
And somebody's going to hear me, and the people who are going to hear me actually understand the trauma that I'm going through.
Absolutely, that is the intent, and that is the type of workforce that is operating in these services. You will get free assistance, that might be legal advice, but also advice for other things. For example, you might need assistance to get a domestic violence order, you might need assistance with housing, you might need assistance with how to navigate Centrelink, and other programs that are in place. You will walk through the door and you'll be provided with that help.
So this is what you're talking about when you say wraparound care. So this is for women who might have never, ever thought they'd be in this situation, from all walks of life and all levels of income.
That's
who
right.
have never had an interaction with Centrelink perhaps in their life, or women who have never, ever had an interaction with the justice system, got no idea how this stuff works. These pilots are providing a new way of helping women with those real and practical challenges. Is that what their purpose is?
That's what I'm saying. So it's not just your legal need that is being addressed when you come into this service, it's your other non-legal need, as well as therapeutic things like counselling, like referrals, like help to engage if you need to talk to the police, for example.
So it's a very big difference from the standard legal service that people might have had trouble accessing anyway previously, but now they're going to get this trauma-informed. So you've indicated the pilots are different in each jurisdiction. I'm sure there's a reason for that. Can you explain why that might be the case, Ms Bing?
Yes, so for example, in WA, it's being delivered by Women's Legal Services WA, RUA Legal Services and the Aboriginal Family Legal Services Group. That is meeting a particular culturally responsive need in that jurisdiction for that service. Some jurisdictions will have their own services as well. And so some jurisdictions, when they've come to us with their pilot proposals, have identified a gap, a service gap in their jurisdiction, and this pilot will help to meet that. For example, it could be that in one jurisdiction they've identified that there is not enough services for youth and people under 25, for example. Okay. So this pilot will focus on that age cohort.
So it's not one size fits all, because we don't want to duplicate anything that's there. That's just wasteful. This is about making sure that the gaps that have been identified get filled in different ways through different pilot projects in different parts of the country.
Yeah,
okay.
That's a very good characterisation.
Last question, if I can, Chair. When will the remaining jurisdictions receive their funding for pilots?
So we'll be working through a federation funding agreement arrangement with the jurisdictions. That funding will flow through a treasury process. I'll have to take on notice the precise timeframe for that, but payments will be made retrospectively where necessary.
So things are being set up in anticipation of the payment
Correct. Coming. So the new jurisdictions, we're aiming to set up the services from 1 January next year. After 1 January next year.
Just in a matter of weeks? Yes.
Correct.
Thank you very much. Thank you, Chair.
Senator O'Neill. Senator Shoebridge.
Thanks, Chair. If we could go back to the Justice Policy Partnership. I referenced, Secretary, an answer which dealt with criminal responsibility, bail and remand. So just to be clear, what specific recommendations did the JPP make on raising the age of criminal responsibility, and which jurisdictions implemented them?
Senator, I don't have the report in front of me. You've already referenced some of the position with jurisdictions raising the age. I'm aware that others have indeed raised the age or have committed to do that. The report also goes not just though to the legislative matter of raising the age of criminal responsibility, but actually goes to the nature of the services that need to be in place to really support that change.
Secretary, just for the sake of time, if the detail isn't here about the recommendations and what changes, I'm happy for it to be taken on notice and for a comprehensive answer to be given on notice. Unless there's some specific evidence you give about which jurisdictions have implemented the recommendation.
So, Senator, my answer was that while I might not be able to point you towards a particular recommendation being implemented, thank you, overtly in a jurisdiction, the report goes to a range of things that need to be in place. So it is a resource that can be drawn upon by jurisdictions as they are working their way through that.
All right. Well, I asked which specific recommendations did the JPP make on raising the age of criminal responsibility. and which jurisdictions implemented them? I still haven't had that answer. Can I get an answer on notice, Secretary?
So, Senator, my answer was I can't point you towards a particular recommendation that has been implemented by a particular jurisdiction. What I can say to you is that that report was provided to all jurisdictions that sets out a range of things to put in place.
Well, what specific, you can, I'm sure, point me to what specific recommendations the JPP made on raising the age of criminal responsibility.
So,
if there aren't any, then you don't
Senator,
point. If there are some, point them.
The JPP worked with, I think it was a SCAG working group, to provide work to Standing Council of Attorneys General for Attorneys General to consider. And that is in line with the role of the Justice Policy Partnership and working groups.
So, Secretary, I'm having trouble getting an answer to my question about what specific recommendations the JPP made on raising the age of criminal responsibility. Do you know why I can't get an answer to that?
Senator, I think Ms Harvey has actually answered your question.
Well, what were the recommendations?
So the Justice Policy Partnership members worked with members of Standing Council, officials from Standing Council of Attorneys General.
I don't want to know about the process, just the recommendations.
Senator, what I might add is that there are no recommendations in
Okay.
that report.
No recommendations.
It is a principles-based framework for jurisdictions to consider in raising the minimum age. So it didn't make a recommendation to raise the age and which age to raise to. So, so what jurisdictions now have is a framework that they can draw from best practice principles in looking to raise the age.
So can you answer on notice what jurisdictions have drawn on that framework, what changes they've made or services they've put in as a result of that framework to raise the age? Can you provide that on notice?
Senator, it would be a matter for each jurisdiction of what they've done.
You're not tracking them?
There's different things that people have done. Some of it is drawn from the report. We might not be able to go specifically link it to because of that recommendation. They did.
Do the best you can, Secretary.
Senator, we'll look at the terms of the question on notice and see what we can provide.
And in the same regard, well, sorry, Secretary, I think Ms Harvey said that the report recommended services that could be put in place that were essential if you're going to raise the age. Do you remember hearing Ms Harvey say that?
I do.
What services have been put in place then?
We'll talk to the jurisdiction.
What concrete bail and remand reforms have resulted from the JPP report to SCAG? And where?
So, Senator, there was a Justice Policy Partnership was asked by the Standing Council to report to it on bail and remand, which it did, and it then commissioned further work from a working group which provided a report very recently. And we gave evidence on that earlier, that report was publicly released. It hasn't been endorsed, but that report was provided to all attorneys in August this year. Now, there are things that the report does reflect, in part, good practice that is occurring in pockets of the nation. It also reflects a range of legislative changes informed by evidence. So I can't point you to say this recommendation has been adopted by this particular jurisdiction. It is a matter for each jurisdiction as to what they do with the recommendations in that report.
And the report also contains a number of case studies of things that jurisdictions are already doing as best practice in relation to some of those recommendations.
They were before the report. Things in place before the report.
Yes,
They inform.
Well, you see, if you're sitting down in regional towns in my home state of New South Wales and you're thinking, well, what's the Commonwealth done to keep First Nations kids out of jail? What has all of this activity, this JPP, the SCAG, the bringing First Nations peaks in, what has it done to keep a single First Nations child out of jail? What would I tell them?
So, Senator, one of the other pieces of work that has been occurring over the last few years with the Justice Policy Partnership is the partnership that we have with them in terms of setting up the National Justice Reinvestment Program. I think it's 12 or 13 of those.
Is this the one that has First Nations kids in Alice Springs, as a result of policies delivered in the last 12 months, put in shackles, having the shackles attached to a belt at their waist, putting them on planes and flying them to jails in a jail in Alice Springs. Is that part of the outcomes from the JPP? Because that's happened since
Senator,
the JPP.
that's not what I was saying. So, Senator, I was saying that the Justice Policy Partnership members have worked with the Commonwealth, and Ms Bogart can go into detail about the work that we did to establish the National Justice Reinvestment Program.
Doesn't touch that though. First Nations kids been put in shackles, put on planes and flown from Alice Springs to Darwin. That hasn't been, that's happened under the JPP, hasn't it? How do you explain that?
Senator, that hasn't happened under the JPP.
Yes, it has.
That is a decision for that government.
Yes, it has.
The National Justice Reinvestment Program has a number of...
Ms Harvey, it has absolutely happened under the JPP. It has absolutely happened under the JPP.
Yeah.
It's just getting to a point that there's a lack of respect for the professional's response. You know, Senator, you have a right to pursue this, but speaking over the witness is not appropriate.
Well, the witness start in an answer with an obvious.
I just want to respond to my point of order, Chair. I'm not in for a debate with Senator Shoebridge.
It's going to take forever.
If we need to take a private meeting to discuss this outside,
Thank
I'm happy to do that.
I would remind senators that in asking questions, it's absolutely respectful to let the officials answer the questions, even if it's not necessarily the answer that we want them to give.
Thank you.
So please proceed.
So, Senator, my answer was that the Justice Reinvestment Program that has been put in place, which was co-designed with the Justice Policy Partnership, which was really important, has a number, I think it's 12 or 13 of youth-focused sites, and that is designed to address those drivers of over-incarceration that we are all very familiar with. I also do take issue with suggesting that the Justice Policy Partnership on its watch saw the incidents that you spoke about. The Justice Policy Partnership is made up of officials and it is made up of Aboriginal community-controlled organisations and First Nations experts. None of us are lawmakers, Senator.
It is absolutely a fact. It is absolutely a fact that in the time frame in which this Justice Policy Partnership has been in place, the Northern Territory government has changed its policy and changed its laws, shut the youth detention centre in Alice Springs, and is now putting kids as young as 10 and 11 in shackles on commercial flights going from Alice Springs to Darwin. That has happened during the currency of the JPP. Secretary, you know that's true. The JPP has failed to stop it. You have no action in proposed to stop it. That's happened under this JPP.
Senator, the JPP is a justice...
Secretary, I'm just flagging. I'm going to rotate the call after this answer.
Okay. It's a Justice Policy Partnership. I think I acknowledge the concerns you're expressing about the experiences of individuals in the Northern Territory and elsewhere, but they are matters. What's happened in the Northern Territory reflects the policies and the posture of the Northern Territory government.
In the answer that you gave on notice, you said that there's work on the Justice Impact Assessment tool. When will that be operational?
Senator, the Justice Impact Operational Tool has been agreed by most jurisdictions now, and I'm just trying to recall if it went to Joint Council at the last meeting. My colleague might be able to assist me.
So it's out of session, going to Joint Council. However, jurisdictions in the meantime are able to implement that tool, including the Commonwealth, who has endorsed in implementation of that tool. It's important to make the distinction between the Cabinet impact assessment process that happens in most jurisdictions versus the impact assessment tool.
I'm only asking about the impact assessment tool.
Sorry?
I'm only asking about the impact assessment tool.
And that's what I'm giving you an answer in relation to, Senator.
So perhaps on notice you can provide which jurisdictions have it in operation, which jurisdictions have agreed to it, which jurisdictions haven't, and when you expect it to be on operational across the country.
Yes.
Can take that on notice.
What stage is the anti-racism tool at?
Sorry.
The this is the anti-racism tool for the justice system.
So the co-leads for that initiative have gone to market or are just about to go to market for the provider to develop that tool. I think that closes in January in terms of the procurement process, after which the process for developing it will commence.
So you've gone out to a private tender on it, is that right?
So, Senator, that work's being led by New South Wales and I think Snake, and they're out to procure that at the moment, or will shortly do so.
Where is the justice sector strengthening plan up to?
It's in development at the moment, so NATSLs is leading that process. They have sector strengthening specific recruitment that happened earlier in the year, so they've got a specific cohort of people doing the development of that.
And that's funded by the National Indigenous Australians Agency.
I'll be honest, I didn't understand what that meant, that answer meant. Just in, what does recruitment... What's actually happened?
So you asked for the status of it. NATSLs has recruited the personnel who will be developing that, who are developing that,
okay.
And that's in progress at the moment.
So there's been a recruitment to get people to start it?
The work
is,
right? The work is underway.
There's a recruitment,
with those people.
You've recruited people to get it started, is that right?
Can
you give me timelines? There must be some timelines somewhere for the actual implementation
Senator,
of any of these things.
we can provide you with timelines, but I think there's work across a range of streams. Ms Woods is trying to take you through that. It's not all led out of our department. NATSLs have a leadership role, other jurisdictions have a leadership role, and I can take on notice to provide you with more detail.
Senator, I'll add the sector strengthening plan is due mid to late 2026, so there is a time frame on that. NATSLs is leading that work.
I've almost given up hope here, but what about the cross-sector partnerships? Can you provide that on notice? The same information.
We can provide that on notice.
Yep.
Yeah. Thank you, Senator Shoebridge. Senator Scarr.
Don't give up hope, Senator Shoebridge. When there's life, there's hope. Okay.
Senator,
hope goes to die.
Senator, that's profoundly unfair, and the people who are sitting here and who are sitting back in the department work tirelessly on this issue, and it disrespects the First Nations communities that are working with us.
The abuse you're preventing. If you can point to any of that, then I'll have hope.
Senator Shoebridge is speaking over the Secretary of the Department, who is mounting a defence for her staff. It's inappropriate, and the defence is being mounted because of the behaviour
to talk about the Commonwealth actually stopping kids going into jail.
A private meeting, please, Chair.
10:51. Senator Scarr.
Thank you, Chair. I'll just give the witness an opportunity to come back, and just whilst you're settling it, I'm impressed. You've obviously done a lot of work in this, so congratulations to you and your team for your efforts. It's a very complicated area. So I just want to close out these questions on section 28 in this issue with respect to the recording of lessons. Why is the recording of lessons in their submissions, in terms of the submissions made by the rights holders, why is the recording of lessons such a sensitive issue?
So I'd go reiterate my previous answer that section 28 has always only applied to a live classroom setting. The reason that is the case is that the recording of a class, whether that be in a physical environment or an online environment, involves a copy of the performance being made, which engages the copyright holder's exclusive right to reproduction, which is generally remunerable under the Act. So permitting recording of the lessons under section 28 could potentially impact existing markets of rights holders, and those are the points that they made to us, not in submissions but sort of in various different forms of consultation we had with them on this section. So I think that and I would reiterate that the focus of this bill had been on clarifying aspects of section 28 that stakeholders could agree on, and recording of lessons was outside of that scope. So if further sort of consideration was to be given to expanding the scope of section 28 broader than it has been in the past, that would require careful consideration and analysis of the impacts of different industries.
Okay. Were there any submissions raised with respect to how the legitimate concerns of the rights holders could be accommodated? So, for example, just thinking it through, you've got a situation where perhaps not everyone can attend a class. Some people have to attend the class after it's been given for the first time. So to some extent you'd say, well, if 30 people are in the room for the same class, they're all part of that class, the lessons given at that time, what's the difference between that and say 20 of those 30 being in their class at the right time and then 10 attending the same class just subsequently? Was there any consideration given to some guardrails being constructed to deal with that issue? So the audience, if you like, for the seminar, the lesson, etc., was not expanded. It was just a question of timing.
Yeah, so I would just go back to my previous point that this bill and the amendments of section 28 are about those aspects of section 28 where there was consensus between stakeholders.
Okay. No need to. That's all right. Well, I won't require you to go through that again. If you've got anything else to add when I ask these questions, just anything else, that's fine.
So sorry, let me just round out that answer, Senator. So because that's what the focus of the bill had been on, no, we hadn't received any submissions about recording in that basis.
Okay. Did you seek any submissions in relation to that question?
Again, given the purpose of the bill, we were really focused on making sure that we were developing amendments where there was consensus, so that's where we focused our efforts.
In terms of this concept of reasonable diligence for orphan works searches, what does that mean?
Senator, I just note, I think the Chair indicated it was appropriate to answer questions around consultation process, but now we're getting into questions about specific provisions in the bill, which I think are a matter for the other committee.
Can I recast it? The question and take it back to submissions. Did you receive any submissions with respect to the concept of reasonable diligence in relation to searches for orphan works? And did you receive any submissions that perhaps suggested that the department should consider a more measurable standard, if you like, that was readily apparent as to what do I need to do in practice? Were there any submissions received in that regard?
So we didn't seek submissions specifically on the drafting of the orphan works proposal, so no.
Were any submissions received?
No. I'll take that on notice to double check, Senator, but I would say that in sort of our earlier discussions with stakeholders through sort of the roundtable process when we were talking about the breadth of orphan works, the general feedback that we received from people is that the orphan works scheme needed to be sufficiently flexible to enable it to apply to a broad range of potential uses of orphan works. And so part of the draft, the way that the bill has been drafted reflects that.
Okay. Can I ask you to take on notice, if you can provide, and just take this on notice, a full list of submissions that have been received or representations that have been received by the department for and against the proposed changes?
Sorry, Tara Inverarity, First Assistant Secretary, Courts, Tribunals and Commercial Division. Is that specifically relating to the orphan works proposals?
Correct.
Yep.
And also the proposed changes, Section 28.
So the bill as a whole?
Yep.
Yep.
So a full list of the submissions and also copies of the submissions, you take it on notice.
We'll take it on notice. Obviously, Ms Priestley has described a consultation process running several years, so we'll see what we can provide.
And has the department conducted, in terms of your consultation or in terms of your exploration of these issues, has the department conducted any economic modelling on the impact of expanded exceptions on small creators, authors and rights holders, particularly in cases where recorded lessons could substitute for purchased content? So,
again, because the bill was focused on areas where there was consensus, no, we haven't done any modelling on recorded lessons because that has not been part of the scope of the bill.
Okay, all right. Okay, thank you. Thank you.
Thank you, Senator Scarr. Now seems like a good time to, unless you've got a couple of minutes, questions you wanted to ask.
To stay on time, and I can put what I've got on notice because I'm conscious that.
Yep, I'm very happy to go to break for morning tea now, and we will resume at 11:15. Thank you very much. Sorry.
Coming back to Justice and Communities Group.
Yes, on the program we've got Justice and Communities Group and Closing the Gap Outcomes continuing.
Thank you very much.
Thank you. We'll return with the Justice and Communities Group and Closing the Gap outcomes, and I will call Senator Thorpe. Yep.
Thank you, Chair. Can you hear me okay?
Yep.
Great. Okay, got a few questions here. First one is around the recent meeting of the Attorney Generals and the fact that the SCAG finally released the Bail and Remand Reform Working Group's final report without endorsement. So with the AGD Act to implement any of its, will the AGD Act to implement any of its recommendations, particularly recommendation 1 and 2 around bail supports and alternative responder models, which would not require any significant state and territory legislative changes? Or is this just another report that will sit on someone's shelf and gather dust?
Thank you, Senator. I will ask my colleague, Ms Bogart, to go to your particular questions on those 2 recommendations from the report.
Thank you, Senator. Esther Bogart here. So the report made a range of recommendations which a lot of those came from best practice and evidence-based practice that's already in place. And so I can pleased to advise that the Commonwealth is already looking at or was already implementing some of those recommendations through its Justice Reinvestment program. So in regards to recommendation 1 around bail support services, at least one of the Justice Reinvestment initiatives is a bail support service. The Aboriginal Legal Service of WA Justice Reinvestment Program has a bail support element to it, so that's being implemented. Recommendation 2 around or alternative responder models. Around 5 of the Justice Reinvestment initiatives already funded are and alternative responder models. So we are implementing those, and we will continue to look and work with Justice Reinvestment initiatives around whether there's opportunities for more work to be done, but also speaking with states and territories. Several states and territories are putting in place those kinds of models, so working with them and encouraging their implementation where appropriate of those types of models. And I know that New South Wales and South Australia at least are providing those kinds of services, and we're tapping into those to see where we can join up, particularly with our justice reinvestment work.
Thank you. Could you name the 5 that you mentioned?
I might ask my colleague Ms Woods to name them. She has them here.
So Anandili royalties, so Groot, Niamala Cultural Leaders and Justice Group, Emanaguda Aboriginal Corporation, Aboriginal Males Healing Centre and the CJC Community Justice Centre. All of those 5 have alternative or co-responder models as part of their initiatives.
Thank you. The Attorney General has fobbed off to states and territories in terms of responsibility. Is it the department's position that every recommendation in this report is the responsibility of states and territories, despite the report explicitly identifying where the Commonwealth has direct responsibility and capacity to act?
Senator, there's 6 recommendations in that report, and the recommendations are made to all governments. There's 1 recommendation there around legislative change, and the vast majority of those recommendations are for states and territories. The Commonwealth doesn't have criminal justice systems in the same way. We, of course, have criminal laws, but the states and territories run criminal justice systems. However, there are 5 other recommendations there that we are looking at, both with states and territories, but also ourselves. So I've mentioned what we're doing in regards to recommendations 1 and 2. Recommendation 3 is around education or guidance material for bail decision makers. We have invested over recent years in a Aboriginal and Torres Strait Islander bench book, which is being developed to provide information, guidance, education to to judicial bail decision makers around decisions that should be considered. We have had a look at some very early drafts of that, and almost all of the issues that are highlighted through that report for bail decision makers to be considering will be covered by that bench book, and we're looking to ensure that it covers all of the issues that were raised.
So can I ask? Sorry, go.
No,
I'm just conscious of time. I'm sure there's a lot to say. And thank you for the extra information. But can I ask why the Commonwealth chose not to endorse the report?
Senator, the SCAG ministers collectively, that was the agreement that they came to. So ministers...
Yeah, but why? Why did the Commonwealth not endorse the report? I'm asking why.
So Senator, the Commonwealth, the Standing Council asked the working group to prepare the report. It went to SCAG, and that was the collective decision made by SCAG.
Yeah, you just said last. Need to know out there, because there's people dying, remember, and I know that you know that, because we've spoken about this through years of estimates, and I keep saying the same thing. I just need to know, and my people need to know, why? Why? We know what the decision is. Why was that decision made?
Senator, I think all we can do is repeat what Ms Harvey said. It goes to the collective decision-making in SCAG and the consensus that the report would be released for transparency, but that we would not move to formal endorsement.
So did they agree to disagree? Basically, because you couldn't reach consensus because we have some pretty racist governments out there at the moment. So was it about agreeing to disagree?
Senator, I wouldn't characterise it in that way, but there was an agreed position between all jurisdictions not to endorse.
So, Minister, will your government provide a formal response to the report's recommendations, or was the AG's press conference all we're going to get?
Oh, thank you, Senator. You'll appreciate this is not my portfolio area, so I shall ask that question of the Attorney-General and come back with a formal response to you.
Okay, thanks. And obviously a lot of work's gone into this. Blood, sweat, tears, even deaths. And obviously the torture continues amongst, against our children particularly. So this has gone on over a 9-month period, drafting the report. So what has the department communicated to NATSLs and other legal services who contributed to the report about what the federal government intends to do?
Senator, we've provided the final report and the SCAG communique to the working group to let them know of the decision. But we do continue to work with NATSLs. We work very closely in partnership with NATSLs on an almost daily basis. We're speaking to them and the Justice Policy Partnership as well. And we will continue to communicate what we are doing, and I think it's reasonably well known by those groups, the work that the Commonwealth is doing on justice reinvestment, on the bench book. The other thing I didn't mention was there's also initial or early work being done between the Justice Policy Partnership and the Data Policy Partnership, which will go to recommendation 6 of that report. So throughout the working group. There were 8 meetings of the working group, and we all spoke about things we were already doing. So I think it's reasonably well known in the group what's being done by the Commonwealth in relation to that report.
Yes, I'm hearing otherwise, but you've been trained to provide responses like that. There's the bureaucracy that unfortunately has to back up the government in their dirty work. So I'm happy to hand it over at this point.
Thank you, Senator Thorpe. Senator Shoebridge.
Thanks, Chair. Secretary, the department has previously indicated to stakeholders that you've received a copy of the expert legal advice obtained by NatSols and the Justice and Equity Centre about the Commonwealth's legislative capacity to raise the age across the country and put in place minimum standards for youth justice.
Senator, yeah, I acknowledged at the last estimates that the department had received the advice and that I had read it. Yes.
And you've indicated to stakeholders that the department has reviewed the advice and is preparing a brief to the Attorney General. Is that accurate?
I think, yes, that is accurate.
Yes, Senator, we have provided some advice to the Attorney General.
All right. And when was that advice provided to the AG?
I don't have the precise date on me, Senator, but it was during November.
During November. And does the department support the view contained in that expert legal advice that the government has the power to raise the age of criminal responsibility to 14 years and create minimum standards for the treatment of children and young people across Australia? Is that
Senator, the department won't provide information about its about legal advice.
Well, Minister, one of the key issues that is constantly faced in this space is the Commonwealth saying it's not their job to deal with the criminal justice system, even if it's creating untold amounts of violence against particularly First Nations youth, but kids across the country. Do you think that the government should tell the Australian people whether or not the Commonwealth thinks it has the power to make these changes? Do you think just that transparency would be good?
Well, we do have an Australian constitution that does define areas of responsibility, Senator Shoebridge, and the government does try and honour the boundaries of federal and state laws. I think in the answer to an earlier question in the day, I made it clear that the government doesn't want to see increased levels of youth detention. We don't want to see increased levels of youth crime. If these problems were easy to solve, then some other government would have done them. They're not easy. But in Michelle Rowland, you have an Attorney General who wants to take action. I've said this a few times to you in questions in question time, Senator Shoebridge. We're an action government. We see a problem, we like to fix it. We do it within the bounds of our constitutional responsibilities. 2 years ago, we tried to get a voice to Parliament so that Indigenous Australians would have an opportunity to talk directly with the federal Parliament. We failed to do that. Unfortunately, particularly in this space, change isn't always easy, Senator Shoebridge, but can I assure you that in Michelle Rowland you have an activist Attorney General, and where she is able to help out in these issues, that's exactly what she'll do.
Well, the good news is, Minister, this advice provided by two of the leading silks, I think one at least was a King's Counsel. If you want to be an action government, it's told you what you can do. The advice was that the Australian government can make a law that a child or young person can only be arrested as a last resort when there's no other option and for as short a period of time as possible. They've said you can pass that law. An action government would pass that law, wouldn't they?
If you want to provide me with that legal advice, Senator Shoebridge, I will happily forward it to the Attorney-General.
But you see, Minister, the Attorney-General's already got the advice. And the question is, I've been put into the department, is you've got the advice that your government, if it wants to take action, can do that. The advice also says that the Australian government can pass a law that forbids any child or young person being held in solitary confinement. You could pass a law to prohibit spit-hoods being put on kids in the Northern Territory. That's what the advice says you could do. The question I'm asking you, but perhaps you could take to the Attorney-General, is do you accept the advice that the Commonwealth has the capacity to do these things? And if you do, why aren't you?
Well, as I said, we respect the boundaries of the Constitution, and if the Attorney has got that advice, I shall ask her what her view is in respect of that advice, and I'll come back to you with an answer, Senator Shoebridge.
Thanks, Minister. I appreciate that. I was going to move on to copyright briefly, and not schools and lessons, you'd be pleased to know, but more in the sort of large language model space.
We'll just get the relevant officers to the table.
Secretary, it won't come as a surprise to you that particularly creatives, novelists, artists, First Nations communities have been deeply, deeply disturbed that their works are being basically stolen and fed into large language models, and they don't seem to have any remedies. You'd be aware of those concerns?
I'm aware that you spoke to them at our last estimates, and obviously through all the extensive consultation that the team have been doing, particularly through the copyright and AI reference group, the KEG, and a range of issues, particularly from creatives, about the impact of AI have been raised.
But Minister, Secretary, rather than spend like 15 minutes teasing through fairly lengthy answers, can I see if you can agree that creatives, novelists, artists, First Nations knowledge holders are deeply anxious about their work, their community's work, their cultural assets being fed into large language models and them losing control and losing power over them? Do you accept that that's a thing?
Senator, I accept that they have engaged with us and raised a range of issues.
Okay. You advised in responses to questions from the last round of estimates that as at the 17th of October 2025, the department is not aware of any court cases in Australia about the use of copyright materials in the development of artificial intelligence tools. Do you accept that that means the current copyright regime is not working to protect people's rights?
Do you want to take it? Okay. No, I don't think we would accept that assertion.
All right. So, Ms. Inverarity, are you aware of creatives, novelists, artists, amongst many other people, being concerned about their works being fed into large language models, them getting no recompense, and then their works being used to provide profits for the owners of large language models? Are you aware of those concerns?
We're aware that the growth of AI raises policy issues that affect many sectors, and yes, we're aware of media reporting in particular about the concerns of the creative sector.
And we have copyright laws that are meant to protect people's copyright, correct? They're meant to protect people's copyright, their ownership over the works. That's what copyright's meant to do?
The copyright regime is intended to protect certain acts from being engaged in with copyright works without the copyright owner's permission, but also sort of fairly balancing use and access to that copyright material in the public interest.
And Ms. Priestley, you know, I heard your detailed answers earlier. I won't traverse over those answers you gave, but one of the one of the responses we've heard from the government is that our copyright laws already protect creatives and others from having their work taken from them without their consent and fed into large language models and then used without their consent in large language models. Do our copyright laws protect people from that?
So within Australia, yes, generally permission is required from the copyright owner to use their copyright material in certain ways.
And does that
acts
include
occurring in Australia?
Yep. Does that include being fed into a large language model and then used to generate content? Does that include that?
If that's occurring in Australia, yes.
Yeah. So Secretary, if that is the case, how is it that there isn't a single case, not one that you can identify, where artists, creatives and others have turned to the law to protect those rights, to seek recompense? How is that the case?
Senator, there's a range of reasons as to whether or not people seek to take action. I think it's impossible to give one single answer for that.
And I think the other thing we might just say is, as Ms Priestley has referred to a couple of times, the Copyright Act applies to acts undertaken within Australia. So there's also jurisdictional questions.
Yeah, we'll come back to this.
Thank you, Senator Shoebridge. Senator Black.
Thank you very much, Chair. If we can just move, and I realise this is a bill, and again, we will go through more, I guess, the consultation that happened, but the Crimes Amendment Mandatory Minimum Sentences for Child Sexual Abuse Bill 2025.
Senator, that's the responsibility of the next group, the Integrity and Security Group. So the officers that are responsible for that will be able to assist in the next session.
Okay, so you guys had nothing to do with any of the consultation for that?
Not the people that are here now.
Okay, no problem. That makes that line of questioning very short. Did you have anything further you wanted to go through, Senator Scarr, with yours, or were you satisfied?
Where would we, Secretary, where would we ask questions in relation to constitutional law issues?
That is in, excuse me, the next section.
It's the next section
Integrity
too.
and Security
Okay,
Group.
that's fine. Thanks.
Excellent. All right. Senator Cox.
Thank you very much, Chair. Can I ask some questions around the National Access to Justice Partnership?
Yes, Senator. I'll just get some more colleagues up.
Yeah, thank you, Ms Harvey. And recently, the government made a record investment of $3.9 billion over the next 5 years in relation to legal assistance. Can you walk us through how the National Access to Justice Partnership funding is helping victims of family and domestic violence achieve justice?
Thank you for your question, Senator. Elena Mitchell, Assistant Secretary, Legal Assistance Branch. The National Access to Justice Partnership assists in the response to gender-based violence through a range of features. So first of all, there's a new quarantined funding stream under the agreement that brings family violence prevention and legal services into the agreement. And that's in recognition that Aboriginal and Torres Strait Islander women and children are disproportionately impacted by gender-based violence. That subsector has received an increase of 112% from the last year of funding that was provided by NIAA through the Indigenous Advancement Strategy. The second feature I would mention is there's a new quarantine funding stream for women's legal services. That's to ensure that women and children have access to legal and other support services to help them escape violent situations. That funding, there's been a 74% increase in funding provided to women's legal services, including to community legal centres, since the last year of the NLAP, the National Legal Assistance Partnership Agreement.
Excellent.
I can add a couple of other things if you like. There's also dedicated funding to peak bodies supporting both of those subsectors, which aims to support and build providers' capacity to deliver effective and targeted services. And there's also just a broad uplift to providers across the whole sector. So that's legal aid commission, community legal centres and ATSLs as well, in recognition of the services that they provide to people experiencing or at risk of gender-based violence.
Great, thank you very much. Can you, the Family Violence Prevention Legal Services play a very, very important role, and I'm glad to see that that funding moved from NIAA into your department has had an increase. Can you tell us or tell those listening out there what are some of the range of supports that Family Violence Prevention Legal Services provide?
Senator, the Family Violence and Prevention Legal Services range around the country. There's 16 providers nationally. And the funding has continued to support all of those 16 providers with the uplift funding that will be distributed by states and territories. Family Violence Prevention and Legal Services provide a range of services to First Nations women and children. They provide both legal representation and support services, as well as more holistic wraparound services to support those women and children who are experiencing or at risk of experiencing family and domestic violence to address other non-legal problems that they're having in their lives.
Thank you very much, Ms Bogart. I know that the Aboriginal Family Law Service in my home state of Western Australia do an amazing job, but can you articulate a bit more of the detail around how this investment is absolutely going to the heart of what First Nations communities are experiencing, and how this particular funding is hoping to address family violence in their communities?
Senator, I'll see if we've got some information on the increase for that particular service. I don't have specific data yet, so the reporting that demonstrates the different services and different impact that they are having isn't due until the start of next year, so we don't have a lot in front of us. We know what those services do and the important role that they play, but in terms of giving you a breakdown of information about the exact impact for that service and services more broadly, I just don't have that data.
I was just giving a shout out to them because I think that they're amazing, Ms Bogart, but I'm happy for you to talk more broadly about the services themselves and the investment that our government are making and what that does to address family violence in our communities.
So, Senator, do you want me to talk about the services in particular or the WA service?
No, just more broadly.
And again, because they've only recently come into the Attorney General's Department, I don't have the kind of robust data around the types of services and the percentages and things like that they provide. I've had a long history of working with FVPLSs in different ways because they've always been part of the sector, but they have only come into this department from the 1st of July, where we're establishing strong working relationships with them. I will say, as I mentioned earlier, they provide legal services as well as non-legal services that might help manage family law issues, family violence issues, where children are at risk of child protection or being taken into child protection. They represent women and their families to prevent children being removed from their families, as well as providing that more holistic support around helping them with housing, tenancy, health and other services like that. And several of them are also delivering other kind of broader programs. We have at least one that's providing a justice reinvestment program. I know some of them are involved in the sexual violence pilots that were mentioned earlier. So they do have a really diverse spread and range of the work that they do.
Yeah, I was with the Attorney General in Bunbury a few weeks ago and visited with her, talking to our legal services. So I know her interest in this area and I look forward to getting a further update at the next estimates. Thank you, Ms Bogart.
Happy to do so, Senator.
Thank you, Senator Cox. Senator Thorpe.
Thank you. What a lovely Dorothy Dixer exchange that was. It seems like everything's rosy on the blackfella front in this country.
It's important to get some things on the record.
Our times have changed.
Great work.
So my question is around deaths in custody, which would be nice to see Labor move on, especially those that have spoken previously used to protest for this. We've been advised that the Minister is looking at further steps to implement the Royal Commission into Aboriginal Deaths in Custody recommendations. So can I ask, has the Attorney-General's Department prepared any advice or doing any work on implementing those recommendations?
Thanks, Senator. We'll work our way through. Obviously, the recommendations of that Royal Commission are now 30 years. And
34 to be correct.
34. And there has been a lot of work across a range of recommendations, both at the Commonwealth and state level. I think in terms of current initiatives working with the states and the territories around deaths in custody, I might just see if my colleagues have anything they want to add to that.
Thank you, Senator. AGD, so Attorney General's Department's responsible for 23 of the recommendations of Ricky Dick. In 2018, Deloitte Review assessed 17 as being fully implemented. So 5 recommendations, mostly complete and 1 partially complete. So I would say that's pretty indicative in terms of the progress towards implementation for those that our department is responsible for.
Yeah, sorry. The Deloitte's, just to bring back the Deloitte's desktop review that never, ever went to any community, any family. They did a desktop review. So we need to not even consider the Deloitte's waste of time and resources and taxpayer monies on that gammon review because it didn't talk to anybody. So the federal government need to not use that as a win or any guide. 23 recommendations you say you're responsible for. What recommendations are being considered now to save people's lives?
Senator, in addition to what Ms Wood said, I think it's important to note that really the central recommendation of that Royal Commission was that if you reduce incarceration rates of Aboriginal and Torres Strait Islander people, you reduce deaths in custody. So we are very focused on the work around reducing incarceration rates and taking practical measures, which we've talked about. What we can do within the Commonwealth's levers, so investing in the Justice Reinvestment projects. A lot of that goes to recommendations around early intervention, prevention, stopping people from having contact with the justice system in the first place. We have invested, the government has increased its investment in Aboriginal legal services, which is a specific recommendation of the Royal Commission.
Thank you.
With $3.9 billion in the recent NAJP, as well as the Custody Notification Service. And I will note, Senator, that was a recommendation in the recent NAJP that has now provided specific funding to every jurisdiction, every ATSLs, to run
Can I ask an additional
Custody
question
Notification Service.
To that, please? Why under Labor has there been more incarceration of Aboriginal people than ever before under this government? Can you tell me, it sounds lovely what you're doing and you're still referring to the Deloitte review, which is a bit of a shame, and you're pouring money in, but there's been more incarcerated black people in this country than ever before under Labor, particularly Aboriginal women. And are you considering hanging points and getting rid of hanging points in this country, because we know that in one prison, and yes, you can throw to the state and territory responsibility, but we saw also through a report that the feds have the power to do something about that also.
Senator, I might start with the first question, and you're right. States and territories, the incarceration rates are the Productivity Commission under the Closing the Gap national agreement. They do measure the rates against those targets, 10 and 11, and it is broken down by state and territory. And the most recent dashboard does show that for adult incarceration, it is worsening. It is improving in one jurisdiction and no change in another. For youth, there's actually 3 jurisdictions, and I know this isn't good news, 3 jurisdictions have worsening rates, but actually 3 jurisdictions have improving rates for youth incarceration and 2 have no change. So we go off the stats that the Productivity Commission produces in terms of those targets of incarceration rates. And I know it's not a good news story across the country, but it's not. Some are improving and jurisdictions are working jurisdictionally and with the Commonwealth to look at ways to improve those rates. On hanging points, that does sit with the Minister for Health, and I know that the Minister for Health and Disability and Ageing wrote to state and territory health ministers in June 2024 about actions taken in their jurisdictions to remove hanging points in line with recommendation 165. We speak with our health colleagues on a regular basis. They are best placed to answer questions about the responses, but it is something that at the Commonwealth level in the portfolio responsible for that issue. So conditions in detention sit with the Department of Health, and they are actively pursuing that line of questioning with states and territories.
It's not my frustration. I mean, it's part of my frustration, but you're talking to families out there who are dealing with this. So whilst, we can all go home to privileged little environments, there are real families and people that are relying on every word you are saying. My next question is around the anti-racism framework, and given that the Parliament is a racist workplace, and we saw that with the racist senator in the chamber not so long ago. Can I ask what your department has carried on and why there's been no response to stopping the racism in Parliament, even though the Race Discrimination Commissioner has asked the Parliament to deal with this issue that is violent? What's your department doing about that?
Senator, in terms of parliamentary workplace issues, the department doesn't have a direct role. I think it's a matter of directing those questions either to the President or the Speaker of the Parliament. In terms of work, this team here is not directly responsible. Our Human Rights branch are responsible for working through the recommendations of the Race Discrimination Commissioner around the anti-racism framework. He provided that report, and it's a matter for not just this department but a range of departments to work through responding to his recommendations, and he will be appearing later today when the Human Rights Commission appears.
Okay, thanks for not much at all.
Thank you, Senator Thorpe. Senator Shoebridge.
Oh, thanks, Chair. I was trying to get through the rest of these copyright questions. Secretary, once content is put into a large language model, there's no current remedy for copyright owners to have it removed in Australia. Is the government progressing changes to put in remedies to allow content to be extracted?
Senator, I'll ask Ms Priestley to talk to that issue.
The department is currently consulting with the reference group on 3 priority areas. One of those includes improved enforcement and issues related to enforcement. And that's potentially something that copyright stakeholders could raise through that process.
All right. Well, one of the proposals is that's been floated is a new paid collective licensing framework as against voluntary arrangements for AI use of copyrighted material. Is that being discussed with stakeholders?
That's, yes, one of the issues being consulted on.
And what criteria are being proposed to decide between establishing those two alternatives, paid collective licensing framework versus voluntary arrangements?
So we've asked for stakeholder views about the status quo, so voluntary arrangements and how those are working, and if they think there is a case for the government to make changes towards a sort of statutory licence framework.
So is the government's response going to be informed by what stakeholders are telling about whether or not the current voluntary arrangements are working?
That will inform our advice to government.
Minister, do you accept on behalf of the government that the current voluntary arrangements for AI use of copyright material is not working for most creatives?
Look, I, strangely enough, have had some interesting conversations with some very famous Australian authors in recent times, including Tom Keneally in advance of his 90th birthday party.
We're going to upload Tom, are we?
Hey?
We're going to upload Tom, are we? Is that the plan?
Well, that's the $64 question, I suppose. Look, I am aware that, people like Tom and Australian authors and other creatives are, deeply interested in this issue. I get the impression, talking with him and others, that they are happy so far with the way in which the government is progressing this issue. Obviously, it's an issue for the Attorney General. It's an issue for the Arts Minister. You might have noticed during the week the government took a decision to increase Australian content in streaming services from overseas streamers in this country. We are very focused as a government on ensuring that Australian voices continue to be heard in this country, and that we protect the creative product of our journalists, of our authors and other creatives. So, just from my own point of view, these are neither of these are policy issues that I'm directly responsible for, but I think the government is heading in the right direction here, Senator Shoebridge. We are seeking to ensure that Australian voices continue to be heard, and both the Attorney General and the Arts Minister will continue to do that.
Well, Minister, your impression of your discussion with Tom Keneally is that he's satisfied. He's described the approach of AI and large language models through taking Australian copyright material, including his. His description of it was a form of economic terrorism. I don't think he's very happy. That's my reading of it, seeing it as a form of economic terrorism. I wouldn't read that as happy.
I don't disagree with his categorisation of what potentially happens here. All I can do, Senator Shoebridge, is report on my conversations with him, and I hope I'm accurately recounting what he has said to me. I know he's directly had conversations with the Arts Minister on this very topic. I haven't seen any recent public report on anything he said publicly, and I hope he doesn't mind me talking about our private conversations in Senate estimates hearings. But I would have to say he seemed to me that to be pleased with the discussions and the conversations that he's having with the Australian government.
Sorry, Chair. I could put the other questions on copyright on notice, but when
12 o'clock, which is lunchtime.
does the government have a timeline for when final decisions on the 3 focus areas currently be considered by the reference group will have an answer, a public answer?
What we can say is that we've asked for submissions from the members of the reference group by the 11th of December, and then we'll consider, we don't have a specific time frame by which we will provide views to government.
Okay. Thank you very much. It being lunchtime, we will now break for 45 minutes, return at 12:45, and we will be returning with the Justice and Communities Group and closing the gap. 4 people in the room. Thank you very much. broadcasting. And we are returning with the Justice and Communities Group closing the gap outcomes, and we will return to Senator Shoebridge.
Thanks very much, Chair. I'm going to move on to two issues that sort of intersperse. One is court transcripts and the other one is the Judicial Commission. Secretary, last time I asked about progress on a Judicial Commission, and the department's response indicated that beyond the task force scoping which finished in May 2024, I quote, the department has provided briefing to the current and former Attorney-General on multiple occasions. When are we going to get a Judicial Commission?
Thank you, Senator. I think Ms Harvey's poised to answer this, so I'll defer to her.
Senator, you're right in that the task force did provide its advice to government, and the timing of a Judicial Commission or whether one's taken forward is a matter for government.
So since May 2024, when has the department briefed the current Attorney-General?
So the current Attorney-General was appointed, I think, in June this year. And I think we have briefed her on 2 or 3 occasions. I don't have the dates in front of me. I think possibly early on when we did a range of briefings to the Attorney-General. I think we did, from memory, we did one on the Judicial Commission at that point. And there has been at least one written submission as well. But I don't have the dates in front of me, Senator, but
can you provide
there has been engagement on a couple of occasions around the Judicial
I don't have the precise date, but the written advice was provided in November.
In November, okay. And that was written advice following the task force? Was it departmental advice or was it advice that came out of the task force?
So it was advice from the department, but the task force was part of the department, and then folded back into the branch that Mr. Demamior leads.
Is Minister, are you aware whether or not your government is committed to delivering a Judicial Commission?
You'll be happy about this, Senator Shoebridge. I won't have to take that question on notice,
Minister, I'm sitting here with bated breath.
Or refer it to the Attorney-General. She's given me a response, and she says that she's giving careful consideration to a federal Judicial Commission.
Well, Minister, I think that's cleared things up absolutely. So, careful response.
Was that a happy response from you, or?
Well, I can't say it was overfull of information or providing the public of Australia with too much information about where you are on Judicial Commission. You haven't overshared, Minister, is probably how I would respond to that.
Is that as
KPI.
Is that as good as it gets? With
You're not oversharing.
Senator Shoebridge, is that the most I can ever expect? By way of a sort of compliment.
And I reflect that question back to you, Minister.
Please, everyone. You should know this.
If you're asking me,
some of the time
if you're asking me, is that as good as it gets? If you're asking me if that's as good as it gets, I'll take that question on notice and I'll get back to you in due course, Minister.
All right.
Yep.
I get it.
So is there a political commitment to deliver a Judicial Commission from the government, not the Attorney?
Well, the Attorney, in her portfolio areas, the Attorney speaks for the government, and I'll repeat her answer.
Oh, you don't need to, Minister.
Sure.
Secretary, you would be aware of very real concerns amongst the legal profession and amongst litigants in federal courts at the prohibitive costs of court transcripts for federal proceedings, in the order of $3,000 to $5,000 per day. Are you aware of those concerns?
Senator, yes. Obviously, in terms of ongoing engagement with the courts around issues with transcription services, but also some of the media coverage in recent days in particular.
well, very real concerns that there's an overseas corporate provider called VIQ Solutions or VIC Solutions that seems to have very low quality standards compared to previous Auscript standards when it was publicly run. You aware of those concerns?
That hadn't been drawn to my attention through the court or through other stakeholder engagement, but again, I think that was implicit in the reporting last week.
Is your government... Sorry, I'll start again. Is there a set of policy settings inside the department that endorses privatised court transcription services for our public courts?
So, Senator, I wouldn't say that. No, obviously, the provision of transcription services is very much a responsibility of each of the courts, and they are responsible for decision making about who is providing it and working with their providers to ensure quality of transcription.
All right, we'll come back to this.
Thank you, Senator Shoebridge. Senator Blythe.
Thank you very much, Chair. I just wanted to touch on areas around child protection and checks in relation to what your department undertakes. And I'm just wanting to find out if the department has provided a brief to the Minister on the use of technology in the identification of perpetrators.
No, maybe not. I'm just trying to identify whether there is a particular angle for the department in terms of child protection services, their state and territory responsibilities.
Yep.
Of course, you will have heard earlier on the work that we're doing around the working with children checks piece. But otherwise, in relation to the child protection system, that is not something that we have direct responsibility for.
So in the working with children checks, is that something that the department has provided advice on in using the use of AI to strengthen those checks?
I would need to...
So, Senator, we've been doing a range of work on working with children checks, in part to set up a national continuous checking capability, which would be run for the Australian Criminal... I can never remember ACIC. Thank you, Intelligence Commission. I don't have any information before me that suggests that will be using AI to do those checks, but it will be a system, an IT system that's established. So exactly what that looks like, I'm sorry, I don't have the details.
Okay.
ACIC may be able to expand on that, but certainly nothing around
and I guess the question was more around whether your department has suggested or recommended that AI be used in strengthening those checks. That's not something you've provided advice on?
Senator, I won't give a definitive answer to that. In the next section, the integrity and security, the team that's responsible for the working with children checks work. Oh no, it's in this section. Sorry, yes.
I was going to say this section. This is this section. Yeah.
They may be able to. Do you want to come to? Because it's just, sorry for the hesitance, but there's a range of perspectives around the use of AI and child sexual abuse material, but I think you're coming at it from the angle of being able to identify perpetrators. Is that where you're coming from?
So in perpetrators, so in terms of the checks that you are doing in those, what did you say, 6 million working with children checks, whether you've made any recommendations of the use of AI in strengthening those checks, or as you're doing those reforms, has AI come up as a recommendation? It doesn't sound like...
So Senator, AI isn't one of the recommendations that were put to SCAG, for example.
Okay.
But as I said, the Australian Criminal Intelligence Commission will be building the national continuous capability. So questions to them might
go more to that, but there's certainly nothing, I'm looking at my colleagues here, but nothing in the particular work we've been leading with SCAG that we can point to around AI.
So I guess to go to that, where there are products in Australia that are not lawfully able to be used, has your department provided any advice in what law changes or legislative changes would need to be made to allow for the use of AI by other departments for this?
In the context of doing child protection, worker screening for child protection, I don't know that that's specifically been raised, and whether or not there could be a range of issues to work through. They could be legal framework issues, they could be system capability issues. So I think what I would say is perhaps we take it on notice to the extent that we've had any sort of engagement on that issue. Certainly there could be experience in the state and territory agencies where they have their own systems. I think as a general proposition, we would be interested in exploring any option that enabled more accurate and faster checking, but ultimately the system that we're responsible for developing is the Australian Criminal Intelligence Commission. They'll be appearing tomorrow in the Home Affairs portfolio, and obviously we can put them on notice that you may have questions about that.
That would be very helpful. Thank you. Thank you.
Thank you, Senator Bice. Senator Cox.
Thank you. Can I ask some questions around the automated decision-making project, if possible?
I'll just get some different people.
Can you provide the committee with an update on where the automated decision-making project is up to that would implement recommendations 17.1 and 17.2 of the Royal Commission into Robo-Debt Scheme, please?
Thank you. Yes, the department continues to lead the development of a consistent framework for the use of automated decision-making in the delivery of government services, as you note, responsive to two of the recommendations of the Robo-Debt Royal Commission. I think one of the key features of this project, which has unfolded over a number of years, has been extensive consultation with quite a large range of Commonwealth departments and agencies in particular, given the complexity of the legislative picture in relation to automated decision-making. So we are still intensively engaging with relevant departments and agencies in the development of advice to government to support decision-making about the framework, and we hope to be in a position to brief government on that soon.
That's great. Just in relation to the consultation, what does that look like? Are we talking that in the form of external stakeholders, government stakeholders? I know you touched on it in your answer. Are you able to expand on talking to us about where they're from, or without, maybe not going into the naming the individuals, but just a broad range, I think, of stakeholders, both external and government stakeholders that you've been talking to?
Certainly. Key government stakeholders probably won't surprise you. Services Australia and the Department of Social Services are key partners in this. The Australian Taxation Office, Department of Finance, the Treasury, Prime Minister and Cabinet, the Department of Employment and Workplace Relations are all key to government consultation. I might ask Mr Still to give some details as well of the public consultation that was undertaken to inform this work.
Thanks, Stephen Still, Assistant Secretary, Administrative Law Branch. So a public consultation process was undertaken to inform the development of the framework between the 13th of November 2024 and the 15th of January. That went through a range of channels to seek feedback. There was a public consultation paper released, an online survey that was potentially anonymous, and a range of stakeholder roundtables and bilateral discussions. In response to that public consultation, the department received 41 submissions, and the survey received 20 responses. Many of those submissions have been published, and a summary of the outcomes of the consultation process, including the key themes that were identified, have been published on the AGD website.
That's great, thank you. What are some of the safeguards in the proposed legislative framework that the department has considered as part of this work? If you could tell us that in a bit more detail.
I think it's a little premature to discuss what the content of a possible legislative framework might be, but I think what we can speak to is some of the themes that came out of the consultation, and obviously building on the themes considered by the Royal Commission as well. And again, there's no real surprises in here. The key themes that we are looking to ensure are addressed in any options that are presented to government are transparency about the use of automated decision-making, fairness and accountability, and also consistency across government in how automated decision-making can be used. And obviously from the Royal Commission recommendations, oversight is another key aspect that we're looking at in terms of how automated decision-making practices can be appropriately oversighted by relevant agencies.
That's great. I think as the Chair of the Community Affairs Committee in Legislation and our recent passing of those laws in relation to apportionment, it's good to see that the department is doing some work around this, as this was one of the issues that were raised during our time in committee hearings. So thank you for the update, and I look forward to future work in this. Thank you, Chair.
Thank you, Senator Cox. Senator Shoebridge.
Thanks very much, Chair. Secretary, going back to the issue of transcripts, does the government have a policy about access to justice? I mean, is that a policy position that you're trying to deliver as the Secretary, that people should have as greater access to justice as possible?
They're obviously across the breadth of our responsibilities for the federal courts, for legal assistance, for a range of other frameworks that support the operation of the courts. There is a thread of ensuring access to that justice system. But there's no one single policy that captures that. But I would say that is the overarching purpose of much of what we do in support of the justice system is to enable access.
So how is it that litigants in the Federal Circuit and Family Court can only get access to the audio recording of proceedings in exceptional circumstances and only if a judge orders it, even though that might be absolutely critical for them doing submissions, considering an appeal, challenging interlocutory decisions? What's the exceptional circumstances test about that?
Senator, I think in terms of the provision of services, we've always worked with the courts, but it's primarily the responsibility of the courts. If there are ongoing issues around the quality of transcription services, I think that is, I suspect you will probably raise it with the courts later today, and we will, in our usual way, engage with them to look at the general issue of both the quality and availability of transcription services.
Well, I mean, of course courts have their own autonomy and need their own autonomy, but the government also has a quite legitimate interest in ensuring that litigants before the courts, the Australian public, have access to justice. I mean, that's a quite legitimate concern for the Parliament and the Executive, isn't it?
Yes, it is.
Yeah. So we have courts that have privatised their transcription service, and in this case, the Federal Circuit and Family Court. They've privatised their transcription service. That private entity is charging litigants $2,000 or $3,000, $4,000 or $5,000 a day for transcripts, and then the court is protecting that business model by refusing to give litigants access to the audio transcripts. That's a problem, isn't it? It's a political problem as much as it's a justice problem.
I won't comment on whether it's a political or otherwise problem, but I think obviously you'll have the opportunity to raise that with the FCFCOA when they appear later today, and in the course of our ongoing engagement with them, I think we will discuss that further.
Well, I mean, have the courts been frank with you in those engagements? Have they pointed out what we've seen reported just in the last few days, that transcripts attribute dialogue to the wrong person, name the wrong legal practitioners, contain an abundance of typographical errors, and in one case had 2 hours of proceedings missing entirely? Have the courts been frank with you about the problems they're having?
That level of detail is, when I saw that article last week, that's the first time I've heard those specific issues raised. But I'll just check if any of my colleagues have anything to add on to that.
Senator, I don't have anything to add in terms of the conversations, other than to say transcription, I guess, in general is a conversation that we've had from time to time, but not with those issues that you're raising there. And it's certainly something that we'll be taking up with our colleagues in the regular discussions that we have around the courts.
Well, Minister, I mean, this is the lurk of all lurks, isn't it? From a private company based in North America, which has got a monopoly on providing court transcripts for the Federal Circuit and Family Court, and charging $3,000 to $5,000 a day for a page of transcripts, when it looks like they're just running it through an AI model at probably close to zero cost, and churning out error-laden transcripts. I mean, you can't be satisfied with that, can you?
I can't what?
You can't be satisfied with that, can you? Some North American company charging people in Australia $3,000 to $5,000 for a day of transcript that's riddled with errors and no doubt produced just feeding it into an AI.
Well, one of the features of the free trade agreement between Australia and the United States is that American companies are entitled to bid for the supply of services in Australia, and I imagine, and I don't know this for sure, that at some point in time they've bid for this particular service, just as under our free trade agreement, Australian companies can bid for services to be provided into the United States.
Minister, I think this entity is based in Ontario. It's got a big footprint in Phoenix, big chunk in Sydney, but I think its headquarters is in Ontario.
Ontario, okay.
And I just,
well, we also have a free trade agreement with...
Question.
Sorry?
I thought you were describing it as an American company.
I think I said North American. Yep.
Yes, you could have said North American, and I just assumed that was the United States. But can I say this? My answer is still the same. We have a free trade agreement with Canada. Not the Europeans yet, Senator Scarr, but we're not very far away.
It all comes back to trade. It all comes back to trade. Free trade agreements are right, but all well and good. But
no.
This... Oh, sorry, Minister, you go.
Look, I'm giving you a serious response there because, you know, we take our obligations under our free trade agreements seriously, and if a contract at some stage went out and this company was successful in getting the contract, well, so be it. But I don't know enough about the particulars of this arrangement, Senator Shoebridge, and I don't want to mislead you in any way or give you the wrong advice. I shall consult with the Attorney-General, and as I always do, I'll come back with a formal response from her about this issue.
And Minister, in seeking that response from the Attorney-General, can you ask if the Attorney-General will raise with the federal courts the barrier to providing audio transcripts to litigants? And as I think I put in a question to the Secretary, the current barrier in the Federal Circuit and Family Court is that the audio recordings will only be provided in exceptional circumstances.
I shall provide the Minister with a copy of your questions and ask her to respond.
Thanks, Minister. Secretary, one of the other concerns that's been raised is judges editing the transcript, taking chunks out, having unsupervised editing of transcripts. That obviously raises concerns for litigants, very real concerns for litigants. Do you have any response to those concerns about judges having unsupervised editing rights of transcript?
So, Senator, I did focus on that when I read that article, and I think it would be interesting to understand that issue better and understand the circumstances around that. So I think that is something that I would like to engage with the court on.
All right. Will you... I began this line of questioning in the context of a judicial commission. Obviously, if there was a federal judicial commission in place and people had a concern about a judge allegedly inappropriately editing the transcript, that would provide a venue, wouldn't it, to resolve complaints against a judge. And for those judges who have been acting well and haven't done anything wrong, the matter would be resolved and there would be certainty. And for any judges who've been acting badly, there'd actually be some accountability.
That is potentially one of the advantages of having a federal judicial commission. I think what I would note that if there were any particular concerns currently, it is of course open to those involved in the matter to raise it with the Chief Justice of the relevant court.
But lawyers around the country have been raising this for years. I think the Law Council of Australia highlighted the problem with costs of transcript and access as far back as 2018 in their Justice Project report in 2018. And it's got more expensive since. So it's not going to be resolved by lawyers raising it with the jurisdictions.
Sorry, Senator, I was responding specifically to the point you made about judges potentially removing material from the transcript, not the broader issue, which I acknowledge, well, it is relevant to raise with the Chief Justice, but I think there's broader responsibilities, including ours.
Minister, federal court proceedings can be absolutely critical for determining fundamental national interest points. The scope of federal powers, contesting federal legislation, contesting executive decisions, like critical to the national interest. Do you think it's appropriate that the transcription services for those proceedings are offshored, being dealt with on a cloud in offshore Ontario, or do you think it's appropriate for that to be privatised to an offshore company?
Well, again, I refer back to some of the reasons why this particular company may have been successful in a bid to provide those services. One imagines that all of the requisite security issues would have been canvassed at the time that this decision was made. When we enter into these free trade agreements, they are legally binding documents. They do impose obligations on Australia as to how we treat bids from other countries for the supply of particular services. So we have to be mindful that having reached those agreements in the first instance, unlike some other countries, we do take seriously our obligations to comply with those laws. Now, there is always going to be a national interest consideration in a range of particular services that we supply. I'd prefer, before I gave a formal response to that question, Senator, to know a little bit more about how these decisions were made, what considerations that were made, what other obligations are on the supplier of this particular service before I answer that question, but I shall endeavour to do all of that and come back to you with a formal response, Senator.
Thank you, Mr. I appreciate that. And if you could you include in that response what contractual measures there are to protect the privacy and integrity of the data that they've obtained, if any?
Yes, I'll look at all of the issues around the supply of this particular contract.
Thank you. My final questions in this session are on AI use and risks. Secretary, the Attorney-General's Department has produced an artificial intelligence transparency statement. You would be aware of that. It's, I think, just ticks over 3 pages. I wouldn't call it double-spaced, I'd call it triple-spaced. Is missing, I would have thought, essential information. For example, it doesn't include what if any, well, what specific AI systems, tools and vendors are currently being used by the department. What's the point of a transparency statement that doesn't say what AI you're using?
So, Senator, I acknowledge your point. We're doing a lot of work in the department at the moment to strengthen and enhance our approach to AI. In terms of the transparency statement, I would have had my colleagues from our corporate area come to the table to support me in this discussion, but because we've gone through that section, they're no longer here. I think I'm happy to take on notice in terms of further detail around the tools. I hope to be enabling broader use of several AI tools for every staff member in the department in the near future. And I'm happy to provide further information. When that happens, we will update that transparency statement as well.
But, I mean, it says we apply AI tools across the department in the following domains: service delivery, compliance and fraud detection, policy and legal, corporate and enabling services. That gives no transparency. That looks like you put AI pretty much across the whole department.
Well, we are looking at trying to use it in as many parts of the organisation as possible. But as I said, in terms of further information on the actual tools that we're using, I'm very happy to take that on notice and provide back to you.
All right. So you'll give that answer on which specific AI systems, tools and vendors are currently being used?
Yes.
You said that you have thank you, Secretary. You said you had an intention to extend the amount of AI being used?
I do, yes.
Which vendors are you considering that for?
I'm just trying to think. I think we're just finalising procurement in relation to one, so I might just be a bit careful about what I can say. They are 2 broadly available tools that I'm hoping I can roll out. So if I can, just to be cautious that I don't cut across any procurement activity, if I can take that on notice, I think I would be in a position to be able to advise you in the very near future.
Are you going to ensure in that the AI providers don't retain data?
Obviously, that's an incredibly important aspect of, particularly with government data, and so yes, we will be working through that.
Well, does that mean you will ensure that they don't retain data? Because the statement, the rather obscure statement on the transparency thing is we ensure that any data used in AI systems is handled in accordance with the Privacy Act. Now, does that mean you're going to prohibit any of these AI vendors from holding the data, retaining the data?
Senator, I think that would broadly be our intention, but I'd like to take on notice to give you the detail on that.
All right. Who are the accountable officials? And I quote that from the thing, for AI oversight.
So we have a Under the new framework, there's a requirement now for 2 accountable officials. So there is a... sorry, I'm just trying to bring it up. I do have this information. Thank you. So we have an accountable official for AI as required under the Policy for Responsible Use of AI that has been issued by the Australian Government. And the Australian Public Service AI Plan also requires that we appoint a Chief AI Officer. We're just working through at the moment whether or not we combine that into the one role or we have 2 separate roles. What I can say is, in light of the impacts of AI, not only as a tool for the way that we do our work, but also looking at its application in broadly in our areas of responsibility, and an area that I'm particularly interested in is around access to justice. So in light of the broader implications for AI, we have taken the decision that our executive board, which is the peak governance body in the department, will also be the governing committee for AI in the department. So it will sit as the AI committee on a regular basis as well.
All right. So when it says governance bodies having oversight, it's that committee that's going to have, instead of bodies, it's body. Is that right?
It will oversight use, capability, systems, security, ethics, everything to do with the use of AI in the department.
Secretary, you say that, and I think I read it to you before, we ensure that any data used in AI systems is handled in accordance with the Privacy Act. I've had a look at the transparency statement and also at the responsible use of public generative artificial intelligence guidance for the department, and that's a September document. At no point does it give a clear direction to minimise the amount of data being fed into AI. In fact, it's kind of silent on that. It doesn't say, and if you're going to be privacy compliant, surely at a minimum you should be saying, don't feed data in unless it's absolutely essential. I mean, I'd say don't feed data in, but if you're using it, don't feed data in unless it's absolutely essential. Why doesn't it say that?
Senator, I'd need to take that on notice. Obviously, we want to take an approach to the use of AI, which is compliant with our Privacy Act obligations. So I'm happy to take that on notice and come back to you.
All right. Have you done a gap analysis of AI risks in the department? Which a gap analysis looks at where you are, looks at where you'd want to be, and works out what you need to do to get there.
We've certainly done a range of work around assessing risk, trying to get that balance right of ensuring absolutely we've got all the guardrails and risk assessments as appropriate in place, but also not doing that in a way that inhibits appropriate uptake of AI, where we can achieve efficiencies or improvements in the way that we do our work. We are very much guided by the whole of government policies around responsible use of AI, and we will continue to. It's not static. We know that we need to continue to assess risk as different use cases come up and different opportunities with the type of platforms that are available.
What AI do you use, Secretary?
I have used Claude and ChatGPT.
Not Copilot or?
Not yet. We haven't rolled that out broadly in the department, but I think what I can say is that is one of the tools that we are looking at.
And we've got you here, Ms Harvey. What tools do you use?
Senator, I've used Claude and Perplexity.
And I should say, when I did an email recently to the department about AI, I noted the fact that I had used AI in the course of preparing that communication.
Minister, what AI tools do you use?
Well, I tend not to, if I'm responding to an email, say from yourself, I write that myself and I don't use any other tool. However, if I'm looking something up on the internet, an AI-generated response from Copilot, I think it is, pops up on my on my search, and I have to say I have been increasingly using that to get the correct response.
That's in your personal work, but not in your professional work. Is your
both?
Or is it both?
Both. Yes, both.
All right.
So, for instance, I wanted to know what the Greens' policy on gas was. I put that into my, search engine.
It says here, keep it in the ground. Hey? It says here, keep it in the ground, Minister. That's what it says. Keep it in the ground.
I didn't need to use artificial intelligence to work that out, I have to say. But no, I don't know whether my staff use AI. I suppose I should inquire about that. But I don't use it for anything I respond to people for, but I do use it to get answers on questions.
Preparing draft
Minister.
answers for question time.
Secretary, when you use Claude and ChatGPT, were there any protections about what you fed in, or was that in a closed space?
It was in a closed space,
licensed space,
and it only drew upon emails that I had sent to all staff in the department. So open emails. I used it to experiment with future communications by drawing on my voice in other communications.
But what you fed in, was that swallowed up by the LLM, or have you got a separate licensing agreement that ensures the data isn't shared beyond a separate?
It was separate.
Can you provide details of that licensing agreement with ChatGPT? Did you use ChatGPT or Claude?
No, it was Claude.
Could you provide details of that licensing
We'll take
agreement?
that on notice.
And in terms of ChatGPT, is there an arrangement with ChatGPT where what you feed in is protected and stays within a set domain for the department or the Commonwealth, or does it get fed into the LLM?
So in terms of that level of detail, I'm going to take that on notice so I can give an accurate response.
Right. And to the extent that Ms Harvey or other department officials use Perplexity, can you provide the same answers on that?
Yes, I can. There's probably one thing I would like to note, and that is the Australian Government Solicitor within the department has a policy around the use of generative AI language models which provides guidance on the appropriate use of AI in connection with duties as legal practitioners and APS employees.
And is that used by legal practitioners in the department or only in the AGD?
Well, it's the AGS legal practitioners that are part of the broader department.
So everyone who's got a practicing certificate has to apply that policy as well. All right, thank you.
Thank you, Senator Shoebridge. That means that we are now finished with this group, the Justice and Communities group, and Closing the Gap outcomes. So thank you very much to all the officials for your time this morning and into this afternoon. It now means that we are moving to the Integrity and Security group. And I am giving the call to Senator Ruston.
Could you give me some water, Mr. Paul?
It was far longer.
Oh, okay. So following on some questioning this morning, the question that was asked for you, Miss, how do I pronounce your name? Chidgey. So I hate it when somebody pronounces my name wrong, so I don't want to do it to somebody else. So does the Department of Attorney Generals accept the findings of the two superior Australian courts that place allegations made against Minister Reynolds were, in the words of Justice Lee, without reasonable foundation in verifiable fact, and Justice Tottle, who said objectively false and misleading and dishonest?
Sarah Chidgey, Deputy Secretary, Integrity and Security Group. So we're aware of those judicial comments.
So do you accept the findings of those two courts?
Senator, what I would say is that it's not the role of the department to accept or not accept judicial findings. We note them, but it's not for us as officials to pass judgment on or public comment on the findings of a court.
I wasn't asking you to pass comment. I was just asking you whether you accepted the ruling of two very senior courts. So in light of those findings, has the Commonwealth undertaken any review of how it treated then Minister Reynolds, including its approach to mediation, settlement and any other public statements made or authorised by the Commonwealth?
So, Senator, what I will do is ask colleagues to take you through that process. I would say, by way of introduction, that was managed in a fairly orthodox way in terms of how these matters are managed, but I'll ask Ms Chidgey to go to some of the detail.
Senator, I can say that we did consider the outcomes of that matter in the context of the settlement. They dealt with different sets of issues, and we obviously had the National Anti-Corruption Commission who reviewed the department's processes as well and found them to be appropriate. So those judicial decisions have not raised issues about the settlement and its appropriateness.
Okay, so there have been no changes to policy or practice since the determination of those two judgments, although since those two judgments were brought down?
That's correct.
Okay. So in the case of the court findings that place allegations made against Ms Fiona Brown were without foundation, I mean, does the Attorney General's Department or the Australian Government Solicitor accept those findings?
Senator, I'm just cautious here because there's matters before the court, and I think it's really important not for me not to say anything that would in any way impact on those proceedings. They are being dealt with by ComCover. They are the instructing agency for those matters. So I think in terms of the conduct of those proceedings, it would be a matter to put to the Department of Finance and ComCover.
Well, I'll certainly be asking those, but I'm asking about a matter that has been finalised in terms of the judgments of these two particular actions. So on that basis, I'm just wondering whether what is your advice in relation to the argument that subsequent actions, that you are not answering questions on that basis? I mean, do you have some advice or something that you can rely on in which to say that this is a sound basis for which you're not answering my question?
Sorry, the not answering your question just relates to, and maybe I got confused which matter you were referring to. If it's the matter that involves Ms Brown in proceedings that I believe are in the federal court with ComCover, they are still on foot. So it would be inappropriate for me to say anything about a matter that's in the federal court that's on foot. In relation to the management of the settlement in relation to Ms Higgins, as Ms Chidgey discussed, that was the subject of an inquiry by the National Anti-Corruption Commission that reviewed all the decision-making and advice that was provided to support that decision, and in fact, in a slightly unusual step, the National Anti-Corruption Commission actually issued a statement to talk through in detail the approach that the department had taken in terms of briefing the Minister, and indicated that it was both appropriate and relatively orthodox in the way that settlement matters are treated. I do have a copy of that statement here if you haven't had it, that we could table.
Yeah. So I'm actually specifically talking about Minister Reynolds and the actions in relation to Minister Reynolds and the findings of those two judges in relation to Minister Reynolds, or then Minister Reynolds. I'm not asking anything in relation to matters that relate to Ms Higgins. Well, given that you've advised that, subject to those findings, you've saw no reason to change how you were dealing with the matter, could I perhaps ask then, since 2022, has the department approved any requests to brief councils at rates over $5,000 per day in relation to the proceedings that involve former Senator Linda Reynolds?
So I will ask my colleagues to assist on that, but just circling back to your last comment, I would just reiterate that those matters that are before the court, they are matters for the Department of Finance and ComCover, and it's not that I'm refusing to answer questions, but they're not the responsibility of this department, but broadly in my responsibility as the Secretary of the Attorney-General's Department, I am highly conscious of not making comment on matters that are before the courts.
Thank you. Senator Anne Sheehan, First Assistant.
Before I go, sorry, Sheehan. So you're making a claim of public interest immunity on the basis, so what is your actual basis for your not making any comment?
I'm not sure it's, I have to get to that space because it's not the matter that we have carriage of, it's the Department of Finance.
So you don't advise in relation to that? Because I would have thought that you would have been the ones that would have been advising in relation to the prejudice that could possibly be incurred if you made comment.
I just reiterate, it's a matter that is being managed by Department of Finance and ComCover, and I don't think I can add anything to that. So I'm not making a public interest immunity claim because it's just not a matter that I can comment on. It's not, the department is not running that litigation.
But you made the comment that you couldn't comment on something that was before the court, so obviously you did have a view in that, in terms of what was the basis for that. I mean, you could only make that claim if you believe that your actions would prejudice the case. I'm just interested to understand what that basis would be.
Right. Look, that would just be from the general perspective of being the Secretary of the Attorney-General's Department, whether or not someone would think, because of the nature of my role and responsibility, that any comments I had had some weight, but that doesn't detract from the fundamental point, which is this department is not running that matter. It's the Department of Finance and ComCover.
Sorry, Senator Russ, I'm just flagging that I need to rotate the call after this question and I'll come back to you.
Well, I'm actually going to move on to another topic, so if you want to do that and then come back. Yep.
Thank you for your assistance. Senator Cox.
Thank you, Chair. Can I ask some questions around the whistleblower reform, please? afternoon. Can you inform the committee when did the open public consultation on an exposure draft of the second tranche of whistleblower reforms close?
Susan McCaig, Assistant Secretary. The ED bill was published on the 10th of September and public consultation closed on the 1st of October.
Great, thank you. Can you tell us how many submissions were received as part of the consultation process on the exposure draft bill?
Thank you, Senator. Sarah Samios, First Assistant Secretary, Integrity and Criminal Law. There were 16 submissions received during the consultation period.
Great, thank you. What stakeholders provided submissions as part of that consultation process?
I don't know that I have a full list in front of me, Senator, but I do know that there, other than some that were private, they have been published.
Okay, great, thank you. Did the department also conduct any meetings or roundtables with stakeholders? And if so, when were these conducted and what stakeholders were involved?
Yeah, Senator, so the department met with representatives from a number of civil society organisations who were selected for their expertise and interest in public sector whistleblowing reform and held a lengthy discussion, a day-long discussion about the drafting of the exposure draft. So bodies involved in that included the Law Council of Australia, the Australia Institute, the Centre for Public Integrity, the Community and Public Sector Union, Griffith University, the Human Rights Law Centre and Transparency International Australia. Now, I don't have the exact date other than it was in September. Do you have the date?
My recollection is it was the 17th of September.
Great. Thank you very much. Was there general support for the submission? For the proposal to establish a whistleblower ombudsman?
I think, broadly speaking, yes, that would be an accurate description.
Great, thank you. How would a whistleblower ombudsman better protect public sector whistleblowers?
The whistleblower ombudsman will improve supports for public sector whistleblowers by providing stronger oversight of the Public Interest Disclosure Act and its operations. Also have a range of functions such as providing general advice to public officials and to disclosures. It has a number of new functions, one of which includes alternative dispute resolution. It performs a range of reporting and other functions to give transparency and insight into the operation of the Commonwealth public sector whistleblower system.
That's great, thank you. Can you please talk us through the proposed measure around reversing the burden of proof and how this would better protect public sector whistleblowers?
Thank you, Senator. So one of the areas of feedback that we heard from stakeholders was that there was a need to strengthen reprisals supports. So the exposure draft bill reverses the onus of proof. In doing so, it aligns the Public Interest Disclosure Act with similar provisions in the Corporations Act. So what it would do would be there would first need to be an allegation of a reprisals made, an initial evidential onus on the applicant, and then the burden would shift to the Commonwealth or the respondent to prove that reprisal action didn't occur.
That's great, thank you. Were there any views received from stakeholders regarding improvements to access legal and other professional assistance for public sector whistleblowers, and what are these proposed measures?
Thank you, Senator. The exposure draft bill makes some important extensions to immunities that would apply to disclosures looking to seek professional assistance. This could include from medical practitioners, psychologists, legal professionals, union representatives, or also professional bodies. For the purpose of seeking advice around the operation of the Act and provided that no more information than is reasonably necessary is disclosed, those extensions which are available under the PID Act would extend to those disclosures to professionals and also protect the professionals receiving that information themselves.
That's great, thank you. And were there any views received around, particularly from stakeholders, the improvements to implementing a no wrong door approach? And if so, what are these proposed measures?
The concept of no wrong doors is, in very simple terms, that there's a broader range of avenues available to people wishing to make disclosures under the Act. The Exposure Draft Bill gives effect to this in a number of ways, one of which is prescribing additional investigative authorities that can receive disclosures. So there are a range of new investigative authorities that are now, would be prescribed. Another way in which the Act increases no wrong doors is it, of course, also creates the Whistleblower Ombudsman, which is a significant new addition to the integrity landscape and is in a position to receive both disclosures and complaints about disclosures. It also increases internal pathways within agencies. So senior officials within agencies can now also receive disclosures under the Public Interest Disclosure Act and a number of other technical amendments which support that objective as well.
Excellent. Thank you. Thank you for the update.
Thank you, Senator Cox. Senator Shoebridge.
Thanks, Chair. Well, while we're on PID Act reform, there was hope amongst the sector that that legislation would have been presented to Parliament last week and presented last week, Secretary. Why not?
Senator, as you can see from Ms McCaig's testimony, a lot of work had been done to have the bill ready for introduction. Unfortunately, it was just a very busy second half of the sitting period, and we just didn't get in there. But what I would say is the legislation is in very good shape and hopefully will be introduced, but obviously that's a matter for government.
All right. Is there an intention, now that we have the time, to put it out, put a draft bill out for consultation over the break so that any wrinkles can be ironed out over the break and then it can be legislated as soon as possible in the new year?
That would be a matter for government.
All right. Minister, do you have a wealth of information to share on this?
Very helpfully, the attorney has given me this response.
I'm happy for you to table it if you want. So if you want to just table it.
I just have to make sure I give you the absolute correct response. I'd hate to, mislead the committee in any way, but the attorney says this. The government is carefully considering submissions that were provided as part of the public consultation on the exposure draft bill. So I think that answers your question that we've already got the submissions and we want to get these reforms right. So I would imagine that the attorney will be working on this over the Christmas break, and she will come back in the new year with a determination on whether to, whether to proceed and under what circumstances and what time frame to proceed.
Thank you, Minister. But Secretary, surely there's been a decision to proceed with the bill, isn't there? This tranche of the reforms, or is that still in play?
So, as you know, back in September, the government released the exposure draft bill for public consultation. That was open for 3 weeks. We received a range of feedback and have further refined the bill. As I said, the work is very advanced.
All right. Well, then I might move on to something that is even more advanced, perhaps. the current FOI reforms. Is that a...
I'll need to bring a different team to the table.
Yep. Well, they're coming up. Secretary, I don't think I was alone. I think a number of people put FOIs to the department about who they consulted, where the information came from, and I think you recall last time we spoke about some of those responses, or maybe that was in the inquiry. Does that ring a bell? I think it was
Yes.
through the inquiry, Ms Moran. There was a discussion about the FOIs that were put in and the FOI responses that were given from the department. Do you remember some of those discussions in the inquiry?
Yes, Senator.
Yep. What was clear, though, was that to the extent that advice came from the national intelligence community, that hadn't been prompted by the national intelligence community. What was clear was that their response about seemingly innocuous government information being accessed through FOI, contrary to our national interest, that only came about once your department directly sought input from the national intelligence community, isn't it? That's how it happened. Is that right?
Senator Celeste Moran, First Assistant Secretary, Identity and Information Law Division. I think I confirmed for you during the bill inquiry that the department certainly did engage with the National Intelligence Community in relation to the bill.
Yes, but I want to be clear is the National Intelligence Community weren't knocking on your door and saying there's a problem with FOI. What actually happened was your department contacted the National Interest Community and said, hey, come and tell us anything you can about the FOI. That's how it happened. They didn't knock on your door, you knocked on theirs.
Again, Senator, I'm not at all disputing that we went to the National Intelligence Community. I think I also said to you during the bill inquiry that on a day-to-day basis, the work that we do in the Information Law Division and Identity area isn't heavy on national security work. What the National Intelligence Community have said, though, is that they put out threat assessments and information to the system more generally. And while they're not driving these reforms, we certainly are in the department, that at times that information that they put out is heard. And in doing that, that was something that we picked up and went to them and asked about, and they provided us some advice in response.
Now, when it comes to the government's assertions that AI bots are causing grief with the FOI system, have there been any AI bot attacks on the FOI system since we last spoke in that committee? Can you identify any instances in this financial year where AI bots have been a problem for FOI?
So, Senator, I think since the previous estimates and the bill inquiry, I don't think we have anything in addition to say that we have previously. I think we've said to you previously that we are aware of AI in the FOI system, that we've had some examples of that from specific departments. The Office of the Australian Information Commissioner has put out guidance in relation to the use of bots and how to respond if agencies think that a bot is responsible for putting in an FOI application. And we've also got examples in the international jurisdictions about AI and bots being used that have actually had greater impacts than we've seen in the Australian jurisdiction.
Well, the only evidence base we got from the FOI was 2 US articles, nothing from Australia, and a couple of FOI requests where it looked like AI had been used in drafting the FOI. That was the evidentiary base you had at the time the department proceeded with the law reform, is that right?
So, Senator, I think the evidence that we've provided in the domestic context is that we're aware from departments that there is AI-generated content being seen in FOI requests, that Services Australia in particular had given us some statistics to suggest that FOI matters that they had on hand, that 18% of personal matters and 50% of non-personal matters included AI-generated content. They also put in a submission to the Bill inquiry that said that it is quite difficult to tell if a request has been made by a bot. And then I've also just referred you to the OAIC FOI guidance that's been put out, which recognises the rise in the use of AI and the potential for FOI requests to be made without human intervention. And we understand that OAIC guidance was put out to respond to the issues and questions being raised with the regulator by different agencies.
Well, the evidence from that you've referred to from Services Australia was that I think 18% of personal matters and 50% of non-personal matters included AI-generated content. That was I'm reading from the material you provided to us earlier, is that right?
That's right, Senator.
Yep. What does included AI-generated content mean? Does it mean like when the Secretary sends an email, some of the email is drafted by AI? Is that what it means?
Well, Senator, I mean, I don't have Services Australia here, so I mean, I think the specifics of it would probably be best directed to them. But I think that the reality is it's very difficult to tell because they can be done anonymously, is the first point. The second is that it is through FOI teams essentially reading requests and making an assessment over time about the way requests have changed in the way that they are framed, and therefore saying they think, but it is hard to tell, that it's AI generated.
Well, that includes AI generated content is very different from an FOI request being generated by a bot. They're fundamentally different things. Having part of your request populated by an AI once you start typing is very different to an AI bot generating the request.
And once this response has been answered, I will share the call, and I'm sure Senator Pugh will want to come back to this after.
These are fundamentally different things, aren't they?
I understand what you're saying. I think that the fact is that the bill is trying to address both of those issues. So the OAIC guidance does go to FOI requests being made without human intervention. But what we're saying is, what Services Australia have told us, is that there are examples of AI-generated information and content in requests as well, which are also complex and voluminous and at times difficult to understand what the applicant is actually asking for, which does put pressure on FOI teams in trying to negotiate with the applicant what it is that they are seeking.
Thank you, Senator Shoebridge. Senator Ruston.
Thank you very much. So since 2022, have you approved any requests to brief counsel at rates over $5,000 per day in relation to proceedings involving former Senator Linda Reynolds?
Senator, we'll bring the relevant people to the table, and I'm sorry, I know you asked that question earlier and I went off and answered a general point.
No, I think I came back to you, so it's all good.
Sorry, found it. Thanks, Senator. Anne Sheehan, First Assistant Secretary, International Law and Public Law Division. As the Secretary has mentioned, the proceedings from former Senator Reynolds are still ongoing. ComCover are leading those proceedings. The Attorney General's Department, specifically the Office of Legal Services Coordination, does have a role in approving counsel rates over a certain threshold. The specific rates charged by counsel in a particular matter are commercially sensitive, so we would not disclose what approvals have been put in place for particular rates in a particular matter. but we can take you through the Commonwealth Council rate regime if that's helpful.
No, I don't. I'd really like to know. Well, first of all, lawyers and barristers are obliged by their own rules to give cost estimates to their clients. So clearly those cost estimates exist. And these are questions about the expenditure of public money, not the merits of the litigation. And we have a legitimate constitutional role and responsibility in scrutinising the appropriations and expenditure of this government. So can I maybe ask you, have there been occasions when rates above $5,000 per day have been approved in relation to the proceedings?
So Senator, as Ms Sheehan noted, there are just challenges around publicly noting that in light of the, as Ms Sheehan said. Could I request that we take that on notice and consider whether or not there might be a need for engagement? I mean, ultimately, it's a matter for ComCover and the Department of Finance. They are running the matter. I think just to ensure that we're not breaching any commercial in confidence issues, if I could take it on notice to come back to you.
So who's the department that actually does the processing in terms of the determination as to whether exceptional circumstances are sufficient to warrant the expenditure of more than $5,000 a day? Is that the Attorney General's department?
Yeah, the request comes to the department, yes, as a matter of process. Yeah.
So you were the one that made the determination, if such a determination was made, but you're refusing to tell me or refusing to tell the Senate whether you approved payments in excess of $5,000 a day for any of the people represented on that case, representing the Commonwealth.
Senator, I'm not refusing to tell the Senate. I'm requesting that I can take it on notice to ensure that there aren't any issues around breaching commercial and confidence information, and I will endeavour to work through that. As I said, the matter is that while the approval for approval of rates above the $5,000 a day is something that's done by the department, the request comes from the other department, so in this case the Department of Finance, and I would want to engage with them.
Okay. So what I'd really like to know then, if you are not going to answer it now and seek to take it on notice, what was the basis, if for whatever, that approvals were granted for more than $5,000 a day, what were the exceptional circumstances that you believed warranted the engagement of somebody who attracted fees of more than $5,000? And also, I'd be really interested in the process of these, commercial grounds that you're citing as the reason why you're not prepared to provide me with that information, which I'm sure you've quite clearly got, but you're seeking to get further information about it. What legal advice does the department have whether commercial sensitivity can be claimed as the reason for withholding this information about the expenditure of public funds? And if you could please table the advice that you are using for the reason why you are choosing not to release this information, if of course you choose to come back and say that you're not going to release it. Because I find it quite incredible that that the cost of the council that is currently being engaged, that there would be any basis why you would not be able to provide us advice as to whether they're being paid more than $5,000 a day.
Senator, so we'll take those confidentiality aspects on notice, but I'll just ask Ms Sheehan to clarify the basis on which approvals are given generally under the regime.
No, I don't want them to generally. I'd like specifically.
We do need to clarify because there isn't an exceptional circumstances requirement, so I think we just do need to put the correct criteria.
Thanks, Senator. So yeah, we've taken on notice the issue of council rates in the particular proceedings that you've mentioned, but I can answer broadly. The legal services directions set out relevant factors for when council rates may be approved above the threshold, and they include the special expertise or skill of the counsel, the availability of counsel generally to appear in the matter, the probable total cost of counsel's fees in the matter, the specific request of a Commonwealth agency that a particular person be briefed and the reasons for that preference, the importance of the matter, including any special sensitivity, and the normal market daily rate at which the relevant counsel is briefed.
So if you could answer all of those questions when you come back as to how they apply to this particular situation, that would be much appreciated. And also, in the last financial year, how many times has the AG approved fees above $5,000 per day, and on how many separate matters did that apply to?
Thank you. We collect that information, so I think...
I think we might have that information here. We'll just take a minute to pull that up.
Senator Philip Ing, Assistant Secretary of the Office of Legal Services Coordination. What I have for you is some figures that relate to the last five years, but we can certainly take on notice and come back to you as soon as we can on the breakdown in relation to... sorry, could you remind me which period you were particularly...
In the last 12 months.
In the last 12 months?
Well, the last financial year, July, June, 24, 25.
So the relevant thresholds are different depending on whether it is a junior counsel, which is $2,300 a day, including GST, or a senior counsel, which is $3,500 a day, including GST. In the relevant period since the 1st of January 2020 until the 1st of November this year, there have been 589 decisions that have approvals that have been given that were above threshold rates. So that includes both ones that were either given by the Attorney General, which is ones that are over $5,000 a day, or ones that are below $5,000 a day, which are decided by the Attorney General's delegate. So that's the figure of 589, and I can come back to you on the question of in the last 12 months and give you the breakdown of the Attorney General and delegate numbers.
So how many over $5,000 was my question, not 3,500 or 2,500, was how many over 5,000?
Sure, I can come, thanks Senator, I can come back to you on that.
Senator Ruston, I'm just flagging to share Paul. Thank you very much. Senator Cox.
Thank you, Chair. Can I ask some questions in relation to the Credential Protection Register? Right, people?
We'll just get
the new officials. Yep. Afternoon. Could you explain what the Credential Protection Register is?
Certainly, Senator. Adam Knott, Assistant Secretary, Identity Branch in the department. So the Credential Protection Register sits within the Document Verification Service, which essentially is a service that we run that allows individuals to present their identity documents, so things like their driver's licence, their passport, their Medicare card, to a government service agency or a business in the private sector, a bank, a telco, that sort of thing, to verify their identity, so to prove who they are when they're engaging with that sort of government service or that business. What we have found over the years is that obviously identity crime and fraud is rife in the community. The AIC, the Australian Institute of Criminology, have done a range of work over the years to tease out the devastating impacts of identity crime. In late 2022, there was a need following large data breaches to do something to deal with identity documents that have been compromised being used to verify someone's identity for a fraudulent or criminal purpose. The Credential Protection Register was built within the document verification service, essentially to allow the system to block an identity document that's been compromised from verifying through the system to protect the person whose identity has been stolen. So that system, the Credential Protection Register itself, was set up in late 2022. Since then, the system has blocked, it's around 700,000 attempts to verify a compromised identity document. So that's pretty staggering. The register itself has been quite successful, and in the 23, 24 and 24, 25 budget sort of processes, so 23, 24 MYEFO and 24, 25 budget, there was a range of additional funding injected into the system for us to enhance the register itself to try to build on the success that we've had to date. There's two things that are underway. The first phase of the enhancements has been recently completed, and the second phase has started. For the first phase of enhancements, we have developed essentially what operates like a portal for identity credential document issuers, so whether they're in the states and territories or in the Commonwealth, to be able to access the portal and to add documents and remove documents from the register in real time. So previously the process to add a new document to the register to protect it was a bit cumbersome. There was a time gap between the document being identified and then added to the register. The new portal functionality that has been developed and is being rolled out now will allow agencies like transport agencies, road agencies, the Passport Office, anyone who issues an identity document to add a document to the register almost immediately once they are aware of it or have received a request from the individual. So that way, the identity document is blocked from being used to verify someone's identity and commit identity fraud, but the person can still use the document. They can still drive, they can still travel on their passport. It just is prevented from being used to, say, open a fraudulent bank account, buy a SIM card, defraud a government agency. The second phase of the work that we're doing with the register is work that we'll be undertaking over the next 12 months. And it essentially will allow us to build and deliver an app sort of functionality within the MyGov system to allow individuals themselves to preemptively or in response to a data breach to log on, verify their identity and then add and remove their own identity documents from the register and to block and unblock them. So a citizen could jump on to the MyGov app, add their passport, say, to the register and block it. That way their document is protected and it can't be verified. Then if they do go to a bank, want to get a home loan, they need to verify who they are. They can go into the app, unblock it, allow the verification to happen, and then return it to a blocked state. We're also looking into functionality to allow notifications to be pushed to the person so that they know when their documents are being verified. So if it's not them who has asked for their document to be used, they will see an alert and then can go make inquiries, contact the police, that sort of thing. So that's work that we're doing over the course of next year.
Excellent. Sounds like there's some really great work being produced, particularly in this area, to protect Australians. I note there was an additional $15 million that the government has put into ID Care for victims support services as well, to support individuals who've suffered an identity breach or identity compromise. Do you want to say anything additional in relation to that?
Yeah, thank you, Senator. So it was $21.2 million over 5 years from 23-24 for the continued support for victims of identity crime. So some of that funding had been delivered to ID Care. The previous contract with ID Care was expiring, we've completed a 2-phase procurement process, and the new contract with them has run from the 1st of August to 30 June 2028, and that's the $15 million component of the 21.2 that you're talking about. So ID Care provide victim support, device cleaning, remediation, financial counselling, referrals, a range of they develop a range of response plans for individuals, and can also provide sort of case management for specifically tailored services for individuals who have had their identity documents compromised. So,
and Senator, we might just give you the numbers that we've got. So for the
that'd be great.
The 24-25 financial year, which is under the previous contract with ID Care, it was 39,582 victims who were assisted through ID Care and the funding that's provided in that financial year.
Great. It's quite a terrifying process of identity crime, and so such a great service. Are there any further enhancements that are going to be made to the register to make sure that we try and help protect Australians about the rising rate of identity crime that's currently happening?
Yeah, Senator, as I mentioned, the future enhancements are the ones that we're focusing on now that will roll into next year, and that will be around that app functionality to allow individuals to block and unblock and add and remove their own documents and to get alerts when they've been used. So that will be the main priority for us for next year in regard to the register.
And Senator, I'll just add to what Mr. Knott has said. I think the app that we're trying to develop puts the kind of control back in the individual's hands, which is something that we hear a bit about in this context. So rather than stage one, which is significant in and of itself, that's having a government agency being the one that controls how that compromised identity document is put on the register. The second stage will mean that individuals can control that themselves, and you can utilise it, as Mr. Knott said, as and when they need to, so that they can continue to kind of go about their daily lives but not have the kind of fear of that compromised document being used for fraudulent activities.
It's great work. Thank you very much for giving us an update on that. Thank you, Chair.
Thank you, Senator Cox. Senator Shoebridge.
Thanks, Chair. I was asking questions about the FOI reforms, and when I think we're having the discussion about the alleged need to protect Australia from bots. Just to be clear, the only evidence from within Australia that was presented on request through the FOI to the department about so-called bots was the 50% of non-personal matters and 18% of personal matters, FOI matters from Services Australia, including AI-generated content. That's the only evidence you could point to through that FOI that I could see from Australia.
Well, Senator, there's that. There's also the content that I think I have provided to you previously in relation to Services Australia's submission to the Bill inquiry, which mentions that there's an upward trend in AI. And I've also mentioned to you the OAIC guidance, which has been put out in relation to requests being made by AI and bots. I think...
No, you go.
What I was going to say is that I take your point about when there's whether or not it's a bot or whether or not it's content generated through an applicant that's using AI for the purposes of putting in their FOI. I think what we are seeing though is that there is AI being used across the system, and that there are few tools that exist currently under the FOI Act to respond to those issues. We are seeing a kind of rapid increase, I suppose, in the take-up of AI, but also that technology advancing day by day. The international examples do demonstrate that it can be used to put in voluminous requests at speed, And as I said, the current FOI Act doesn't have tools that are available to respond to those issues. And so the amendments that the bill has here are trying to address those issues and have one eye on the future, which is that we are seeing these issues in international context, that there is a bill before the Parliament and that there's an opportunity to have an eye on that technology and the advances in it and ensure that the bill is fit for purpose in this digital age.
Ms Moran, thank you for that. What is very clear from the answers you've given and the material that's been produced is the Commonwealth cannot point to a single instance where an AI bot has put an FOI application in. You can't point to a single actual instance, can you?
Well,
and if I'm wrong in that, show it to me. Show me the instance.
Well, Senator, I've given you the evidence that we've been provided from other agencies. I think I've consistently said to what other departments and agencies are telling us that it is difficult to tell if the request has been made by a bot or by AI.
But I'm going to give you the opportunity now. Anyone here, can you point to a single instance where an AI bot has put an FOI in? A single one?
Well, Senator, I think actually Ms Moran has gone through information that we've received from other departments that indicates some role of AI in applications, and I would circle back to the issue that OAIC would not issue guidance if it had not had the issue raised with it by departments and agencies.
Well, we can ask OAIC that themselves. Have they told you this? Have they told you that there are instances of bot applications? And
My understanding is that's why they felt it was necessary to develop guidance for the sector.
Where does your understanding from, Secretary?
I think from talking to my colleagues.
But they've just confirmed they're not aware of a single instance of an actual bot being used.
That's not what they confirmed.
I think...
Well, tell me, show me the instance.
Senator, I think what we've said is that it's difficult to be absolutely certain, but that, for example, Services Australia has indicated that they've seen an upward trend in requests that appear to them to be from bots. So it is a judgment they're making, and that is some of the information we have.
Where has Services Australia told you that they've seen an uptick in applications that appear to be from bots? Because that's quite separate to what they've said in the inquiry, and it's quite separate to what you've provided in the FOI. So where is it, Ms Chidgey, that Services Australia has said there's been an uptick in applications that appear to be from bots?
It's on page 7 of their submission to the bill inquiry, Senator.
And how did they identify the bots?
Well, it's under a heading that says responding to genuine applications. There's a paragraph which I can read for you in full or I can not. The second paragraph says, while it is difficult for the agency to be certain that an application has come from a bot rather than a person, the agency has seen an upward trend over the past few years of requests that appear to be from bots. The agency supports this reform as it will help the agency to focus on responding to genuine requests for information.
Is Services Australia aware that bots don't have a right to freedom of information? That only people have a right? So are they progressing applications that appear to be from bots, despite the fact that there is no obligation to produce it? In fact, you'd say it's actually probably contrary to the Act.
Senator, presumably you'd have to ask Services Australia that question. I don't think it's particularly fair to ask this witness that question.
Yeah, they're on Wednesday. Come down. I'm the chair of that committee.
I mean, look, if the witness wants to answer, by all means, but I just think you're getting a little bit too far away from the source of the information.
It's probably good advice, Minister. I'll take it. Thank you.
I'm full of good advice, Senator Shoebridge.
Well,
any time you'd like a bit of advice.
I appreciate it.
Without AI.
No AI. No.
I was going to go on to some
using
privacy...
my own intelligence, not artificial.
Chair, I was going to go on to some privacy law reform, but if now's a convenient time to move there.
I can check my notes here.
While you're checking, I may as well
We've got
start.
about 3 minutes left in your...
Yeah, what's the current status of the next tranche in privacy law reform, Secretary?
there has been a significant amount of ongoing work in relation to privacy reform. Ms Moran and her team have been progressing that at the same time as they're progressing the FOI reform. So I might invite them to give the update on the latest work.
So, Senator, I think at the last estimates we confirmed for you again that the government has given a commitment to a second tranche of privacy reform, that work is underway. I think previously I said to you that from the last update we gave you, which I think was in the February estimates, we've had a new Attorney-General who is considering what should be in the package of the second tranche of reforms. She's publicly committed to it and has said that the Privacy Act should be fit for the digital age, and that is work that we are undertaking. The government's committed to doing a consultation on that second tranche of reforms, and that will happen in due course.
All right. The sector, but probably more importantly, millions of Australians have been waiting for this government to update privacy laws so that they're vaguely fit for purpose. Since February, we've seen dozens of major data breaches because our privacy laws are not fit for purpose. Are you saying that there's no time frame that you can tell us?
Well, Senator, I'd start by saying, and I know that you're aware of this, but I'll just mention it anyway, that the first tranche of privacy reforms passed the Parliament late last year, and they did make a number of updates to the Privacy Act. They also made some specific changes that do go to the point that you made around data breaches and how they can be responded to. So there is that first tranche of reforms that have already passed the Parliament. And then, of course, there's a commitment to the second tranche of reforms, and that work is underway.
Yeah, but what people are asking for are things that are already embedded and have been embedded in European law for over a decade, like a fair and reasonable test, a proportionality test, the definition of consent. That doesn't mean when you give consent in 1983, you've given consent for the rest of your life for every single purpose. They're the kind of reforms people are waiting for. When are they going to happen?
Well, Senator, I'm not sure I can add much more to what I've said. They are issues that are being considered and developed as part of the second tranche of reforms. The commitment was that reforms that were agreed in principle by the government as part of the response to the Privacy Act review are potentially within the scope of the second tranche of reforms. They do cover things that you've just raised, like a fair and reasonable test, and that work is underway. There will be a public consultation, but as to the exact timeframe of that, that's a matter for government, Senator.
Thank you. Thank you, Senator Schubert. Senator Ruston.
So could I have my officials back again, please? Thank you. So just to be really clear about the information that I was seeking, it's approvals for council over $5,000 per day in the last 12 months. How many separate matters by the AG department? If you could do that, and if it was possible to have that by the end of the day, that would be great. And the other, could I confirm that you or the services of Mr Justin Gleeson SC, Dr Ruth Higgins SC and Ms Kate Eastman SC have been engaged in relation to proceedings involving Senator Linda Reynolds and Ms Fiona Brown?
Thanks, Senator. I think we've pulled up the number of approvals over 5,000. I think I'll ask my colleague to answer that. I think we might still be looking for just the number of particular matters.
Can you just take the whole lot on notice and come back with what I've actually asked for, because that's what I want. So, and in the second part of the question?
I think the actual council engage would be a matter for ComCover.
Are you telling me that you are refusing to answer a question that I've just asked about confirming?
I mean, it would be a matter of public record, so we could look and find out for you.
Do you know or don't you know?
I don't know off the top of my head whether all three of those, I think two of them rang a bell to me, but I would want to double check the third to make sure.
Yeah. That would be great if you could come back and confirm that.
I'll come back.
Because I don't think anybody would believe in any universe that they would be operating on $5,000 a day. So can I ask, can the department confirm that the Attorney-General has overall responsibility for Commonwealth compliance with model litigant obligations under the Legal Services Direction 2017, regardless of which portfolio the matter is being, or who's the instructing client?
That's accurate.
Okay. So has the Attorney-General's Department provided any advice to the Department of Finance or Comcare regarding model litigant obligations in relation to the Reynolds proceedings or the Brown proceedings?
In terms of the provision of advice, I'm not sure. I mean, obviously, departments are responsible for ensuring that they do comply with the model litigant obligations. If any issues or concerns are raised about that with the department, we would work with the relevant department to try and understand those issues. But we don't. We do broad work across government to ensure everyone is aware of the model litigant obligations, and we work with General Counsel right across government. I think I probably need to stop there in terms of anything, unless Mr. Ng has anything to add.
No, just to say, Senator, that's correct. The Secretary is correct. Really, the role of the Office of Legal Services Coordination within the department is really to support agencies in ensuring compliance with their obligations under legal services directions, and it's agencies that bear that responsibility to ensure they comply with model litigant obligations, both as expressed under the legal services directions, but also at common law.
Have you provided, as the Attorney-General's Department, any advice to the Department of Finance in relation to model litigant obligations in relation to the Reynolds proceedings or the Brown proceedings?
So if it's legal advice on him.
Senator, we're not aware of any, but we'll take that on notice to check.
Okay. Okay. So if you have, I'd be interested to understand what they were, and if you could table any such review or assessment in relation to those.
Senator, I just need to note that we have never provided a committee with legal advice. We are required to confirm whether advice has been provided and the date on which it's provided, but we do not provide the legal advice itself.
Okay. Well, any information that you could provide this committee that about this matter would be very helpful. So when the Attorney-General approves fees above $5,000 a day, what specific assessment is actually undertaken that the costs are reasonable and proportionate to the dispute, and that the Commonwealth is not using its resources to overwhelm or wear down an opponent contrary to the model litigant principles?
So, Senator, I think Ms Sheehan outlined the criteria that that are applied to consider above threshold rates.
I was being really specific around what do you do in relation to ensure, because you've already confirmed that the Department of the Attorney-General is the one who has responsibility for ensuring model litigant responsibility. I'm just keen to understand, what do you do to ensure that the actions of whoever is the instructing client do not overwhelm or wear down an opponent contrary to the model litigant provisions?
So we would obviously assess an application received from a department against the criteria, and we would rely upon the information that they provide to us. In some of these processes, we will go back and query some information or request further information. I'm not saying that may or may not have happened in this circumstance. But sometimes it is an iterative process where we seek additional information to get us to the point where we're satisfied that we feel we can either make a decision as delegate or provide advice to the Attorney-General.
Are you absolutely satisfied in both the proceedings against involving Senator Reynolds and the proceedings involving Ms Brown, that those provisions have been, the department is satisfied that they have been upheld?
So Senator, I think I've undertaken to take on notice in terms of any information I can provide you about that matter, and I couldn't answer beyond that. What I would do say is we are, obviously committed. It's our role to do that assessment and to ensure the model litigant obligations are appropriately upheld.
Mm-hmm. So it would be really helpful for you to come back and give us a categorical statement that you believe that those obligations have been upheld in this matter after you've had the opportunity to have a look, because it would be quite horrifying to think that they hadn't been upheld. So, just as an example, Ms Brown has been unable to work for over 4 years and is currently being represented by in a pro bono manner. The Commonwealth obviously has engaged a number of senior and junior counsel on the matter as it relates to Ms Brown. So I'll be very keen for you to come back and give us a commitment how you assess this situation against the model litigant principle that the Commonwealth is not taking advantage of a party who lacks the resources to litigate, which quite clearly Ms Brown has very limited resources available to her. So I'll be very keen to understand if you have taken any steps, if you've got any oversight, have you taken any actions in these matters to mitigate the resource disparity that exists in the case of the Commonwealth versus Ms Brown.
So I've taken on notice to come back with what I can.
And Senator Scarr?
Just a follow-up question on that.
Final question.
Secretary, I'm also particularly interested to know whether, and again take this on notice, to what extent in the context of the model litigant guidelines obligations, the Commonwealth, you have considered the fact that 2 findings have been made by senior judges in superior courts with respect to allegations that have been made in relation to inappropriate cover-ups, etc. So after hearing all the evidence through extensive trials, they made positive findings that there hadn't been any inappropriate action by the Minister or by Ms Brown. And from my perspective, I would have thought that's highly relevant in terms of deciding what a proportionate response is from the Commonwealth. So could you take on notice whether or not that's been considered as well?
Yes.
Thank you, Senator Scarr. Senator Pocock.
Thank you, Chair. Thank you for your time this afternoon. I've got 2 separate things I was keen to ask questions on. First was the ICJ advisory opinion. I was just over at asking DQ officials about this in the ENC committee, and they sent me here as they said you're coordinating the work on a response to the opinion. And I was just interested to find out where that's up to. Is it ongoing? When will it sort of be given to government, and will it be made public?
So they're already here. I was going to say we'll get the relevant people to the table.
Thank you. Can see them coming up. Thank you.
Thank you, Senator. Jessie Clark, General Counsel, International Law. The department was responsible for Australia's participation in the International Court of Justice advisory proceedings in relation to climate change. You'll be aware that that advisory opinion was handed down on the 23rd of July, and that concludes that proceedings. Nevertheless, since that day, we have been engaged with other departments, including DQ, who have relevant policy responsibility to assist them in understanding the implications of the advisory opinion. That work is ongoing.
And will there be sort of formal advice given to government? You know, my reading of the ICJ opinion has some pretty serious ramifications for our emissions reduction targets, our approval of fossil fuel projects.
So they are all matters, Senator, on which departments ask for our advice on relevant and contemporary questions of international law that's particular to their policy responsibilities. And indeed, we are actively engaged with DQ on the sorts of matters that are raised by the advisory opinion.
Mm-hmm. And looking at the ICJ opinion, they found that mitigation must aim at the 1.5 degrees Celsius temperature goal and must be based on best available science. I think those paragraphs 224, 245, 254. My reading of it, if you look at the ICJ then sort of sets out that the IPCC is an authoritative statement of best available science. Would you agree with that?
Senator, what I can say is that Australia's submissions, there were 2 rounds of written submissions, 1 set of oral submissions at the hearing. They're all publicly available. I'm just conscious of not going beyond those and providing the committee with legal advice, which you'll understand we don't do. You will see, if you look at those publicly available submissions, that the government took no issue with the role of the IPCC and its articulation of the best available science. So I feel I can answer your question that way.
Sure. Thank you. That's helpful. And I guess looking at what the IPCC has said about 1.5 degrees, which the ICJ has essentially ruled on, saying that states have an obligation to be sort of in line with that. The last IPCC report states with high confidence, which we know in sort of science speak is an incredibly high degree of certainty, that future CO2 emissions from existing fossil fuel infrastructures without additional abatement already exceed the remaining carbon budget for limiting warming to 1.5 degrees Celsius. Does it follow then that we have a legal duty to not approve new fossil fuel projects if just the existing ones breach the 1.5 degree obligation under the ruling?
Senator, I hope you'll understand that while I was trying to be helpful in relation to your last question, I feel to answer that question would be to provide the committee with legal advice, which would not be appropriate for me to do. So I'll have to leave my
Sure. Have you provided legal advice on that particular matter to DQ?
Senator, again, we wouldn't disclose the particulars of the topic on which we would give advice. I'm just a bit cautious.
Sorry, why is that?
Because it could disclose the advice itself. So,
what's wrong with that?
Well, it is not our role to provide legal advice to the committee or the public. It's to provide advice to the government, and that legal advice is confidential and privileged.
Sure. I guess I'm just trying to find out if you've given that advice. I don't want to know what it says, but you can't even tell me if you've given legal advice on this. I'm just trying to. I'm genuinely trying to understand what the problem with that is.
Perhaps I should have led with the helpful part of the answer to your question, Senator, which is I can confirm that we have been engaged with DQ since the delivery of the advisory opinion in providing them with advice on various aspects of the government's policies in relation to climate change. And we've done that over the course of a few different advices, and we continue to provide them with advice.
And does that include the ICJ opinion?
I should say specifically in relation to the ICJ advisory opinion, yes.
Which ministers has the department briefed on the ICJ opinion?
So I couldn't tell you which ministers other departments have briefed, but I can tell you that throughout the proceedings, we in the Office of International Law provided various submissions to the previous Attorney-General. We've also kept the current Attorney-General and her office up to date on the advisory opinion and its implications.
Okay. Thank you very much.
Thank you, sir.
I've got some questions on FOI to finish, if that's all right. Thank you for that. Thank you. I was keen to just pick up on a question I put on notice about Commissioner Holmes' closing observation about Section 34 being repealed, and whether or not that was a recommendation. You came back on, so what is it, SBE 25032. You came back on notice saying that it wasn't a formal recommendation, it was just an observation. And I'm interested, I think there's people involved in the Royal Commission on the record saying that it was actually meant as a recommendation, but be that as it may, why are the proposed changes to the FOI Act, directly contrary to the final observation of the Royal Commission?
Senator, I apologise. At the moment, I can't see in my pack that I've got that specific one, but I'm getting it. Thank you.
I guess the Quan's maybe not as important as
yeah, I think this is answered by someone else in the department. So, is it possible for you just to repeat the question for me? Sorry.
Well, so you're saying that the final observation of the Royal Commission isn't a recommendation; it's just an observation. Be that as it may, why are you going against the final observation of the Robodebt Royal Commission with the new FOI sort of bill that's before the Senate?
So I think Ms Moran can talk to you about the position around cabinet confidentiality.
We can, Senator, and as I said, while I hadn't seen that answer to the question on notice, I think at the time the government response to the Robodebt Royal Commission articulated why it didn't support that observational recommendation, however it's framed, and that went to the requirement for cabinet confidentiality and to ensure that that was upheld. And I think the Attorney General has answered similar questions, as I understand it, in the other place as well. I think specifically, the Australian Government's response to the report of the Royal Commission, the government noted that it believed it was critical that the Cabinet, the key decision-making body of government, is comprehensively informed in its deliberations. They said to achieve this, the Cabinet must have the benefit of frank and fearless advice from ministers and senior public servants. The principle of collective responsibility requires that ministers should be able to express their views frankly in Cabinet meetings in the expectation that they can argue freely in private while maintaining a united front in public when decisions have been reached. And so the government didn't support the repeal of Section 34 as was recommended.
Yeah.
And so I think the FOI bill is not changing from that government position.
Okay. I guess it seems like the Royal Commission's view was contrary to that, where they didn't see any evidence that they would actually reduce the frank and fearless advice that was being given. During the bill inquiry into the FOI Amendment Bill 2025, the APSC provided evidence where they said, these are threats that have been levelled against FOI officers, and they read off sort of this fact sheet type thing. I'm aware that one of the ones they referred to wasn't actually, had nothing to do with FOI. It was actually to do with the Comcare claim. When I asked APSC about this, they said, well, it wasn't ours. We don't have that email. We just were given this sort of quote. And so I'm interested did that come from AGD?
Well, I'm not aware of the specifics of what you're raising, Senator. So I can't answer that specifically. I do know, though, that in relation to the issues that the APSC raised, that they developed that content that they provided both in private hearings and in public forums.
But if they don't have the email, did your department provide examples of abusive emails?
Not that I'm aware of, Senator.
None? Okay. So it's Comcare then? Who's...
Well, I think we'd have to get that from... I think the APSC are the best place to be able to advise how they
Quan was
receive that information.
certainly didn't contain any information. So I'll take that up with them. Thank you.
Thank you, Senator Pocock. Senator Blyth.
Thank you very much, Chair. And I just wanted to quickly clarify just on...
Sorry, I have given you the call, but I just wanted to indicate to officials that we are going to extend by 15 minutes into afternoon tea to allow us to finish with this outcome, and we will return after afternoon tea with the Human Rights Commission. Sorry, Senator Blyth.
No, all good. Just in relation to the line of questioning by Senator Ruston, where she had asked for some questions to be responded to on notice, and that was the approvals that were above $5,000. Sorry, and I'll let these guys come back up. And this is just a very quick clarification, and then I'll hand over to Senator Scarr. But in that financial year, those numbers of where approvals have happened above $5,000, if we can just get that broken down into where it was just a normal trial process, an appeal process, or an appearance in the High Court, so that we can see that broken down. Is that possible?
So, Senator, we'll endeavour to do that, but that's a slightly more complex inquiry going through the data.
And Senator, I think the only other thing we'd add is that to the extent that might identify individual matters, we'll obviously have to consider those same issues about confidentiality and commercial in confidence.
Yeah, I'm sure you can understand where we're getting at is that obviously paying for expertise in the High Court is quite a different matter to just paying someone above the commercial rate in a regular trial scenario. So that if that gives you some background as to why.
We will tackle that and see if we can break it down in that way.
Fantastic, thank you.
Senator Scarr.
Thank you very much. Crown and Clark, number 9. Ms Chidgey, I'm sure you weren't involved in Crown and Clark, number 9, or else it wouldn't have had that outcome. I have a lot of confidence in you.
Senator, so we're aware that it's Commonwealth Director of Public Prosecutions led prosecution, and that they've appealed the judgment, so we'll obviously be a bit careful about making public comment. What I can say...
Not that anything we say here would have an influence on the Queensland Court of Appeal, I can assure you, but anyway, go on.
What I can say is we've also had engagement with the Australian Taxation Office, and so we... obviously, you might want to put further questions to them, but we know that they are considering the implications of that judgment and arrangements within their agency.
When did the Attorney General's Department first become aware of the case? How did it come to your attention following the judgment?
Yeah, so I'll just ask my colleague, Mr Ng, to talk about that.
Senator, we became aware of the engagement following the ATO notifying us of the case. Okay, and when did they do that? I'll take that on notice, Senator, but it would have been very shortly after the decision. Sorry.
Is it in October?
It would have been in October.
To check the precise date.
Okay. Do you know whether or not it was before or after the Assistant Treasurer stated that he was aware of the case, and that was on 7 October. Are you aware whether you're informed before the Assistant Treasurer made a public announcement or after?
We'd have to check.
Okay. Have you given any advice to the Assistant Treasurer or to the Department of Treasury in relation to the matter?
Our engagement's been with the ATO.
Just with the ATO?
Correct. That's correct, Senator.
Okay. All right. Have you had any engagement with the CDPP?
Senator, I've not personally had any engagement with the CDPP on the matter.
Has anyone from the AGD had any engagement with the CDPP? Because they are quite shocking findings by the judge at first instance?
I have not, Senator.
No.
No.
Has any... Well, why not?
I think obviously we are aware to some degree of the matter, and as Ms Sheehan noted, that we have engaged with the ATO. To date, we haven't engaged with the CDPP. I think I'd probably just need to look into the matter in a bit more detail.
Yes. And I think the CDPP are appearing, but generally, because they're run prosecutions entirely independently, we normally wouldn't engage with them on the conduct of prosecutions.
Okay, but you recognise these are quite extraordinary circumstances where the judge found, I quote, "I find that this conduct offends the integrity and functions of the court, particularly so when I consider some of this false evidence was relied on at both committals and is proposed to be relied on at the trial. A stay should only be ordered in an exceptional case. I find this is such a case," end quote. So the judge themselves is calling this an exceptional matter. Does that heighten the sensitivity from the Attorney General AGD perspective in terms of engaging with the CDPP to try and get some sort of explanation as to whether or not the appropriate checks and balances were in place to pick up the false evidence that's been referred to?
I mean, I think we've mentioned that the CDPP are appealing in the matter, so can't comment beyond that, but it's then probably questions that are best directed to the CDPP.
Okay, so the CDPP is independent to an extent or wholly from the AGD? How would you describe the relationship between the CDPP and the AGD Secretary?
They are an independent agency, and obviously we take very seriously the independence of their prosecutorial decision making. They're a portfolio agency, so we engage with them though around a broad range of issues, and I think where there are matters that warrant a discussion between either myself and the head of the agency or more generally with the department, we do that from time to time. So I note the issues that you're raising.
Okay. I just want to quote to you from the summary of the judgment. The court finds that numerous no-case submissions were made by the defence to the CDPP to discontinue the state fraud charge, which were not responded to or responded to in any meaningful way. The court finds that there was no case to answer on the state charges particularised. The court also finds that the state fraud case was continued by the BA for a collateral purpose, namely for the recovery of their money, BA referring to an organisation involved in the case. The charge was discontinued in May 2021. So the judge has raised the particular concern that there were repeated submissions of no case to the CDPP, but there was no meaningful response to that. In the context where you've got the respondent dealing with the might of the Commonwealth, the ATO, in relation to such a case, doesn't that raise issues with respect to the model litigant rules?
So I haven't had the opportunity to discuss this at all with the CDPP, so I'm very conscious of not forming a view. I think that you've noted some comments that have been made in judgments that I think we would look at, and I would want to engage with the CDPP to understand the issue from their perspective.
And Senator, the only thing I'd add is that the CDPP operate in accordance with the prosecution policy of the Commonwealth, and those are the criteria about public interest, sufficiency of evidence, under which they make their prosecutorial decisions.
Right, so there are all sorts of issues arising under that policy as well in the circumstances of this case. Who's got oversight of the CDPP in relation to these issues? So in terms of compliance with the policy they're meant to comply with?
So they're ultimately answerable to the courts in this matter, and I think, Senator, because they've appealed and it's still before the courts, it's difficult to comment, but I do note the CDPP is on later today.
Oh, well, I'm sure they're going to be looking at it very, very carefully. I hope they are, because I'll be asked some questions about it. Can I... sorry?
Just flagging final questions, Senator Scarr, before I rotate the call.
Oh, I've got just... If you just give me three quick questions, I might be able to wrap this matter up.
Very
with that
indulgent.
invocation from the chair. Constitutional law, who's responsible for constitutional law?
We will ask the relevant officer to come to the table.
It's been waiting
You did
there,
ask that earlier.
Yep.
Yeah.
waiting for the call.
I'm just defending that you did ask that earlier.
Constitutional law question.
Oh, okay.
Pending your right to ask it over here.
Yeah.
He was very upfront about that.
All right, so I'll be very direct in my questions. I can't meander.
Appreciate it, Senator Scarr.
Mr Lewis, what advice did your office give to the Treasury Department with respect to this complete cock-up with respect to the $2.28 billion payment to the states under the energy rebate arrangement, which infringed Section 83 of the Constitution because they didn't have the appropriate authorisations in place? What role did your office have in this?
David Lewis, General Counsel, Office of Constitutional Law. Thank you, Senator. I understand the issue you're raising. It was reported, I think, in the Treasury annual report. You appreciate that I wouldn't disclose, as we previously discussed, any advice that we gave.
Sure.
I would say our office is responsible for constitutional policy, so we wouldn't ordinarily be advising on whether there was a breach of the Constitution in a particular case. As you recounted in your question, I think that the issue here was about whether or not the legislative requirements for payments were met. So even though it's described as a breach of Section 83 of the Constitution, the underlying nub of the issue was compliance with the statutory conditions, as I understand it, and the annual report does indicate that Treasury has put in place arrangements to ensure that doesn't happen again.
So, Mr Lewis, you seem to know quite a bit about it, which is, I know you're extraordinarily well read, but have you had any engagement? Has the department had any engagement with the Department of Treasury in relation to this matter and how to make sure it doesn't happen again and the importance of it?
Senator, I would say I've had some engagement with lawyers who are in the Treasury, but ultimately issues like this that are to do with compliance with the legislation are a matter for Treasury, and as I said to you, as appears from the annual report, Treasury has indicated there that they've put in place arrangements to ensure it doesn't happen again.
So at what state, my last question, so I'm interested to know in particular the involvement of the Attorney-General's Department in relation to this set of circumstances, which were quite unfortunate. I recognise it was rectified after the event. So interested to know at what stage that engagement occurred between the Attorney-General's Department and Treasury, in particular, whether or not it occurred prior to the matter being rectified, after the matter being rectified, prior to new processes, Q&A processes being put in place to make sure, or try and make sure it doesn't happen again, to mitigate the prospect of it happening again, or after those processes?
Senator, I can only answer for the Office of Constitutional Law, and I'm saying that because I'm also aware that agencies often seek advice from the Australian Government Solicitor in relation to constitutional matters. And of course, if there were to be questions about that, that would be a question to ask Treasury as the one who would have asked for any advice if they did. But from the point of view of the Office of Constitutional Law, I've only become aware of it after the publication of the annual report.
And was that what triggered you reaching out to them, or did they reach out to you?
That's what prompted me to contact them.
For what purpose?
Just to understand the issues.
For what purpose?
You're asking me what the department has done in relation to...
but why I'm interested... Well, when I started on this chain of inquiry, I was interested to know whether or not they'd reached out to the department to get some assistance. From your answer, Mr Lewis, you're telling me that you reached out to the department after the department published its annual report, so you only found out about it through the annual report when it was presumably reported in the media. I suspect you're not trawling through the annual report. So my question is, what was the purpose then of you responding to them? Because, as you said, your office deals with policy issues.
Thank you, and I will share the call after the answer to this question.
Thank you, Senator. I just wanted to know some information about the circumstances in slightly more detail than was appeared in the annual report.
Okay.
Thank you, Senator Scarr, indicating that it's likely to go to afternoon tea at about 3:20, approximately 3:20. Senator Shoebridge.
Thanks, Chair. We've got you, so it's just a shuttle door. Have you been approached by the NAC for any constitutional legal advice?
Senator, as I said, we wouldn't usually provide constitutional advice. That would normally be the Australian Government Solicitor.
All right. And so, the best of your knowledge, is that the answer no then? No, and you wouldn't expect to? Is that it?
No, I wouldn't expect to provide advice to the NAC. I wouldn't expect to provide constitutional advice to anyone.
All right. And have you reached out to the NAC on any constitutional matters?
No, Senator.
Okay, thanks, Mr. Lewis. Secretary, do you remember at the beginning I asked you some questions about Dan Duggan and Safrine Duggan?
Yes, I do, Senator.
Did you get an answer to any of that?
I think we can assist with some information relating to that. We looked into the matter, and I think Ms Chidgey or one of our colleagues will come to the table to assist.
Yep. I know I asked questions about both attorneys. The previous attorney did respond to Safrine Duggan's letters. I suppose, if given the amount of time, if we could focus on what the current attorney has done.
Good afternoon, Senator. Susie Williamson-Jeffreys. I'm the Acting First Assistant Secretary of the International Cooperation and Human Rights Division. So the department's responded to a range of ministerial correspondence from Mrs Duggan to both the Attorney-General and the Prime Minister. The department generally does respond on behalf of ministers where the correspondence relates to matters before the court or before the minister for decision. Most recently, the department's response was sent on the 31st of October this year.
So is there an explanation for why? I mean, these are very personal requests. The previous attorney responded in person. This attorney is not responding. Is there a change in policy? Is this a position that's been changed?
I don't think so, Senator. No, it's just it's the stage that the matter is at. So last year it was before the Attorney General for decision, and now Mr Duggan has sought judicial review of the Attorney General's decision and the matters before the federal court.
All right. Well, if you perhaps on notice can provide, as far as you understand, the dates on which correspondence was directed to the current and former AG, and if you have it, the Prime Minister, and the date on which responses were done, and whether who provided the response.
Yes, of course.
Just given the time. Secretary, I'm advised that when this was last in the federal court in October, that the attorney had 10 legal representatives present in the courtroom, including a very highly paid King's Counsel. And indeed, there were so many legal representations for the state that the Duggans were limited to bringing a maximum of 4 people into the room. How many legal representatives were there for the attorney in the October hearings? And was it 10, including a King's Counsel?
Senator, I think we would need to take that on notice. in terms of that very specific detail, but we can do that.
Even if it's close to 10, can you provide can you provide the number of legal representatives, the number of whom were barristers, any of which, and the number of whom were senior counsel, King's Counsel? Could you provide that on notice as well for that hearing?
Yep. Yes, we can.
On the assumption that this is accurate, that there were 10 legal representatives, can you provide any justification for it on notice? And if it's 9 or 8 or 12, can you provide a justification? And then if you could also provide what the costing was for that hearing.
We'll endeavour to provide as much information consistent with the questions you've asked.
Thank you. Just given the time, I'll move on to humanitarian aid reform. I don't know, who does humanitarian aid reform?
DFAT.
Does DFAT do it in conjunction with you when we're looking at the potential criminal prosecutions for...
do you mean exemptions under the criminal code?
Exemptions under the criminal code or exclusions under the criminal code for humanitarian and aid organisations who are delivering life-saving aid in areas where there is a listed entity that has some or all control over the region.
It's under the criminal code. Ms Chigi is best placed to answer.
In the last few weeks of sittings, I know many humanitarian and aid organisations were watching as law reform went through in relation to some aspects of the humanitarian aid code. Some of this was in relation to the changing the law to allow the listing of additional organisations. But in the course of that, pretty much every party in Parliament showed a willingness to amend the law so that humanitarian aid organisations are not inadvertently caught when they're providing life-saving aid. Is there a project on foot inside the department on this?
Senator, I can say we are giving consideration to those issues and consulting within government and with the humanitarian sector. So there are some defences already, but we're aware of concerns and requests for broader exemptions and are giving consideration to those issues.
I think it's part 5.3 of the criminal code where most of these offences are found. Does amendment there require consent from states that referred powers to the Commonwealth? Is that part of the reform process?
Yes, Senator. So amendments to Part 5.3, we do consult and seek agreement from states and territories.
Has there been any initial consultation with states about potential reform? If not, why not? And is there a timetable?
So not as yet, Senator. We would usually consult them when we have more specific proposals and we're considering those issues within government and what might be appropriate, because they're obviously complex matters about what would be appropriate for any further exemptions.
Given I think pretty much the overwhelming majority of parties in Parliament indicated willingness to engage in reform in this space to protect humanitarian organisations. Secretary, has there been any prioritisation given to this reform?
Well, in the context of a lot of work that's done within this area of the department, both legislatively, both in terms of legislation and policy, the fact that they are working on it now indicates a certain amount of priority to engage within government, within the federal government, with relevant agencies. So I think I can say that the matter is being taken seriously, and we are looking at what possible reforms could be taken forward.
I know that NGOs are particularly keen to get this reform done as soon as possible. Would you take on notice whether or not your department would be willing to bring the NGOs in for a meeting to discuss the next steps and process?
Happy to take that on notice, but generally we're always happy to engage with
super
civil society
happy to
organisations. So perhaps I don't even have to take that on notice, because I can say we will engage with them.
Well, you put the kettle on and bring the biscuits, and they'll be there to try and work out when this happens. All right. The legislative response to the Modern Slavery Act review, who's that, Dean? I'll start by putting the fairly obvious concerns. It's been, I think, 3 years since the review was announced. Stream A consultations concluded in September. Is there a timetable for draft ledge?
No, Senator. There's no specific time for draft legislation, but we are undertaking a very comprehensive consultation process on the specific proposals from the statutory review, and I can ask my colleague, Ms Wang, to talk in further detail about that.
Sorry, just because we have limited amount of time, I think it was May, not last year, but the year before, that the Macmillan review was tabled with 30 recommendations. I mean, the sector who are here, Be Slavery Free, the churches, you know, those entities that are asking for reform have been waiting more than 2 years for a substantive response to some of those key recommendations from the Macmillan review. What do you say to those organisations? What should they be looking for?
Senator, I'd say that the modern slavery team is doing a lot of detailed work with those organisations through public consultation processes, and I think for the first phase of consultation, as at the 29th of October, we've got around 180 online and written submissions that we're working through. That includes civil society groups and other sectors as well, who've provided input on more detailed options for responding to that review.
Minister, is your government committed to delivering legislative response, a comprehensive legislative response to the Macmillan review on modern slavery this Parliament?
Look, I don't specifically know the answer to that question, Minister, but Senator, what am I saying? Promoting you way above your status.
It's not a task I've ever wanted.
It's what?
It's not a job I've ever wanted.
Oh, seriously?
No, seriously,
I mean,
it looks soul-destroying.
Wanting to solve all these, problems.
It's utterly soul-destroying.
But can I say this? The Albanese government is committed to strengthening the Modern Slavery Act. The department is currently undertaking a comprehensive consultation process. On the 1st of September 2025, public submissions came to a close for phase 1 of the consultation process. Phase 2 of the consultation process has now begun, with stakeholders across civil society, government and business invited to participate. Phase 2 of the consultation process will focus on a due diligence model and high-risk matters. These consultation processes will play an important role in formulating the government's position on how best to reform parts of the Act. Yeah.
All right, thanks, Minister.
So I think that's probably as far as I can go at the moment.
Well, perhaps you could take on notice on advice from the attorney whether there is a commitment to get those reforms in this parliamentary term.
As I can. Thanks, Senator.
Chair, I have a very small compass of questions on behalf of Senator Waters in relation to settlement negotiations and non-disclosure agreements.
You've got 2 minutes remaining on my clock.
All right. Well,
sure.
It would be great to get this finished and then move on after afternoon tea. Ministers, Senator Waters has been asking a series of questions to your department on notice. and also in previous rounds
Just
of
a question
estimates.
to me, Senator.
Oh, sorry, I meant Secretary. Sorry, Secretary. The Legal Services Direction requires the Commonwealth to act as a model litigant. Several people who have been involved in harassment and bullying claims against Commonwealth departments have told Senator Waters that their experience dealing with departments was re-traumatising, particularly regarding delays in handling their claims, failure to update on process, low settlement offers and generally being dismissive of their experience. Does your department record and log complaints about either your department or other departments being in breach of the model litigant rules?
I will ask Mr Ng to assist with that. Obviously, I think you are aware we do play a role in collating any reporting around the model litigant rules. So.
Thanks, Senator. That's correct. The department does have a role in, supporting agencies to comply with the model litigant obligations. It's an obligation that relies on agencies, that involves agencies accepting that they have the responsibility to comply with those obligations, and they do report to the department, to my area, the Office of Legal Services Coordination, about any possible or alleged breaches of the directions, which would include model litigant obligations.
So, could I ask you, going back 4 financial years, and including this partial financial year, the number of complaints that have come to your office regarding breaches or alleged breaches of the model litigant rules?
Senator, I just want to be clear on the answer to that, so I'll take that one on notice and come back to you on the exact number.
Can you also break it down by department or agency for each of those financial years or this partial financial year? And do you have some kind of record of what's happened to those complaints? Have they been upheld? Have they been not? Do you keep that data as well?
Certainly. I can undertake to have a look at what we can do in terms of the identifying in the broad the agencies who it relates to. Obviously conscious of where it may be small numbers, not necessarily being able to identify specific matters, but appreciate that's and also actions that have been taken. So the agencies would notify, as part of their agency notification forms to our department, actions that they are undertaking to rectify potential or investigate and where necessary rectify non-compliance with the directions.
If you could provide that detail on notice, I'd be really grateful. Secretary, in answer to question on notice, usefully numbered SBE 25-122, you advised Senator Waters in relation to non-disclosure agreements that while the approval of the Attorney-General or the delegate is often required to settle a matter, and then I'll quote, "The department does not require agencies to provide copies of final settlement agreements. The relevant entity remains responsible for managing and settling the claim within the parameters of any approved settlement terms." As you would be aware, there are very real concerns, particularly where there's allegations of misconduct, about non-disclosure agreements being used by agencies and departments to silence dissent and to pay for silencing dissent. If you're not getting copies of the final settlement agreements, how can you be sure that NDAs aren't being used?
Well, I think it goes to that issue in terms of seeking agreement around the broad parameters. But perhaps Ms Chidgey can provide some more detail.
And sorry, Ms Chidgey, while you're doing that, if you might, just for the matter of time, if you could address, is there a firm policy provision on non-disclosure agreements and non-disparagement clauses? And if so, what is it?
Senator, I'll get Mr Ng to talk about what we see as part of settlement approval processes. There are policies around non-disclosure and confidentiality clauses, and for sexual assault and workplace harassment claims in particular, the policy is generally not to seek confidentiality and never to seek confidentiality in a way that would prevent a complainant from telling their story. and we follow the guidelines on the use of confidentiality clauses that was produced by the Australian Human Rights Commission in that respect.
So when you say generally, could you, perhaps because we've run out of time, can you provide on notice what that qualification means generally? And can you also answer the substantive concern, which is if you're not checking the final terms of these settlements to see whether or not an non-disclosure or non-disparagement agreement has snuck in, if you're not checking, how do you know? How do you know they're being complied with?
Senator, what I might just set out very briefly in the broad is just that the legal services directions, which the Attorney administers, really do provide for transparency in Commonwealth settlements as the default approach, and really confidentiality is only to be sought in where necessary to protect the Commonwealth's interests. And so in exceptional cases, the Commonwealth may seek limited confidentiality if this is necessary to protect its interests. The matters that we see, that my branch would see within the department, are reported to us as significant legal issues. So as you know, it's a subset of the broader legal issues that an agency may encounter. But these are obligations because they're under the legal services directions that apply to all Commonwealth, non-corporate Commonwealth entities. And so they would apply across the board. I'm happy to take on notice any further questions you have, noting the time, but or answer other ones you might have.
And of course, what one agency may think is protecting core Commonwealth interests may be actually protecting my secretary, protecting the department, protecting the Commonwealth from scandal, embarrassment or other damage that may come if the material gets out. So it's in that context that people have for decades been anxious about NDAs and non-disclosure agreements.
Thank you, Senator Shoebridge.
I was just going to add that if it was reported as a significant legal matter, then the settlement would need to be approved by the attorney or their delegate. So the reasons why, if an agency was seeking to include a confidentiality clause, they would have to justify that, and that would be part of our consideration.
Perhaps in the answer you could declare whether the extent to which particularly bullying, harassment and other similar claims fall within the definition. That would be useful.
Thank you, Senator Shoebridge. And that concludes our time with Integrity and Security Group and with the Attorney General's Department. So thank you very much to the Secretary and your officials. We will now break for afternoon tea, and we will return at 3:40 with the Human Rights Commission. Broadcasting. And we are returning with the Australian Human Rights Commission. Welcome to Legal and Constitutional Affairs Committee. While the call is with me, I'd like to especially welcome the National Children's Commissioner, Ms Deb Savaris, for her first appearance at Estimates as well. President, would you like to make an opening statement?
Got a brief opening statement. Thank you, Senators. I acknowledge the Ngunnawal and Ngambri elders and ancestors, their ancient and ongoing culture and their unbroken connection to the country that we're meeting on today. Senators, some of the key issues that the Commission is currently focused on include highlighting the need for the reform to the Disability Discrimination Act, which is currently being reviewed, as well as related reforms to improve all of our national discrimination laws. Finalising two major projects to address racism in Australia, the Racism at Uni Survey and the Seen and Heard project, addressing the backlog in our discrimination complaints and preparing for the upcoming United Nations Human Rights Council review of Australia's human rights record, known as the Universal Periodic Review. I want to take this opportunity to welcome the new National Children's Commissioner, Deb Savaris, who joined the Commission last month. She brings deep expertise in child, family welfare and human services and is ideally placed to champion children's rights in Australia over her 5-year term. Finally, I want to acknowledge that Australia has just granted its 1 millionth humanitarian visa since the end of World War II. This reflects a long-term humanitarian commitment by our nation to provide a new life in safety and freedom for refugees and their families. People receiving these humanitarian visas receive support from highly regarded settlement services. They have made immense contributions to Australia in many fields. While parts of our refugee laws and policies continue to raise serious human rights concerns, the granting of our 1 millionth humanitarian visa is a major human rights milestone that should be celebrated. We look forward to today's dialogue with the committee. Thank you.
Thank you, President. Certainly a milestone worth celebrating. Thank you very much for drawing that to our attention. I'll share the call, and Senator Blythe.
Thank you very much, Chair. So my questions are for the Sex Discrimination Commissioner. Thank you. So my questions are relating to the United Nations office holder that you sought to block. Do you see that as a function of your role as Commissioner here in Australia?
Senator, my role is as the Sex Discrimination Commissioner to advocate for gender equality and also for the rights of LGBTQI+ community. My role in relation to the Special Rapporteur on Violence Against Women is to observe what work she does. I think what you're referring to is me seeking advice from the Chief Executive about her appointment.
That's correct. So you do see that as your role as the Sex Discrimination Commissioner?
Senator, my role is to seek advice from the Chief Executive if I'm unclear about a particular aspect and about her appointment or reappointment. My greater role, as I just referred to, is to advocate for gender equality within Australia and also for the rights of the LGBTQI+ community.
Okay. So, I would put to you that it would be inappropriate for a Sex Discrimination Commissioner to interfere in UN appointments and not within your remit. So you were basically saying it is within your remit and you don't agree with that?
Senator, I refer to my previous answer.
Okay. At a previous Senate estimates hearing, you stated that you didn't understand the term biological man. You've now had some time to look at that. Do you now have a definition for biological man? What's your understanding of it?
Senator, I'm not a medical expert. I'm a human rights advocate. As I've just said, I advocate for gender equality and for the rights of LGBTQI+ people. That's my role under the Sex Discrimination Act.
Do you accept that there's a clear criteria that exists to distinguish between male and female?
The Sex Discrimination Act does not define man or woman. It has an inclusive definition of women that includes all women, so that is First Nations women, women from culturally and racially marginalised backgrounds, trans women, lesbians, women with disability.
So how would you define a man?
It's not defined under the Sex Discrimination Act, and my role, as I've said, is to uphold gender equality under that Act.
So you can talk about what a woman is and what do you think a man is?
Senator, all the same definitions that I've just given in relation to women. So First Nations men, men with disability, culturally, racially marginalised men, and gay men and trans men.
Okay. Do you recognise that there are biological men and women?
As I said previously, Senator, I'm not a medical expert. My role is to uphold...
So you think you have to be a medical expert to be able to recognise whether there's a difference between a biological man and woman? Is that what you're saying? So only medical experts can...
As I said, my role is to uphold the Sex Discrimination Act. It's not defined what a man is and what a woman is within the Sex Discrimination Act.
Okay. Do you consider that a person can change their sex?
Under the Sex Discrimination Act, it makes it unlawful to discriminate on the basis of gender identity, on intersex status, and also on sexual orientation.
So I haven't asked that.
Anticipates.
I've asked sex. So that's very tight. Do you consider that a person can change their sex? I'm not talking about gender.
Correct. The gender identity?
No, I'm not talking about gender. I'm talking about sex. Do you not see that there's a difference between those two?
So under the Sex Discrimination Act, it's not defined what gender identity is, or under the Sex Discrimination Act, what sex is. So that's the guiding legislation for the human rights implementation within Australia.
So I guess, so do you consider that a person can change their sex, yes or no?
Under each state and territory, there is legislation which enables someone to change their sex on their birth certificate or on any legal document. So under state and territory legislation, they can change their documentation which recognises that they have changed their sex.
So you consider a person can change their sex?
Under state and territory legislation, people are able to change their documentation so that their sex marker is different from what it was as assigned at birth.
So which state and territories are you referring to?
All states and territories throughout Australia.
Okay. Do you acknowledge that the Sex Discrimination Act was first enacted primarily to deliver, as far as practical, substantive equality between men and women, as those terms have been traditionally understood?
The Sex Discrimination Act was enacted to give effect to the Convention for the Elimination of Discrimination Against Women, and the aim of that convention is for substantive equality between men and women.
Can I ask how you, as Commissioner, can advocate and stand up for the equality of women if, under your own evidence here today, anyone can be a woman? So how do you protect and advocate for what you can't define?
My role is to advocate for gender equality, as I have been doing over the last 2 years, holding consultations around women's experience of workplace sexual harassment, advocating around domestic and family violence, advocating around sexual violence. That is how I advocate for women.
Do you, and I guess your definition of a woman there though, is anybody can be a woman. So if anyone can be a woman, how are you advocating for a group if you can't actually define who they are, and they could be anyone?
I refer to my previous answers, Chair.
Okay. So do you think then if all men can be women and all women can be men, it's completely interchangeable and fluid, does sex discrimination exist?
Sorry, Senator, I'm just going to suggest that I don't think I heard the Commissioner express her personal views on this, in relation to your questions. I think she's outlined some responsibilities under that are her responsibility. So I would just suggest that you not verbal the Commissioner in terms of what it is that she's said here today. I haven't heard her give that evidence today.
Okay, so if the Act doesn't define using biological sex. And so men can be women and vice versa. Does sex discrimination exist?
We know that sex discrimination is an ongoing and serious issue within our community, as evidenced by the high rates of domestic and family violence. We know that one woman dies every 8 days in Australia currently. So that is an expression of sex discrimination throughout our community, as is the experience of 1 in 3 workers of workplace sexual harassment, as is the experience of sexual violence across our community. So absolutely, sex discrimination exists in our community, and that's why the work that I do and that the work that the Commission does is particularly important.
Can I ask, based on the Sex Discrimination Act and the definitions that you've given, how do you know that they're women that are dying?
The statistics that are collected by a range of agencies, including the Australian Bureau of Statistics. Each state and territory also has a body that collects statistics, and they are the organisations which would define the gender of the person that they're collecting statistics on.
Okay, thank you. I now have questions for the National Children's Commissioner. Just a quick. Thank you. Welcome.
Thank you so much.
This is only weeks into your
11 days.
11 days. We haven't even got into multiple weeks. I just wanted to ask, and these are very brief questions. The outgoing Children's Commissioner, Anne Holland, stated that Australia's lack of success responding to youth crime is due to a lack of government accountability for evidence-based action. Mm-hmm. Is that a position that you maintain as 11 days in?
Thank you. My name is Deb Zavaras, just for the record. Thank you for your question. The Help Way Early report is a fantastic piece of work that my predecessor undertook in her time at the Commission. There's definitely a growing concern around the country around very young children being incarcerated as a matter of course. All the evidence suggests that these are very harmful policies and not backed by evidence. As I said, the previous Commissioner's work is remarkable and outlines some ways forward. There's a supplementary paper which is called the Evidence-Based Approaches to Child Justice, which outlines 3 very good examples of some things that we could look to in Australia that works for not just families and children but their communities. So I would refer the committee to that. It's published and available so that we can intervene early, prevent children coming in contact with the criminal justice system and being further criminalised. So I have fairly strong views about this. I suspect lots of people do in this room, and we really need to make sure that we do not continue to breach the human rights of children in this country.
Excellent. And just going into, and these will be my last 2, just going into foster care, is it still your view that cost of living pressures are still a major barrier and issue when it comes to having foster carers for children in the system?
Thank you for that question. It's nice to be asked a question about foster care. There's definitely an issue for those who want to become foster carers or even kinship carers in this country, that they are afforded special treatment in terms of additional financial support in order to do that really important work. Yes, I do believe that's the case.
Excellent. Thank you very much. Thank you, Chair.
Thank you, Senator Blythe. Senator O'Neill. Thank you very much indeed. And I've got 4 lines of questions. The first ones I'd like to direct to you, President De Cresta. So, complaints handling is a critical part of the work that you do. Could you give me an idea of how many complaints of discrimination the Commission receives each year?
Yeah, right, close to 3,000 complaints a year.
Close to 3,000, and it fluctuates a little above and below?
It was around 2,800 last year, which is about a 3% rise from the previous year.
Okay, and the 2,800 number, does that relate to calendar year or financial year?
Financial year.
Okay, thanks. And what about the previous year? You said it went up by 3% in 2025, is that correct?
24-25. So
Yeah.
if you take a sort of long-term look at it, we saw a big spike during COVID, and then the complaint numbers dropped to a new normal, which was about 30% higher than the pre-COVID level. And so there's been increases in certain types of complaints, disability complaints, around 47% of the complaints that we receive. Sex discrimination complaints are going up, race discrimination complaints are going up.
Great. I might interrogate that a little more.
Sure.
The trends that you're observing in the volume and the type of complaints. So if you can just sort of walk me through that slowly. Obviously, we had a reset of everything after COVID,
right,
and not everything went back to the way we would hope. So people's anxieties are obviously at a different level. So what's the trend that you're seeing now with particular areas? Disability you mentioned.
Disabilities typically have been the area most complained about in terms of the complaints that we receive. We're certainly receiving more complaints around psychosocial disabilities, people who are neurodivergent, for example. In COVID, there was big spikes in disability-related complaints around vaccination mandates and the like, but setting that aside as related to the pandemic, that trend of increasing disability complaints and increasing complexity of disability complaints is one that has been strong.
So do you have some numbers and percentage lifts?
My colleague, the Chief Executive, has just shown me the numbers from the previous year. Yeah, it was 47% disability last year, 22% Sex Discrimination Act, 18% Racial Discrimination Act, and 5% Age Discrimination Act, and then we can receive complaints under the Australian Human Rights Commission Act as well, which formed 8% in 24-25.
8%, okay. And in terms of trends, you said 47 was an uptick for the disability, mainly psychosocial. So of the 47%, how much was psychosocial?
I would need to take that on notice and happy to do that and come back to you.
Perhaps I'll notice the trends rising.
Again, I'm helpfully being shared with the disability. So mental health psychosocial was 21% last year in 24-25, neurological disability 18%, physical disability 13%, assistance animals 6%, and medical condition generally was 16.5%.
Thank you very much.
That's all under the Disability Discrimination Act.
Okay, that's well, disturbing. Any kind of discrimination, very disturbing, but there is some interest in why this is occurring at this particular point of time. I understand that you also have a function to look at matters relating to systemic discrimination as a result of the current government's Respect at Work reforms. How often have you used that particular function?
Are you talking about the positive duty?
Yes.
Yes, so the positive duty function is a new regulatory function that the Commission has. That's in relation to the Respect at Work inquiry and report that the Commission did under the previous Sex Discrimination Commissioner, Kate Jenkins. Successive governments implemented all of those recommendations. And so the positive duty team has commenced I think we talked about it at the previous estimates in end of October, 4 inquiries, 72 reports, 35 voluntary engagements. They're the current stats in addition to preparing all the regulatory guidance materials and working with related regulators and the like. And so the positive duty is a new function. There'll be a review of it coming up.
Okay, so the regulatory guidance documents are underway, but you actually have had 72 reports and 45 engagements. So do they overlap or are they separate
The 72 reports is, as I understand it, reports that we've received from individuals about positive duty concerns. So where an individual is reporting potential sexual harassment or sex discrimination around an employer or other workplace issue. So they're separate from the sex discrimination complaints where a person is seeking individual redress for themselves. They're saying there's a problem with this particular employer, and that helps us to decide where to allocate our regulatory focus and resources. We've had, as I said, 35 voluntary engagements with employers, I think representing or having workforce of around 120,000 employees. And we've launched 4 formal inquiries into particular employers, which are ongoing in areas like retail and hospitality and transport.
Okay, so 4 formal inquiries. If I would consider them perhaps to be identification of critical matters that are based on the complaints that you've received. So you just quickly mentioned a couple of areas. Did I hear you say retail?
Yes, so we're focusing our resources on high-risk areas, retail and hospitality in particular.
And what are the issues in, let's just pick that sector alone. What are the issues there, and what actions have you taken as a result? And have you seen any outcomes from that yet?
Yeah, I guess more broadly, when you look at the sexual harassment prevalence work that the Commission's done over a period of time, you're seeing very high rates of experiences of sexual harassment. Around 1 in 3 workers have experienced sexual harassment in the previous 5 years. That's higher for female workers. It's higher for workers from, for example, LGBTIQA+ backgrounds, First Nations workers, workers with disability. The positive duty function tries to shift the focus away from the burden on an individual person having to complain about what's happening in their workplace to a proactive approach like we have for workplace health and safety, where employers have a legal responsibility to take action to prevent sexual harassment in their and sex discrimination and sexism in their workplaces. And so we are we're preparing resources for employers to assist them to prevent sexual harassment and sex discrimination related conduct, and engaging with employers around that, providing information resources, but also those more acute regulatory powers where we can require the production of information for us to make an assessment of whether a particular employer is actually complying with that positive duty.
So in the retail sector, which entities are you working with? Some major companies in Australia?
Yes.
Any representative bodies? Like who's doing this work with you?
Yeah, one of the challenges with the secrecy provisions in our legislation is that when we launch an inquiry, we're not able to talk about the names of the employers that we're formally inquiring into.
Oh, no, my question's not asking you to do that. My question is that, like, I could name Woolworths and Coles and Bunnings without saying you're doing an inquiry into those particular entities, but I would be pretty disappointed if you weren't actually interacting with them in planning and in an iterative way, really starting to get stuff that works in the workplace. So who are you working with? Are you working with the Australian Retail Association in addition to the companies themselves and the unions, particularly the SDA? Like, what's your research team and your implementation plan for that one sector of the 4 that you said you're pushing in?
So certainly, for example, we're holding engagement with major retailers in February next year, I think together with Safe Work Australia, to be engaging with them proactively to say, this is how are you going with your compliance, how can we assist you with compliance, what are the trends that you're seeing in terms of the retail industry, which as we know is a high risk industry. I can come back to you with the names of the specific. I don't want to give
my question is not about who you were inquiring into, it's who are you working with.
I understand in terms of a voluntary engagement where we're working collaboratively with employers to assist them to comply with the positive duty to make sure that their workplaces are safe and free from sexual harassment and sex discrimination and sexism.
And Chair, now that Black Friday has passed, but there's still a lot of shopping to go before Christmas arrives, I'll just take the opportunity to signal the No One Deserves a Serve campaign, which has been running from the SDA for 8 years, and just make sure that all Australians understand that everybody at the shops, the shoppers and the workers, everybody deserves respect, no matter how crazy Christmas might get.
Absolutely. And Senator, I think we're putting out a statement today in collaboration with Safe Work Australia around the need for employers to look after their workers in this busy retail period coming up to Christmas.
Thank you, Chair. I've got a couple more lines of questioning if time allows.
Thank you, Senator O'Neill. Senator Faruqi.
Thank you, Chair. Good afternoon, everyone. I have some questions for the Minister to start off with, and then a few for the Race Discrimination Commissioner and the Human Rights Commissioner. So, Minister, the National Anti-Racism Framework was delivered by the Race Discrimination Commissioner a year ago. Since then, it really has been gathering dust on the government shelves at a time when racism is rising, where white supremacy and neo-Nazis are marching on our streets, and where senators are displaying Islamophobia openly in Parliament. When will the government respond to this framework?
Thank you, Senator, for the question. The Albanese government has made it very clear that there's no place in Australia for racism, hatred or discrimination of any kind, and we unequivocally condemn it. Every Australian, no matter their race, should be able to enjoy their life in an Australian community without prejudice or discrimination. Of course, the Australian Labor Party has always understood and defended the importance of Section 18C of the Racial Discrimination Act in our multicultural society. As to the specifics of your question, this is obviously not my area of responsibility, Senator, and I shall ask the question of the Attorney-General and come back to you as quickly as I can.
Yeah, well, Minister, you're here today representing the Minister. This is a document that's been sitting there for a year. Last week, on the anniversary of the framework, more than 50 civil society organisations wrote an open letter and signed an open letter to the government urging you to fund and implement the National Anti-Racism Framework. They were citing deep racism, deepening racism and its harms. Has the government responded to them? Do you know?
No, I don't know the answer to that question, Senator, but now that you've raised the issue, I shall make an inquiry and come back to you as soon as I can.
Minister, which minister in your government is responsible for anti-racism?
Well, I would say everybody from the Prime Minister down is responsible for ensuring that racism doesn't prosper in this country and that we eliminate all forms of racism.
So you're responsible for anti-racism, but you don't know anything about when the government is going to respond to the framework. Who is actually responsible for implementing or responding to the framework itself?
Well, obviously the Attorney-General has a role in that.
Has a role, or is the Attorney-General the Minister who is responsible for the anti-racism framework?
To you that it's the job of everybody in this government to ensure that racism
Minister, you have no idea who, even in your government, is responsible for anti-racism. Can't be everyone. Can't be responsible for it.
Order.
Yes.
Thank you. So, Senator Faruqi is bringing into play in this committee this afternoon matters that are at odds with the description of your call for behaviours this morning. Now, Senator wasn't there, so perhaps she was unaware that this is going to be done with dignity, civility, fairness and respect. I have no doubt about your conviction, Senator Faruqi, but your civility is absolutely not appropriate. So I would suggest,
so
Chair...
Don't lecture me on civility.
I'm taking a point of order,
If we can just allow that to happen,
and
please.
speaking over people is the problem that I want to identify. So I do not believe it is either civil or respectful to speak over the witnesses. So I will demand, Chair, that standing order be adhered to by all participants. Thank you.
Thank you, Senator O'Neill, and I do remind senators that when asking questions, it is absolutely respectful to allow ministers and witnesses at the table to respond.
Minister, how many MPs and senators in Labor have undertaken anti-racism training? And you could take that on notice. I know you probably won't have the answer today, but if you don't have that, could you please take that on notice?
Sure.
Thank you. Minister, I asked the Race Discrimination Commissioner in the October estimates about the cost of delaying action on racism, and the Commissioner told me that there is a huge cost in terms of people's lives, in terms of society, and in terms of financial cost. So it is a pressing issue. So I guess you said everyone in Labour is responsible for tackling racism. What actions has the government taken on anti-racism, and how much funding was allocated to anti-racism this year?
The exact amount of funding I would have to check for you, Senator. I don't have that information on the top of my head, but can I say this? The government is looking at a framework on this issue in conjunction with the reports, particularly of the special envoys on anti-Semitism and Islamophobia, and we'll be providing a considered response in the very near future. The Attorney-General, of course, is working with Minister Ali on developing a holistic response to this issue.
If I could go to the Race Discrimination Commissioner. Commissioner, as I just asked the Minister, over 50 civil society organisations have formally called on the government to fund the framework immediately. Do you consider the lack of federal funding for a national anti-racism strategy, despite the Commission's extensive consultation with communities, to be holding back Australia's ability to prevent and respond to rising racism and hate?
The government has provided some funding for the National Anti-Racism Strategy on an ongoing basis, but there's not yet been a response in terms of the National Anti-Racism Framework and its implementation. Mm-hmm. And as I've said here before, and I've said publicly before, we think it's really important to have funding to implement those recommendations because of the increase in racism that is pouring out onto our streets in terms of the impact of racism in health, education, workplaces. And we hope to work collaboratively with the government as we go forward in terms of trying to implement those recommendations. But it is certainly a pressing issue. Our structures are broken, and that is why the bile of racism is able to pour out onto our streets so frequently and in such a damaging fashion.
Commissioner, according to the Scanlon report, negative attitudes towards Muslims have increased from 27% to 35% in the last 2 years. And in the same time, positive attitudes have decreased from 24% to 16%. As the Race Discrimination Commissioner, do you believe that Senator Pauline Hanson's burqa stunt last week, which was basically taunting Muslims, to put it mildly, feeds into this attitude?
Well, Senator, firstly, I would say yes, I've engaged with the Muslim community extensively since I came into the role, and it's very clear to me that Islamophobia is increasing, and it's important to understand that if it's not just, Islamophobia doesn't act in a unique way, it acts in a myriad of ways, and particularly it acts in an intersectional way. So for women and women who wear the hijab or who wear the naqib, there is a higher likelihood of racism, including physical violence, and that came through in consultations, and that's come through in, for example, the Islamophobia Register's report. And I raise that because that is connected to what Senator Hanson did, and I've said this previously. I think it was very disappointing because the standard that politicians hold, and particularly in the public arena, and the behaviour that they exhibit is the behaviour that often is seen as what is appropriate for the rest of our society. And so if behaviour is behaviour that mocks or demeans anyone because of their religion, then that is very disappointing because that has a negative impact on people generally, and it will have a negative impact on a young woman in a hijab the next day who's trying to catch the train or go to school or do something like that. So I think it's really important that the behaviour within this institution is of the highest standard because it's the behaviour that others follow.
Chair, I have a few more questions, but I'll wait for the next round.
Thank you, Senator Faruqi. Appreciate that. Senator McLaughlin.
Thank you, Chair. I have some questions on the submission to the Independent National Security Legislation Monitor dated 21st of October. Is that you, Ms Finlay? I note in public discourse there's been some contention around the definition of the view that's been expressed about modifying the view to terrorism. I'm not seeking, my questions aren't seeking to unpack you forming that view. I'm interested in the internal processes of the Commission. You form the view, it goes into it's submitted to the National Security Legislation Monitor, they make their call. When a view like this is contentious and there's various views, is there an internal review mechanism? Is there any subsequent reflection on did you get it right, formally or informally? So that's where I'm coming from with this question.
There's always a reflection mechanism, Senator, because obviously at the Australian Human Rights Commission we always want to make sure that our recommendations and the evidence that we're presenting reflects an appropriate interpretation both of human rights obligations and of the best interests of the Australian community more broadly in terms of protecting and promoting human rights. And certainly in terms of the INSLM submission, our normal practice would be to put a submission in, but then obviously to read through all of the other submissions that are received. Normally there's a public hearing process and both formal and informal mechanisms exist to make sure that we are always reflecting on the things that we say as part of our efforts to best protect and promote human rights throughout Australia.
So where are we at the moment on that continuum? You're waiting for the decision? How does that process roll from this point?
Well, the INSLM would be best placed to answer questions about the process that he's conducting
No, I don't mean his
for that
process.
inquiry.
I mean the submissions have all come in. I'm looking at it from the perspective of the Commission.
Well, I can certainly indicate, and I can't speak on behalf of all of my fellow commissioners, but I personally have read through a significant number of the submissions, some in more detail than others at this stage, and I'll certainly continue to do that as this inquiry proceeds to ensure that if we are asked to give evidence before a public hearing, we do that with a full understanding of what other submissions are saying.
And then if that process obviously takes its own course, and at the end of that process, the Commission has cause to reflect on how it landed on its view, do you make that public, or does the view remain the view until you're asked to formally reflect on it again? I'm looking from the perspective of the evolution of the view. Nothing is cast in stone, maybe two famous tablets, but I'm interested in the continuum of the view of the Commission.
It would depend on the circumstance, Senator. As I'm sure you can imagine, the Australian Human Rights Commission and all of my colleagues, both individually and as an institution, deal with a wide range of human rights issues. And if we were to announce our particular view at any minute of any day on all of those issues, there would be little time to do anything else. But certainly I can say in relation to this inquiry, the view of the Commission was formed after careful consideration. I personally, and I'm sure my Commissioner colleagues as well, are interested in reading and have read many of the submissions that have been made, and my understanding is there will be further engagement with that inquiry as it continues to be led by the INSLM.
No, thank you. No further questions on that.
Thank you, Senator McLaughlin. Senator Scarr.
Sorry. I just wanted to ask a quick question in relation to the positive duty. Is Ms Cody there? So I have a particular interest in this. I was sitting on the Legal and Constitutional Affairs Legislation Committee when we actually looked at the legislation that introduced the positive duty, and we received submissions from a whole range of stakeholders in relation to the matter. Can you give us any insight with respect to what you're seeing happening within organisations, very large large, medium-sized and small with respect to grappling with the issues of the implementing and meeting their positive duty?
Thank you, Senator. And we have been engaged in a substantial education work around the positive duty since we launched the guidelines, as the President was referring to earlier. I would say that from the number of talks that I do and talk about the positive duty and the importance of the role that it has as a preventative approach to workplace sexual harassment and sex discrimination, the large employers, the large organisations, corporations have certainly got the structures in place to deal with it. There are greater challenges with the smaller and medium-sized employers and organisations, which we are trying to grapple with in terms of for example, some of the smaller retailers or smaller restaurants, that the smaller organisations would have a harder time with trying to ensure that they comply with the guidelines, but also are up to date with what their legal requirements are. But certainly what we've seen is that with the whole raft of changes under the Respect at Work inquiry, that employers, when they've been surveyed by the Human Rights Institute, have talked about how that has made the most change in the last 3 years in terms of understanding their responsibilities. So we are very confident that there will continue to be a grappling with their responsibilities under the Positive Duty and the Sex Discrimination Act.
Okay, so how are you becoming aware of the issues that perhaps smaller employers, smaller organisations are having in terms of meeting all their compliance responsibilities and regulatory responsibilities, and this is one of them, a very important piece. How are you becoming aware of that through the discharge of your obligations?
There are both formal and informal ways of becoming aware. So through my engagement in speaking engagements, so in conferences, in being asked to come and talk to employers, so the interaction that I have through that means. Yeah. Also, we have the Respect at Work Council, which has the Business Council of Australia and other employer groups, as well as unions and other civil society organisations represented, working women's centres. So there are both formal mechanisms as well as the informal mechanisms. I work closely with Champions of Change, for example, who work extensively with employers and larger organisations. And then the smaller organisations I would hear more anecdotally, and it would be through civil society and their discussion of some of the issues that women who come to them face in the workplace.
Okay. One of the issues that was raised during the inquiry, which was a few years ago now, I think, was the different situations in different working environments. So, for example, you might have a construction work site where there are people on the site most of the time, but then you have contractors coming onto the site, leaving the site. You might have interaction with other people, suppliers, etc. In a hospitality setting, you've got the added complexity of interaction between the staff and customers, and the issues that potentially raises. How many different guidelines do we have that actually speak to the particular circumstances of different workplaces and what needs to be done in practice by an employer to discharge their obligations?
So each employer or organisation has to comply with the 7 guidelines that we have and 4 principles that are applying, but they have to do what's reasonable and proportionate according to their size and their resources. Yeah. So the level of complexity of the response will vary according to their size, the nature of their business, but it certainly does catch all of those interactions with third-party suppliers, with contractors who come on site, and certainly through our Speaking from Experience consultations, people talked about how that was one of their most severe impacts, was through drivers coming on, delivering goods who weren't actually employed by the principal organisation.
So you've got less control over them.
Exactly. But they're still caught by the responsibilities, and the employer has to have in place a policy and a response, and the guidelines would cover each of those areas, so whether it be leadership, culture, education, so there'd be those guidelines that would impact on those suppliers also.
Okay. I've just got 2 more questions. Is it 2 questions or 2 minutes or 20 minutes?
2 minutes.
Okay. One of the other issues, so I've just got 2 quick questions. I might ask them both at the same time, just to give you an opportunity.
Thank you, Senator Scott.
One of the issues that was raised during the inquiry was that the Human Rights Commission will wear different hats in terms of its educative hat and also in relation to its role in terms of receiving complaints. And there was discussion about establishing ethical walls on separation of functions. So I'm interested to know how that's operating in practice. And second, I'm interested to know whether or not there's been what you can say in terms of complaints that have been made alleging a failure to meet the positive duty and whether or not any matters have actually made their way to the courts, to what extent a matter's been conciliated and mediated and resolved without going to the courts.
So there are, as we referred in our last appearance before this committee, there are strong information barriers in place between both the complaints investigation complaints service, the positive duty regulation, and then the policy sections of the Commission. So each section has tight barriers, both ensuring that any email communication or any material documents are held securely. There is no crossover between those 3, also because of our secrecy provisions. So, for example, I'm not aware of how many complaints or what the nature of the complaints that are received around sex discrimination, and similarly around the positive duty. That is not my area of responsibility. That's the President's area of responsibility, so that I can advocate clearly and forcefully around sex discrimination. So there are barriers in place and they are working effectively. There are also different staff. They don't cross over between each of the sections, so they're all employed within that particular section. Around the complaints, we do receive information from both individuals, but also we are able to proactively look at what's happening in the media, identify where there might be particular areas that we want to inquire into, but those won't become public until, for example, there is a more formal, the next stage within the inquiry process. So as the President referred to earlier, there are 4 inquiries currently on foot, and until they are further progressed, then there won't be something in the courts.
Thank you, Senator
Can I just ask the President, did you have anything you wanted to add to that, just in relation to management of cases?
Clarify, no court cases at the moment.
Okay.
The staffing teams are separate. The information barriers are there to quarantine the information between the different teams. And there's, in terms of our partnerships, last time we talked about our partnerships with Australian Defence Force, Federal Police and Border Force, for example. There's contractual terms that specifically address the issue that you're raising.
Okay. Thank you. Thank you, Chair.
Thank you. Senator Faruqi.
Thank you, Chair. And if I could please have the Race Discrimination Commissioner and Human Rights Commissioner back at the table. Thanks. Thank you. So I might go to the Race Discrimination Commissioner. Does the Commission see a risk that the increasing political legitimacy of far-right rhetoric and also some of the debate on migration that tries to blame migrants for economic insecurity and dehumanize them is shifting the acceptable boundaries of public debate and emboldening racist actors, whether it's online or offline?
Yes, there is certainly there's almost a legitimising in the sense of that the boldness and the visibility of white supremacists and the far right, and the way in which mis and disinformation that is often spread by those groups or associated with those groups, which uses racist stereotypes or tropes, anti-Semitic, Islamophobic, other forms of stereotypes and tropes, in an unchecked manner on social media is very concerning in that it appears to be increasing, it appears to be gaining momentum, and it is directly connected to anti-immigration rhetoric, where immigrants are being blamed for a litany of issues which actually have far more complex causes. So it's an evolving situation. It's not a straightforward one, but I think it is certainly one to be concerned about now and into the future.
Another concern, Commissioner, that quite a few people of colour in the community have raised with me is, the White Australia Party, an explicitly white supremacist group, is reportedly seeking registration as a political party. Does that raise concerns for you about the mainstreaming of extremist ideology in Australian politics?
I think it is concerning if a political party is basing its platform on a notion of white supremacy, and by extension that often leads to very xenophobic, sometimes violent or violently based ideologies. We have to be very careful, of course, in the sense of there is always a balancing in terms of, and it's this is Commissioner Filnay's portfolio as well, there has to be a balancing in terms of we also need to have freedom of speech, freedom of expression, freedom of political communication, and any restriction on that should only be proportionate to the harm that we're seeking to contain. So I raise these concerns about a party that has a particular platform. That doesn't immediately mean that a party cannot do that. That depends on the laws around, which I'm not an expert on, the formation and registering of political parties. I think that the issue of great concern really is that we should be exploring is how do these parties gain traction? There are clearly problems that they can point to in terms of growing economic insecurity, a divide between the rich and the poor, various inability to get housing, various other issues. The problem is that then the finger gets pointed at migrants or at people of colour rather than looking at what are usually far more complicated reasons for these issues which require complicated solutions. And so you need to have a number of different ways to combat that, like we point to in the National Anti-Racism Framework, in terms of education, in terms of working with community and community-led community design solutions, in terms of better regulation of social media. There is not one solution that will fix these things. As we pointed to in the framework, it actually requires a, like we say in the framework, a whole of government and whole of society approach.
And Dr. Finlay, do you agree with the Race Discrimination Commissioner on this?
I do, Senator, and I'd agree in two particular outcomes. The first is, as you said, when you have extremist ideology starting to gather pace, it has obviously an effect on individuals and communities who are dehumanised. But I think more broadly, it also stops us from having the mature and respectful discussions we need to have about public policy issues of substance. And that's something that is not only a detriment to the individuals and communities affected, but a detriment to the nation more broadly.
Yep. This is a question for both of you, but if I could start with you, Dr. Finlay. Many communities have expressed, again, concern and outrage that heavily policed First Nations justice rallies, refugee right protests and pro-Palestine marches stand in stark contrast to the lenience shown towards neo-Nazi demonstrations, and mainly in the sense of, policing. Does the Commission see structural and institutional factors that could explain these policing disparities?
Well, Senator, I think the starting point for that is the explainer that the Commission put out earlier this year about the right to protest, which, as you're well aware, is a fundamental democratic right. And one of the core principles there is your approach to protests and regulation of protests should never be dependent on the content of those protests in terms of policing a particular protest differently because you like or support or dislike or don't support the particular issue that's being protested. The question is always around, is it a peaceful protest and does it therefore fall within the bounds of the right to protest under the International Human Rights Framework?
I guess I'm particularly going to human rights issues as well, and also issues of racism, because there has been a disparity in policing. There's report after report, in terms of the Komanjai Walker inquest. The judge found former Constable Zachary Rolfe, who fired the fatal shots, was racist, and she could not exclude the possibility of those attitudes. were a contributing cause for Kumanjai's death, for instance. In 2024, Aboriginal people were 15 times more likely to be searched by Victoria Police than white people. People perceived to be African were about 9 times more likely, and I'm reading here from the Racial Profiling Data Monitoring Project. In New South Wales, police officers unconscionable racism behind decision to ignore Aboriginal man self-harming, another report found. So I'm particularly going to asking you if you see structural and institutional factors in this type of policing, and are you considering work specifically aimed at investigating and addressing this discrimination, these disparities, and this racism?
There are a number of things in that question, Senator,
Yes.
and perhaps the best way I can answer to say, first of all, in terms of investigating state police forces, that wouldn't fall within the mandate of the Australian Human Rights Commission in terms of that particular function. But everything that you just raised in your question really does highlight to me the complexity of factors and things that we need to deal with as a country, which really does reinforce the importance of the work that Commissioner Sivaraman is doing and the need for that whole of government approach, not only in terms of the national government, but state and territory governments as well, and getting right down to the local level, including local councils, of having a national anti-racism framework that really is about everybody coming together to send a very clear message that racism is unacceptable and is something that in Australia we do need to deal with in a very conscious, deliberate fashion.
And just finally to you, Commissioner, I know there are recommendations specifically on police in the report. Could you just kind of highlight those for us?
I'd have to bring up the framework.
In the framework, yeah. Or what do you think about
but
this
in a
structural
general
aspect?
sense, yeah.
Yeah, just
Sorry.
generally.
There's a couple of aspects to it. The first, of course, is building racial literacy within both federal and state police forces to actually understand how policing, which the police force or the officers themselves may see as purely objective, is not. How it may be influenced by beliefs on race, or how particular approaches or tactics might discriminate against some groups based on race. So the first issue is building racial literacy. The second is having anti-racism training as a compulsory aspect of policing. The third is actually acknowledging the past, in particular in terms of the role of police in the treatment of Aboriginal and Torres Strait Islanders. The fourth is accountability. So there has to be independent accountability of police actions, which I think Commissioner Finlay has probably already pointed to in the past, so that accountability is essential to change and transformation. So I would say, overarching, those are the themes in terms of what we say needs to happen in terms of the justice, of that aspect of the justice system.
Thank you. Thanks, Chair.
Thank you, Senator Faruqi. Senator O'Neill.
Thank you very much. Clearly, the efficiency and effectiveness of complaints handling is going to be critical to the success and the public confidence in the work of the Commission. I understand that you were recently audited by the ANAO with regard to that complaint handling function. What steps are you taking in response to the ANAO report to improve that efficiency and effectiveness?
Thank you. So we agreed in principle to the 5 recommendations of the ANAO report. Primarily those recommendations go to, so some of them are about how we monitor performance. A key thrust of it was those complaint stats, which we discussed previously in response to your questions. And so the ANAO is rightly pointing out that the timelines for us to resolve complaints are being affected by the higher levels of complaints, that 30% higher level of complaints compared to pre-pandemic, and the fact that our resourcing hasn't kept pace with that level of complaints. And so within the budget envelope we're looking at a range of things to try and finalise more complaints with the same level of quality while improving the efficiency. And so some of the things we're doing is increasing staffing through a different form of budgeting, looking at how we recruit staff so we avoid gaps through attrition from staff resigning, so more flexible staffing, more targeted recruitment, more innovative approaches to triaging complaints and trying to resolve complaints in a more efficient way through what we're calling a satellite team of more experienced conciliators, which is having some success, and also looking at whether there's regulatory reform that could remove some unnecessary parts of the complaint handling function to improve efficiency. And the data so far this financial year is, I'd say, cautiously promising in that regard, in the sense that we're on track so far this financial year to finalise more complaints than ever before in the Commission's history, as I understand it. But that's against a very challenging backdrop. I think the complaint numbers are still on track to go up again, like several percent, and obviously we're only partway through the financial year, but they're some of the things we're doing around trying to respond to the ANAO report. There's also some things that they recommended around our electronic complaints management system, which we're responding to, and a methodology for determining satisfaction, for example, of complainants.
So it sounds like it's ongoing work. To what extent do you believe you've already made the necessary changes that the ANAO recommended?
I might take that on notice in terms of preparing.
What do you think's complete? What do you think's like 70%? What, if you could take that on notice?
Yeah, I mean, the thing that I worry about most is the timeliness of complaints, and so that is a challenge for us, where you have complaint numbers going up, the budget envelope staying the same, and within that, the team that does that work has had good innovations and some resourcing changes that have meant we're making inroads, but it's small compared to the challenge, if you like, and we'll know more by the end of this financial year. And we can provide on notice the responses in terms of the progress of implementation of those other 4 recommendations from the ANAO.
So you need further innovation and further regulatory, reconstruction, further options for flexibility in terms of staffing and alignment for those better outcomes.
The efficiency and timeliness. Most of the ANAO recommendations were around how we measure performance and the methodology for that, and performance measures, and like I said, we've agreed to all of those recommendations, and they're being implemented, and very happy to provide a status update on whether they're fully implemented or in progress, and likely timeframes as well.
If I could, one further question. I have more if there's time, but I think of the Blue Pacific, and we've got one of the larger islands in the Pacific, but we've got many brothers and sisters on the other islands in this part of the world. And I know that the Attorney General's Department undertakes work to support the Australian government's goals to deepen our strategic partnerships and build capacity across the Asia-Pacific region. The areas that I understand work is being undertaken in regard legal policy, law reform and legislative drafting, and I've actually had the benefit of speaking with some of the beneficiaries of legislative drafting support, and they are truly appreciative of the guidance that they receive. Could you give me a sense of how the Australian Human Rights Commission's work with our regional neighbours in ASEAN and in the Pacific to build human rights capacity complement the broader program? How's it going? What would be your lighthouse example of great success? Ms Smith.
Thank you for the question, Senator. Leanne Smith, Chief Executive at the Commission. The Commission's work in Southeast Asia and in the Pacific is supported through partnerships, different partnerships with DFAT. At the moment, the work in the Asia-Pacific involves the technical cooperation work, if you like, sits under 2 bilateral human rights agreements, one with Laos and one with Vietnam. Vietnam in particular has been a very long-standing human rights dialogue. The technical cooperation sits under that, and we work with the promising work, I suppose, is building relationships over a long period of time with civil society organisations where we can, with bureaucrats in different ministries from foreign affairs to more implementing agencies, and seeing how building that trust and relationships over time allows us to support each other in making progress on human rights in very practical settings, whether it's through human rights education in primary school curricula, or, for example, with business peak bodies, building human rights and business into the work that they do. In the Pacific at the moment, a good example of the progress we're making is working with the Fijian National Human Rights Institution. We have a wonderful relationship with them that's been long-standing, and they've asked us to provide some guidance and support around two particular areas. Governance issues is one, so helping them with a governance framework, and secondly with support for developing their own complaint handling manual. So that's an example where I think we can really have a big impact in the Pacific. Thank you
very much. Thank you, Chair.
Thank
More
you,
questions
Senator.
if there's time.
Thank you, Senator O'Neill. Senator McLaughlin.
Yes, Ms Finlay. Completely different issue. The social media ban, which comes into effect on the 10th of December and is becoming increasingly popular around the world. I'm interested in how we reconcile the rights of use political communication. I'm coming from the context of, let's say, the environment, because we have the ban, which is from a philosophical perspective of protection, but we also have, you know, a generation that's coming increasingly active in trying to save their world. How do we reconcile that from a rights-based institution?
Well, that's a very broad question, Senator, and perhaps I can best put it in this way. Firstly, to note that not only myself, but obviously my Commissioner colleagues, including the former National Children's Commissioner and now the new National Children's Commissioner, have a deep interest in this particular issue. And again, the Australian Human Rights Commission, when this legislation was first announced, put out an explainer to highlight the different human rights that might be impacted, recognising, of course, that we all share the goal of wanting to ensure that our children are protected online. The question is whether the ban is the best mechanism for achieving that. We recognise that human rights are engaged through the ban trying to protect children from harm online, but there is also a need to protect children's rights in terms of their ability to engage, get their news, communicate, be part of the online community. And I would also add one thing that we are very interested in and concerned about at the Commission is that the social media ban doesn't only have effect on the human rights of the children who will be directly affected, but indeed all Australians through the privacy implications that result from the introduction of age assurance that will attach to social media accounts moving forward.
So from your perspective, and I know there's another Commissioner that's involved in relation to youth, but do you regularly take stock of the operation of a bill, or, you know, in the sense that in 2 years' time, do you reflect on the rebalancing? For example, it's gone too far, or it hasn't gone far enough. How does the Commission work there?
Well, perhaps there are 2 points I could make in relation to that. The first is that it was hard to have reflection on this bill given the speed that it was passed, but given that it has been passed, we obviously will have continuing reflection, and that was part of the Commission's advocacy around the need for review mechanisms to be built into the operation of this legislation, and that will be something that we'll engage with as the Commission as it is rolled out.
Apart from your public announcements, does that also involve direct communication to the Minister of the day?
Well, we communicate with all of the relevant ministers whose portfolios attach to the various human rights issues that we deal with, and the relevant departments as well, and also other government agencies whose work crosses over with ours in terms of being attached to those issues.
Yeah. No, thank you. My question comes from the recent pronouncement of President Macron, who argued in a particular philosophical ways. But thank you, you assisted.
Can I ask a follow-up question, please?
Very briefly,
very briefly. Commissioner Finlay, good to see you again, and thank you for all the work you do. There's apparently a High Court challenge against the social media ban being launched. Is the Australian Human Rights Commission considering whether or not it should make submissions as a amicus curiae in relation to that case?
Well, I might ask the President if he would like to add anything in, but noting the challenge was only announced a few days ago, my understanding is some initial documents are public available, but certainly it would be a matter of the Commission looking closely at the legal arguments that would be raised. And again, my understanding, because of the nature of the issues being raised by that particular challenge, it wouldn't be a matter of individual commissioners looking to exercise their amicus functions, but rather the Commission as a whole exercising its intervention functions if it was to intervene. And perhaps, Senator, the best response I could give at the moment is to point you to our guidelines for intervention that are publicly available on our website and that would guide any decision making in that type of process.
And yeah, so it'll be a very significant case, obviously, in terms of freedom of political communication. Haven't looked at the pleadings yet, but it's something we'll consider, and the guidelines will outline the factors that we weigh up when we're looking at whether or not to seek to intervene.
Thanks.
Thank you, Senator Scarr. Senator Shoebridge.
Thanks, Chair. Just quickly on that, has the Commission decided to pull the commissioners together to have a meeting to discuss that? Are you at that
No, we're
point?
not at that stage yet.
All right. And if you were going to make a decision, President, would that be the kind of process you would go through, or is it your decision as President?
I would need to refer to those guidelines. It's very new news, if you like. So we will go through a process around whether or not to seek leave to intervene in that case.
It's new news, but there may well be some urgent.
I understand, yeah, because the timing of that case is...
This being the 1st of December and it kicks in on the 10th?
Yes.
All right.
We have a commissioner meeting tomorrow, for example. Yep.
Sorry?
We have a commissioner meeting tomorrow.
Oh, and it's on the agenda?
Well, that's a regular meeting, so it provides an opportunity for us to discuss whether or not and how we might weigh up those considerations in those guidelines around the... And you want to be useful in these cases to say what arguments might not be put effectively if the Commission didn't intervene. How can we help the court in its deliberations around considering the human rights dimensions of the particular issue that they're looking at?
I understand that. And just my final question on that is, if there is a decision to intervene or not, is that your decision as President? Is it a collective decision of commissioners? How is the decision arrived at?
I need to take advice on that. Certainly some of the commissioners, for example, the Sex Discrimination Commissioner has an independent power that is exercised by the Sex Discrimination Commissioner herself. There's also a broader power of the Commission to intervene as the Commission, as I understand it, and I need to take advice about how it would apply in this circumstance.
And perhaps if I could add, Senator, noting that the issue of potential intervention in the court challenge is one part of this equation, but in terms of the implementation of the policy more generally, certainly the Commission has been publicly engaging in both the things that we suggest are positive about the ban and the human rights concerns that we have in relation to the ban. And if I can give just one example, it was only last week that I spoke to the Law Society of Western Australia looking at a webinar outlining the introduction of this legislation and the human rights considerations that it raised from the Commission's perspective. So it's certainly an issue that we think is significant. The question of the court challenge is one that has only really emerged in the last few days, and as the President suggested, will need to be considered.
Well, as one of a minority of senators, which included all my Greens colleagues, who voted against the ban because we were concerned about the impact it would have on young people's ability to organise and participate in politics, participate in, a social life. I just urge the Commission have a close look at this, because it's 9 days now, and the better part of 2.5 million young people are going to lose their significant part of their ability to communicate. So,
understand.
Yep. Can I ask about the Commission is undertaking a review on solitary confinement? Mm-hmm. Is that you, Commissioner Finlay?
It's a number of commissioners, but I'll be able to answer those questions, Senator.
Yeah. So I think Senator Thorpe's asked some questions about this before, and I won't go through all the iterations, but it's fair to say its arrival has been imminent for some time. Mm-hmm.
And I do have news for you on that front,
Excellent.
Senator. The content has been finalised and it's currently being prepared for publication, and we are on track to publish that prior to Christmas. And what I can indicate, Senator, is that while obviously I can't speak to the specific recommendations until it has been published, I can say that it builds on work the Commission has done in this area over both a long period of time and more recently. So we certainly haven't been silent on the issue, and I'd refer you particularly to the Help Way Earlier report from last year, which did recommend that there needs to be legislation to prohibit solitary confinement in child detention facilities and prohibit the use of isolation as punishment in any circumstances.
We're going to get to Help Way Earlier very soon, but so it'll be the expectation published before Christmas.
Yes.
Has it been delivered to the attorney or the department?
Not yet. It's still being prepared for publication, Senator.
All right. Okay. Thank you for that. On the Help Way Earlier report, obviously one of the issues in Help Way Earlier report was distressing materials about evidence about young people being held in solitary confinement and other distressing, deeply, deeply distressing circumstances of detention. Has there been any engagement between the Australian Human Rights Commission and the government, more broadly, about any of the material raised or the recommendations raised in the Help Way Earlier report?
That may be a question best answered either by the President or the Children's Commissioner, Senator.
Yes. Well, I'm happy for the Children's Commissioner to respond.
And it's probably easier for me to respond knowing, given that the new Children's Commissioner wasn't involved in that engagement with government, but certainly Commissioner Hollins was engaging with government around the recommendations of Help Way Earlier, and those recommendations, relating to solitary confinement have disproportionate impact, for example, on First Nations children and families, and myself and Commissioner Kiss and Commissioner Hollins have engaged with governments around those recommendations.
The second iteration of the report was delivered barely a month ago.
Yes. Now.
I'm assuming that was given to the government and provided to the attorney.
It's normally transmitted that way.
Yep. So we've had the government basically say they're not intending to respond specifically to the Help Way Earlier report. Have you requested a formal response from the government to either the first report or the addendum?
It's a matter for government in terms of how and when they respond to our reports. Our hope is that government engages with our recommendation and implements those recommendations. With Help Way Earlier, obviously some recommendations are targeted at the Australian government, some are for state and territory governments as well, and we're seeing a number of state and territory governments going backwards on child justice issues.
So I suppose I might ask you to take on notice, and it's a bit unfair asking you, you've still got that new commissioner smell, that the new car smell from the commissioner, to answer it in detail now. But could you, Commissioner, take on notice what, if any, interactions there have been with the government on either the first report or the second Help Way Earlier report, and what, if any, proactive engagements have come from the Commission to the government seeking that kind of engagement?
Absolutely, Senator.
Okay, thanks, Commissioner. Villawood and detention. Commissioner Finlay, your 2024 report on the experience of women in immigration detention, you recommended that women at the Villawood Immigration Detention Centre be moved to Mioa Village in order to create a separate women's compound, and that was because I think your staff and you and others, and also the
Our
women,
inspection team, yes,
had observed safety and harassment concerns for women there. The women have now subsequently been moved to high security compounds in the middle of the centre. Are you aware of that?
We are, Senator, and you may remember at the last Senate estimates where we discussed this, I indicated that we were considering undertaking a follow-up visit to Villawood. I can confirm that we have actually conducted that follow-up visit now with an inspection team attending on the 13th and 14th of November, and we also conducted an inspection at the same time of a hotel APOD that we were advised is holding detainees in the short term, including some female detainees. So that report is currently being drafted, and we'll look at the follow-up to the recommendations that were made in the initial report, as well as any other observations that we made during that follow-up visit.
I mean, what's happened is not consistent with your recommendations, is it? This high security compound is not what you recommended.
It's not the entirety of the recommendation that we recommended. We did recommend that the women should be moved from the facilities they were in. That has happened, but the next step of where we recommended they were moved to has not.
All right, and are you in a position to share with the committee any initial observations about the circumstances in which the women are now in the high security compound?
I'm hesitant to do that before the report is finalised, Senator. The visit was only conducted very recently when we are still putting together the contents of that report. What I can say is that we think the follow-up visit was important in order to enable us to see with our own eyes how those recommendations had or had not been implemented. And while there are some things that are positive, there are some things we continue to have concerns about, and we're continuing even ahead of the publication or the finalisation of those recommendations and publication of the report to engage with the department in relation to those matters.
And you made reference of another form of detention. Can you describe that other form of detention that women are being held in?
There's a hotel APOD detention, and you may remember the Commission conducted an inquiry during my first year as the Commissioner into the use of hotel APODs. This particular facility is being used for short-term detention, so effectively turnarounds, and it's something that we took the opportunity to inspect while we were at Villawood, as we were told that there were, or informed there were some females being held there.
All right. When can we expect a report on women in that follow-up visit that you had, or visits if they were to the two facilities?
I don't have a particular date, but I can say we're working on finalising that report for release in the first half of next year.
I have a final set of questions. In answer to some questions in additional estimates, the Department of Home Affairs said this: ABF is partnering with the Australian Human Rights Commission in ensuring the safety of women in detention by collaborating on the development of policies to support people in detention, including women, co-designing an enhanced engagement strategy for improved assurance oversight, and supporting the development of ABF/service provider training material and the treatment of people in detention. Is that right?
We've certainly had engagement with the department, and we'd like to see the full implementation of the recommendations that we made in the Women in Detention report, which would include the provision of gender-specific training and a range of other policies.
But I mean, what Home Affairs have said is quite, and I'll give you the question reference, it's A25360 if you want to look at it on notice, but collaborating on the development of policies to support people in detention, including women. Is the ABF and the AHRC collaborating on the development of policies to support people in detention, including women?
I think I would like to take that on notice, Senator, so that I can go and have a look at the exact wording of the question. What I can say is there has been engagement on those issues and regular meetings with the department in terms of following up on the recommendations from the report.
Well, given you delivered the report, and I'm assuming that's the engagement is with you as the Commissioner, are you collaborating with the ABF on the development of policies to support people in detention, including women?
Again, Senator, I would like to take that on notice so that I can look at exactly the way they framed that answer and look at the precise nature of the engagement that we have had.
Or are you co-designing an enhanced engagement strategies for improved assurance and oversight with the ABF?
Again, Senator, I would like to take that question on notice so that I can look at the precise framing of the answer that the department gave.
Are you supporting the development of ABF/service provider training material on the treatment of people in detention?
Senator, again, I'd refer to my previous answer.
We see I'm going to have ABF in estimates this week, so it would be useful to know if you agree with what they've said. It's a fairly series of specific observations that the ABF have made. You would know if what you're doing with the ABF, and you're sitting there, and I'm asking you, are you doing these things with the ABF?
And I would say, Senator Shoebridge, it is absolutely within the right of people appearing to take questions on notice.
Well, yes, but
it's within the
you must know, Commissioner, what you're doing or not with the ABF. Are you doing these things with the ABF?
Of course I know the engagements that we've had with ABF, Senator. However, the reason I'd like to take it on notice is so that I can see the full context of the answer that ABF have given and compare that to the engagements that we've had, so I can provide a fulsome answer that gives you the details you're requesting.
Very reasonable.
All right. Well, can you then, if you're going to the fulsome answer, can you provide a full outline of the work you're doing with the ABF on women in detention, in immigration detention?
Of course, Senator.
Thanks.
Thank you, Senator Shoebridge.
Chair, could I just clarify two things very quickly?
Absolutely.
One was it's a decision, as I'm advised, it's a decision of the Commission, not an individual commissioner. So that's the Commission is the 7 commissioners and the President as to whether or not to intervene. Yep. And I'm advised by a colleague online that we're not on track to have the highest number of complaints ever finalised. We had 1 year in COVID where we finalised a very high number of complaints. We're on track to, I think it's the second highest, but a higher number. I didn't want to misspeak in terms of the highest number. I shouldn't have said that, but we're on track to have a significant improvement in the number of complaints finalised compared to the last 2 or 3 years.
Thank you, President. That concludes the questions that we have for the Human Rights Commission. I thank you for your time this evening. We'll take a short suspension while we welcome the National Anti-Corruption Commission to the table. Zoom broadcasting. Thank you very much. I now welcome Minister Green to the table and also the National Anti-Corruption Commission. Thank you for joining us this evening. Mr Reid, would you like to make an opening statement?
So I prepared an opening statement and provided it to the committee, and I'm happy for that to be tabled.
Great.
But I would like to make a short statement to the committee on top of that.
A summarised version of your opening statement?
No, just about a couple
on top,
of different
in addition
items.
to?
That's
okay,
right.
Absolutely. Go for it.
Okay. So on Tuesday, the 25th of November, I provided a written clarification of the evidence that I'd given during my appearance on the 7th of October in response to questions about the Commissioner's provision of assistance to the Inspector General of the Australian Defence Force. In preparing for today's hearing, it's come to my attention that our response to question on notice number SBE 25-040 that was tabled with the committee on Friday, the 28th of November, contains a small error on page 2 at line 9 of the table headed 2024. The date should read 18 November, not 30 November, not 18 November, which was when the Commissioner provided the advice. All other details relating to that line item are current. We've provided an updated response to the department, and I understand that that has been submitted to the committee. So that's the end of my short statement.
Thank you, Mr Reid. I'm advised by the Secretary they have that correction. So thank you for your diligence. We'll proceed to questions.
So is this since the 25, there's further correspondence come to the committee since 25 November?
It's two different elements. So one was the further correspondence to the committee, just acknowledging that, and the second was a minor amendment to
SBE 25040
just
about
today.
Commissioner Brereton's advice to the IGADF.
So written to the Secretary at 4 o'clock today.
Can we circulate it?
Yeah, absolutely. Senator McGrath.
Thank you for coming along. This morning at the Finance and Public Administration Estimates hearing, senior officials from the Department of Parliamentary Services confirmed a contractor from TransPerfect was granted access to the internal APH IT system to retrieve information for a NAC investigation. That contractor, we now know, did not hold the required security clearance to conduct this very sensitive work. Was the NAC aware of this?
I don't believe so.
So you were not aware that a contractor for TransPerfect who was extracting information for a NAC investigation did not hold the relevant security clearance?
I think, look, I don't actually know the answer to that. We have not used that entity to assist us, so my understanding is that it would be the Department of Parliamentary Services that would have authorised any contractor.
So TransPerfect were not engaged directly by the NAC in relation to the extraction of the data?
That's correct.
Okay. Bearing in mind, I'm aware of the confidential nature of your investigations, and you may be limited in terms of the answers you can give. Have you had any relationship with has the NAC had any relationship with TransPerfect or employees of TransPerfect?
Not that I'm aware of.
Okay. Okay. So in terms of, if I can just summarise then, your evidence is that in relation to the extraction of information for a NAC investigation concerning a parliamentarian's IT system, that the NAC, you had no direct or indirect involvement with the extraction of that information. That was something that was solely done by the Department of Parliamentary Services.
I suppose I could answer it in a slightly different way. If we were requesting access to a parliamentarian's emails or the IT system containing their emails, we would do that usually under the terms of the MOU that we have with the Parliament about parliamentary privilege, and we would do it in consultation with the clerks. But if it were associated with a different matter where it didn't involve a parliamentarian, then we would expect through notice for instance, DPS to search the systems to find the material that we may be interested in.
So you would rely on the Department of Parliamentary Services to search and find the information that you may require for one of your investigations. So that's a yes?
Yeah.
So sorry, just so Hansard can't interpret the head nod. And you have no direct involvement. The MOU, is that a public document?
Yes.
It is. So is it on your website or, as a senator, I should probably know this, but
on your website.
It's on the Parliament's website. Well, I could do an ad now for Tell Us the Truth about dps@gmail.com, so while those people are listening. But can you just remind me, when was the MOU signed?
I might have to ask my colleague, Rebecca Omar.
Rebecca Omar, General Manager Legal. I think it was the 27th of November 2024.
Okay. Just in relation to this particular matter, has DPS advised you that TransPerfect and or their employee, one particular employee, did not have the relevant security clearance to extract information for your investigation?
I don't believe so.
No. Okay. I'm good. Sure. Sorry.
Just on this question. You seem to be drawing a distinction between an investigation which is looking into the conduct of a parliamentarian and the approach you would take with respect to accessing the information, and an investigation which is not specifically looking into the conduct of the parliamentarian, but the content of emails may be relevant to that investigation. Is that correct?
Yeah, I'm trying to assist, but at the same time identify that there are different sorts of investigations that the National Anti-Corruption Commission could undertake. And if we were looking at a current or past parliamentarian, then we would follow the MOU in terms of obtaining or seeking to obtain information about that parliamentarian or past parliamentarian that's still on the record.
So is it your evidence that the MOU itself draws a distinction between access to the emails of parliamentarians, the process for access to emails to parliamentarians, current or former, with respect to investigations into them, as opposed to accessing the same pool of potential information and records if the access is not in relation to an investigation in relation to them?
Rebecca?
So in terms of the MOU, the critical terminology is material that may potentially be subject to parliamentary privilege. And specifically in relation to emails, there is a provision of the MOU that deals with where third parties may hold that potentially privileged communications. And I think it references emails or material that's held by DPS, and it outlines the process there in terms of that in the first instance that material is seen to be held by the parliamentarian, so we would need to consult with the parliamentarian, except for if there was concerns in terms of their impact that may have on an investigation, in which case then the Commission has an obligation to consult with the clerks in relation to the process that will need to be followed to ensure that privilege is respected.
All right. Thank you. Thanks, Chair.
Thank you. Senator Scarr. Senator Shoebridge.
Thanks, Chair. Mr Reid, I note your clarification on the 25th of November that in response to questions I was putting to you about the hours that he worked, that Commissioner Brereton was working for the IGADF.
Providing advice to the IGADF.
Is that the formula now, providing advice?
It's not a formula, it's the reality of what has occurred.
Well, you say that. Is that because that's what Commissioner Brereton has told you that he was doing?
No, it's quite clear that that was what he was being asked to do, and to provide advice about his knowledge of a very specific inquiry that had been undertaken by him when he was Assistant IGADF, and that's just the reality.
Well, you say that's the reality. Is that because that's what he's told you he was doing, providing advice to the IGADF?
Well, clearly I'm dependent on, two things. What was identified before the last estimates appearance which was that the two extensions were related to a request by the IGADF to be able to continue to access the Commissioner wearing his Major General hat in relation to that inquiry, and that it was a very important connection for the IGADF linked to OSI to be able to have that source of information and advice.
So is that what Commissioner Brereton told you?
Well, that's...
he told you that the only thing he does for the IGADF is provide advice? I'm just wondering, because we've gone back and forth a number of times about what you've told us, and then you've had to go and get corrections about the number of times, the nature of the engagements, when the engagements happen. So it's best, I think, we get an understanding of where, let me finish, where your advice to this committee, your evidence to this committee is coming from. So when you say that he's only done advice work, is that where it's come from him?
Was that he had advised me that his the provision of advice to the IGADF was infrequent and that it largely occurred outside of normal business hours. Subsequently, as a result of going through the exercise of providing a more detailed response under the question on notice, it turned out that we now know the number of occasions that that the requests were made to him, the number of occasions on which he provided advice, and the number of occasions that were outside normal business hours or within normal business hours.
Well, you see, Mr. Reid, that's not true, is it? You didn't tell us on the last occasion that the work he did was largely outside of the business hours of the NAC. That's not true. That's not what you told us, is it?
In my letter of the 25th of November, I said, while responding to questions from Senator Shoebridge on page 82 of the Hansard, I stated it doesn't occur during the hours that he works for the Commission, and yes, it was outside of hours that he was associated with the Commission.
We see, Mr. Reid, you tried to then qualify your earlier evidence just then by saying that you told the committee earlier it was largely outside of business hours. And I just want you to reflect on why you did that, and if you want to confirm that that's not true. You didn't say largely outside of business hours, did you?
And so then the two paragraphs below those quotes, I say that at the time the Commissioner himself could not define when the advice was being provided in the lead up to my appearance before this committee, and subsequently that's now been clarified. So to me, the letter of the 25th of November 2025 clearly identifies that it was not all of the advice being provided outside normal business hours. There was advice being provided within business hours. I think it's quite clear.
Well, you say that, but Mr. Reid, we had the exchange about work. Do you remember that exchange about work last occasion? You said it's not work. You now say it's advice. Is that right?
And I said that in the last hearing.
And then I say, I asked you, it's work. You're not denying it's work. And then you retorted by saying it doesn't occur during the hours that he works for the Commission. Do you remember saying that?
Yes, that's in my... I mean, I've quoted it here in my letter of the 25th of November, so clearly I'm aware that's what I said.
Yep. And that's not... It's largely outside of business hours, which is how you tried to characterise it earlier, is it? It's categorical. It was outside of hours that he was associated with the Commission. Do you see that? Or it doesn't occur during the hours that he works for the Commission. Do you see that?
It's quite clear what I said because it's written down here. So
what I'm putting to you, Mr. Reid, is what you said earlier about it being largely outside of business hours. That's not an accurate That's not an accurate recounting of your evidence before the committee earlier. You didn't say largely outside of business hours. You said it doesn't occur during the hours that he works for the Commission. Do you accept what you put earlier to this committee and what you said on the 7th of October? You mischaracterised what you said on the 7th of October, didn't you?
You know, you might be twisting things. I'd have to go back and look at what's on the Hansard now, because the clarification was to say that it was, it's on the second page of the letter, that there were 22 occasions over 28 months on which the Commissioner has provided responses to 18 requests, and 14 of those occurred outside ordinary business hours. And that means that the majority were within, outside, business hours. What did I just say? Occurred.
Why don't
14 occurred outside.
Why don't we go back
8
to
occurred within business hours.
Why don't we go back to your the evidence you gave on the 7th of October, and we'll just go through it in a bit more detail. I ask you it's work, you're not denying it's work. You say it doesn't occur during the hours that he works for the Commission, and he there is Commissioner Brereton. You agree?
Yeah, as I've stated in my letter of the 25th of November.
I then say, how do you know he didn't even tell you he was doing it? And you said, he advised me that. I asked since, and then you say, yes, it was outside of hours that he was associated with the Commission.
Yeah. So he advised me after it became known that he was providing this advice. He and I had a discussion before the last estimates, and he advised me that it was infrequent and outside of not occurring during the hours that he works for the Commission.
And that was...
But that was before he had had an opportunity to look at his records.
Well, you didn't qualify it there. You didn't say, in your answers on the 7th of October, you didn't qualify it.
No,
you told us... Let me finish, Mr Reid.
I've corrected it on the 25th of November.
You told us that Commissioner Brereton told you that he only works outside of hours associated with the Commission on the IGADF. That was your evidence on the 7th of October because...
That's correct.
Because that's what Commissioner Brereton told you, isn't it?
That's correct.
And he misled you again, didn't he? He's again misled you, because it turns out that more than a third of the occasions that he was providing advice to the IGADF happened during the time of ordinary business hours for the NAC. He misled you again, didn't he?
Before the 7th of October appearance, he had not had an opportunity to go and look at his records in detail, and so he told me what I said.
And it's not as though he forgot one occasion.
The question on notice, he has gone in detail through his records and identified that both the date and the timing on any particular day of that advice.
Well, he misled you on 2 points, Mr Reid, didn't he? And you therefore misled the committee. First of all, he misled you, Commissioner Brereton misled you by saying it was infrequent, when in fact it's been at least 22 occasions that he's provided advice. And he secondly misled you when he said that it was always outside of the Commission's business hours, when in fact on 8 separate occasions he's provided advice to the IGADF during the business hours of the NAC. He misled you on 2 points, and then you misled the committee on those 2 points. That's what's happened, isn't it?
He advised me that that was the case. I provided that advice here because that's what I was aware of at the time, and I've now clarified that in my letter of the 25th of November.
This isn't
I'm not sure
anybody.
where we're heading with this.
Well, this is where I'm heading. The Commissioner of the NAC should be providing you with accurate, truthful advice and information so that you can provide accurate and truthful advice to this committee. And the Commissioner of the NAC didn't. He misled you on 2 key points. That's a serious matter for the Integrity Commission in the country, isn't it?
Yes,
Him misleading the committee through you.
Everybody can be fallible if they haven't had the opportunity or the time to go through records and in the quick time between when a story is written about the extensions and my appearance, that was the conversation we had. I see nothing wrong with that.
But of course, you see, Commissioner Brereton wanted to hose down these concerns to minimise the amount of times that he'd provided moonlighting work for the IGADF. And that's the problem you face, isn't it? When the Integrity Commissioner has an incentive for giving misleading evidence
that's incorrect.
to minimise the number of occasions that he's worked for the IGADF and to deny that he'd worked for the IGADF when he was on the NAC's dime getting $900,000 a year. That's the problem you face, Mr Reid, isn't it?
No.
I'm just flagging. I'm going to rotate the call after your response to this question, Mr Reid.
He's doing this when he's meant to be a full-time 900K commissioner.
I am going to interrupt. I think you've asked the question. I think Mr Reid understands the question. I am going to remind senators and people at the table that we will, in an orderly way, have questions asked, take a breath, questions responded to. None of this back and forth. Mr Reid, you have the call.
Sorry?
To respond to Senator Shoebridge's question.
No, well, I completely refute that statement.
That he had an interest in minimising the scandal.
Senator Shoebridge, I've flagged that I'm going to rotate the call. I think Mr Reid has answered your question. Is that your response, Mr Reid? Okay, I'm going to rotate the call now. Senator Bligh.
Sorry, yes, thank you very much. Thank you very much. And we're just looking at workplace shortages within the NAC. So I understand that you've received over 3,000 referrals in your first year. Are you able to let me know how many remain unassessed or waiting for preliminary triage?
So what I said in my opening statement was that as at 26th of November this year, was it 26th? Since the commencement, the Commission has received a total of 6,533 referrals, of which 5,556, which is 85%, have been assessed. And during its second year of operations, the Commission finalised the assessment of 2,004 referrals in total. So there's 15% that are still under consideration.
Okay. And are they all from the sort of second year or are they a mix of...
It's a mix.
A mix of both?
Predominantly it's becoming more matters from the second year and those in this half of the third financial year, which we're focused on, but there are still referrals from the first financial year.
So how does that, I guess, impact your ability, or are you meeting your statutory expectations?
So in the annual report, we're reporting against our KPIs, and at this point we're meeting the KPIs that we have identified that are in our corporate plan.
Okay, but statutory obligations that you have, are there...
Well, this is specifically, those KPIs are specifically about the numbers of referrals that are dealt with in within 90 days, and we're saying 80% at 90 days, and the number of investigations that are completed within 2 years, and we're saying 60% there, and then the number of corruption prevention and education presentations and products that we produce, and that's just the number. So that's the KPIs as they stand at this point in time, and they're reported against in the annual report.
Okay. Are you able to confirm whether there are any matters involving current or former members of Parliament?
What I said in my opening statement is that of the 38 investigations that are currently, corruption investigations currently underway, that the 7 of them concern conduct of current or former parliamentarians and 5 concern the conduct of current or former parliamentary staff.
Okay. Thank you. And I guess just going back to some of the questions that were raised earlier by my colleague Senator McGrath, there's a lot of referrals that have come to you. Where there is, I guess, a need for public trust, if there are investigations being undertaken where third parties are used to collect evidence on your behalf for an investigation, I guess what precautionary measures have you got in place to ensure that there is no overreach in relation to legislative frameworks that are set up?
Yeah, I'd have to consider that. I don't know whether, Rebecca, you would want to add?
Yeah, so just in terms of when we serve agencies with notices, it really then becomes a matter for them in terms of how they go about producing that material to us. But as I stated earlier, we are always mindful of the potential for there to be privilege concerns, and it may be that we are aware of those, in which case then we'll refer to the MOU and comply with that. Or similarly, if an agency was to raise that with us, then we would look to make sure that we're complying with the MOU. But in terms of how an agency may go about responding to that notice, that really is a matter for them.
Does that impede your ability to investigate, though, if agencies, so like we've seen, data's been handed over with no security clearances in place? Does that challenge some of your investigations, do you think? So if agencies are then on your behalf gathering evidence and not necessarily following the correct protocols, can you see how that could hamper outcomes for your agency or your commission?
Look, at this point, it's clearly something that you're concerned about. It's a hypothetical in a way to us, and so I suppose it really depends on the nature of what is being alleged here. We're reasonably clear about entities, departments, other entities having to provide information within the terms of the notice that has been served on them, and we will follow up with them if we don't feel that they are doing it within a timely fashion, or if we're not sure that they've provided all the information that we think may be available. So it's a bit hard to do anything more than make those general statements. But, you know, we can take it on notice if there's something of substance that you're referring to.
So I guess the Commonwealth Ombudsman report into the NAC's non-compliant use of covert and intrusive powers made 7 suggestions for improving the NAC's use of surveillance devices and telecommunication data powers. To date, how many of those recommendations have you implemented?
I might turn to my colleague,
certainly.
Peter Ratcliffe, who has a better understanding of that.
Certainly.
Good afternoon, Senator. Peter Ratcliffe, General Manager of Operational Capabilities. you're quite right. There were 7 recommendations made. If you don't mind, I'll take it on notice for now, but I'm going to look it up now and I'll be able to give you an answer within the next couple of minutes.
That would be fantastic. Thank you. Can I just, I guess, follow up on that as we lead on from the Ombudsman? How many complaints have been received about the NAC?
By the NAC?
Received about you?
Yes,
so
by the National
Yes, so where
Anti-Corruption
you've been
Commission.
notified, yep.
I don't think that I certainly don't have that number with me. We'd have to take that on notice.
That would be excellent if that could be provided on notice. So, and then if we just sort of go a little further, employees of the NAT who have made complaints around or against workplace culture, lack of governance and mismanagement of conflict, and then this goes on, sorry, this is point 9.5 of the annual report. It goes on to state the inspector advised the commissioner of these complaints and did not take any further action.
So I think are you referring to the inspector of the National Anti-Corruption Commission's annual report?
Yes.
As distinct to our annual report?
Yes.
Yeah. So I think that's really a matter for the inspector.
Okay.
I mean, as you will note, there's references made to a variety of complaints and other matters that she has been dealing with. And some of them we may be familiar with and others we may be less familiar with. So,
okay. And this may be something you want to take on notice. If you're aware of these, I guess, the annual report from the inspector, what did you do with them?
Well, if it's the ones that the inspector is referring to in her annual report, she receives complaints that we never find out about.
Okay.
Because, well, it's up to her to explain her role. Other matters she will provide to us and ask us for information about a particular referral or referrer. And we provide that information to her, and that may lead to her providing an outcome to the referrer, but that's not something that we have any visibility on. We've got an MOU with the inspector, which is on our website as well, and it defines the way that we will interact in relation to those sorts of matters, but we're not aware at any one point in time, unless the inspector writes to us about something, what may have been provided to her as a complaint about us.
Is there anything that the inspector has raised with you or written to you about that has prompted any kind of change within the NAT?
Oh yes, we've ended up with changes to the way that our assessment process is undertaken. There's a variety of things that she has identified that we have gone off and agreed to change as a result of them being raised with us.
Excellent. Thank you.
Thank you, Senator Blythe. Senator Pocock.
Thank you, Chair. Thank you for your time this evening. Mr. Reid, I'm interested if there will be a public hearing into Robodebt.
Big pardon?
Will there be a public hearing as part of the investigation into Robodebt?
That's a matter for the Deputy Commissioner presiding over that matter, and as I think I explained at the last hearing, that's a very arm's length process, even though they are a Deputy Commissioner of the National Anti-Corruption Commission, and it's been set up, I should say, in a way to ensure that we're not directly involved in any of the activities of that investigation unless individuals have been requested to be involved, and there's a small number of staff in that category. and I have to approve anybody that's going to be associated with the investigation, but I'm not meant to be aware of the activities of that investigation, and therefore, to fully answer your question, it's a matter for the Deputy Commissioner presiding over that as to how they will manage the investigation.
Okay, thank you. And so just for my understanding, you don't even have visibility over where things are up to in terms of the timeline of an investigation or potential findings?
Well, what we do to ensure that the investigation can function, we have to be able to approve the money associated with the investigation, and mostly that will come to me to sign off on. We have to ensure that any staff member of the National Anti-Corruption Commission has had to submit a declaration about any conflicts of interest that might be associated with that investigation. But beyond that, we have a very limited understanding of what would happen in that investigation on a day-to-day basis, and I'm sure you and the public would agree that that's a very important thing given the history of that matter and the Commission's consideration of that matter.
Yes. And so there's been no money requested or allocated for a public hearing?
There's been money expended for hearings, but we're not... all that I know is that we've had to pay expenses for witnesses and such like.
So there have been hearings, just not public hearings?
There's been hearings, but as I said, I'm not meant to have any significant knowledge about that, and therefore I'm not in a position to give you any advice about whether or whether not they will do any public hearings.
Has the requirement for exceptional circumstances been a barrier to holding public hearings?
The Commission is on the record saying no, that the circumstances have not arisen as yet, and in the work of the broader Commission, and as I say, we separate out that investigation into Robodebt.
Sure. And so in all the other investigations, there's been nothing that has met the bar of exceptional circumstances?
That's correct, to this time.
Would you agree then that that bar is unlikely to be reached? If something like Robodebt doesn't reach it, then it's very unlikely we'll see public hearings.
I think it's really a hypothetical question that I can't answer, in the sense that, you know, I think the Commission would say something along the lines of, we'll know that we've reached that point when we get to that point.
I've previously asked about Chairman's Lounge memberships, and I understand that yourself and the Commissioner and Deputy Commissioners all have Chairman's Lounge.
That's correct.
Membership. Does this not raise any issues for you around conflicts of interest?
No. Qantas is not a Commonwealth agency.
No, I understand that.
And if it were ever to become an issue, then we'd have to consider it at that point, but it hasn't been an issue to date.
Sure. I guess if there was a matter that was referred to you that involved a public servant and Qantas, and, you know, for years you've all been enjoying the Chairman's Lounge, who, you know, I assume you all have to then recuse yourself, or look, surely the risk does not outweigh the benefit, given you're all incredibly well paid to do this job. What's the little sweetener to have a Chairman's Lounge access?
It'd be hard to identify that example that you were using, where a potential corruption issue, which is a precursor to an investigation, would be.
I mean, this would normally be. This is a company we procured $200 million worth of travel from a year. So, I'm obviously absolutely not alleging anything. I'm just raising this as a potential conflict of interest. And I just don't see, as the National Anti-Corruption Commission, when you weigh up a chairman's lounge membership, access to a sort of VIP lounge at an airport, I just don't see why you would be taking that risk. Why did you say yes to it?
Well, it was something that I had in previous jobs.
Sure,
so
but you weren't at the NAC.
I was at a Royal Commission. I was initially also at New South Wales ICAC. So and prior to that, senior government official. So I'm, at this point in time,
it just comes
the
with
likelihood
the
it is ever going to get.
Senator Pocock, we'll let Mr. Reid answer the question.
To a point where there's going to be an issue in relation to that is probably remote, and clearly we would have to address it if something did come through the door. Nothing's come through the door in 2.5 years.
Sure. Have any of the Deputy Commissioners made disclosures of conflicts of interest?
They all make, as I do and as the Commissioner does, annual declarations of interest. In cascading down from that, in the matters that are considered by what we call the National Anti-Corruption Commission Assessment Panel, Senior Assessment Panel, NSAP, Deputy Commissioners and other individuals that participate in those meetings will make declarations, and under the revised terms of reference of that body,
he's talking for a long time.
They are meant to be, if it's a deputy making a declaration, it's got to be assessed by or determined by the Commissioner, and if it's the Commissioner, it's got to be a deputy.
Sure.
And so the terms of reference are quite clear, and we've tabled them previously, questions on notice.
Sure.
So everyone in their life is potentially going to end up with people that they know or have worked with, and so I suppose you've got to define whether it's real, apparent or potential.
Okay.
And that decision then has to be agreed to within the terms of that particular process, which is where it's most likely that conflicts will occur because you don't know what's coming through the door in any one day, 1 week, 1 month, and then what the assessment process throws up for those decisions.
Sure. And are those declarations of interest public?
No, but they're recorded in the minutes of the meetings of the NAC Senior Assessment Panel.
But so they're not public, and the Commissioner is signing off on the Deputy Commissioner's conflicts of interest.
And if you read the terms of reference, yes, it's outlined in the.
Does that not concern you?
No.
Given the Commissioner doesn't seem, as I guess in the past, hasn't understood what a conflict of interest is?
I think you're referring to one occasion that was the subject of the investigation undertaken by the inspector, and it was one, matter that was raised around, and
it was found to be officer misconduct, and since then we've seen,
because of an error of fact or law,
we've seen you have to correct the record a number of times to Senator Shoebridge over, I guess, non-disclosures or disclosures that are not as fulsome as you expect from the Commissioner. And I guess I'm concerned if the only check on declarations of real or perceived conflicts of interest is to the Commissioner, there's nothing public.
No.
I'm wondering if that's a good setup.
So the other place on an annual basis where declarations are made are to the Attorney-General by each of the Commissioner, the Deputy Commissioners and myself. But again, that's not public. Though the Commissioner's initial declaration of interest to the previous attorney was made published with small redactions, so it's on the public record.
And would you be willing to put on the public record the Deputy Commissioner's declarations of conflict?
I think that would have to be a matter for them.
Well, maybe you could take that on notice, given they're not here. Thank you.
Thank you, Senator Pocock. Senator Shoebridge.
Thanks, Chair. We'll build in on that. On how many occasions has Deputy Commissioner Kilgore, for example, declared a conflict of interest and therefore not participated in a referral or a matter before the NAC?
I'd have to take that on notice.
Could you take that on notice for each of the Deputy Commissioners?
Yes.
Yes. You've previously told us that there are half a dozen occasions where Commissioner Brereton had declared a conflict of interest and stepped aside from defence matters. Do you remember that?
Yes.
How many is it now?
As you'll be aware, on the 31st of October, in the November update that was published, the Commissioner has now recused himself from all defence and ADF related matters. So the number that existed up to that point, I'd have to go back and check. So maybe I'll just take that on notice.
Mr Reid, this was one of the most obvious questions you would be asked. A significant development since we were last here in estimates was Commissioner Brereton stepping aside from all defence matters, not just the 6 that he'd previously stepped aside from, but all defence matters. You must have known you would be asked questions about this, mustn't you, Mr Reid?
I've given you my answer. I'll take it on notice.
Well, I would ask you, we're about to go to a dinner break, to assist this committee, and by doing that, assist this Parliament holding the National Anti-Corruption Commission to account and provide over the dinner, if you can, on how many matters now Commissioner Brereton has determined his connection with defence means that he will no longer sit on defence matters. On how many occasions has that led to him either not sitting on or not considering matters or withdrawing from matters that he was involved in? You must be able to find that out, Mr Reid.
All right, I'll see what I can do.
Thank you, Senator Shoebridge.
Well, I have a couple of other, if we're going to go to 6.
2 minutes worth?
Yep. How much is Commissioner Brereton paid, by the way?
That was asked at the last hearing, but I'll just quickly go to my notes. $803,440.
And does he get superannuation on top of that?
There is a provision made, yes.
So basically 900,000.
Well, I'm just giving you the salary figure, the remuneration figure.
Minister, do you think it's a reasonable expectation from the Australian public that if Commissioner Brereton is being paid $800,000 to do the job of the Commissioner, that he would devote all of his work hours to being the Commissioner of the NAC? Do you think that's a reasonable expectation on an 800K plus package?
Senator Shoebridge, I think I'm going to give you a similar answer to what I've given you before in relation to the NAC. As you know, the operations of the NAC are independent. I'm not going to comment on them. We have gone through the process of which the Commission has disclosed the informal advisory role. Like all Australian officials, are required to disclose and manage a personal interest that could result in potential conflicts.
All right. But we come back to the point. The Australian public is paying Major General Commissioner Brereton $803,000 in salary plus superannuation on top. Don't you think it's reasonable that he works full-time for the NAC?
I think it's reasonable that the NAC is independent as Parliament designed, that the government shouldn't be making comments about the operations of the NAC. We certainly have gone through the process that you've raised a few times now in estimates around the advisory role that the Commissioner plays and how that's being managed. But those questions in terms of the management of it need to go to the Chief Executive.
Thank you very much. It being 6 p.m, we have reached the dinner break. I am advised that we have further questions for the Commission, so we will return with you after the dinner break. We will now suspend until 6:45.
Okay.